it was given as a gift, so that it would be that amount or the property would take care of their daughter when she's in her in-laws house. When there is an emergency, she can use it. It is for her well-being that a dowry was given. But later on, over the period of time, it was kind of a demand. The gift was changed into demand, and the people started demanding. The in-laws started demanding. So once you demand a dowry, that is when it becomes a crime. And then we have to take up as, a case. So we normally say that, the best dowry you can give for a girl is education, but it doesn't happen so. I'm sorry to say, it's been 1.5 years that I've been in this position, and I've already taken up 52 cases, of which more than half of it are from well-educated people, doctors, blue-collar job, white-collar job, both husband and wife, very well educated, and advocates. And there was also, there are cases where in which first day of marriage, and then the next day I'm getting a call saying that I don't want to proceed with him. The reason is like, I don't like his smell. He smells, he stinks. So I don't want to continue living with him. So when I do a lot of counseling, and when we are trying to counsel them, like during our generation or even now in our generation, what we do is we try our best to adjust and live according to the situation. But the children of now, of this generation, for them, they need immediate results. They don't want to even try to solve the situation or try to overcome it, or try to find a solution for it. They demand, divorce. That is how things are happening with respect to dowry related cases. And of course, I wouldn't say that I've received any fake complaints. Normally people say you get a lot of fake complaints, people are filing fake complaints, but so far no fake complaints. It is all genuine complaints that has been filed. So with respect to domestic violence and the dowry, the Dowry Prohibition Advisory Board can be approached, and we are stationed at the Department of Women and Child. So our committee also has the domestic violence protection officer, the women protection officer. They are there. So anything to do with dowry or domestic violence, you can approach us. So we are there to help you. And the third important one is the sexual harassment at workplace, where it is exclusive. All these acts are women friendly. That's why, when men come forward with the complaint, I've received complaint of domestic violence from men, the husbands come forward and they give the complaint, and I get, so many photographs of them showing that, today she beat me up. See, my hand is fractured. I don't know where, whom to go and complain. So I say, go to the nearest police station, but the police also don't take up their complaints. So it is in a way very pathetic. But, the most vulnerable people are the women. So that is why we have all these women-friendly laws. And maybe like 5% of it, such incidents happen to men, but mostly it is the women. In sexual harassment at workplace, in the year 1991, in the state of Rajasthan, there was this lady by name Banwari Devi. And she is a social worker in the Department of Women and Child. She has to go around the villages assigned to her to find out whether any child marriages are happening. So her main work is to stop such marriages. So one day she goes to this particular village, and she finds the house, well decorated, and it was, in a festive mood. And she goes there to find out what is happening here. And she's been informed that there is a marriage. So when she still, further tries to find out who is getting married, that's when she comes to understand the baby of the house is getting married, and the baby is only 1 year old. So she says this is child marriage. You shouldn't go ahead with it, and it is a serious crime. A child has to complete her 18 years, and only then you have to give the child away in marriage. But the family is opposing because they belong to the upper class and they are, the Jameens of that area, and so they, kind of shoo her away. And so she immediately goes to the department. She informs the department. She goes to the collectorate and informs the collectorate, the staff who are in charge, that, an incident of child marriage is happening. And, people come down, inspect, and the marriage is stopped. The marriage is stopped in the sense it's only during the daytime. The marriage does happen in the night. But she at the follow-up of her cases, she goes to this place again, and they are not cooperating with her. So after the inspection, she goes to her field where her husband is there. It's during the working hours. She goes to meet her husband, and there she is confronted by the men of this family. 9 of them go there, tie her husband up, beat him up, tie him up onto a tree, and in front of him, she's been repeatedly raped. So she goes to her department. Then the police refused to file a complaint because they belong to the upper class, the VIPs of the village. And she goes to the collector, and finally she files a case in the court. And she struggles a lot with the case because this nobody is there in support of her. And when her case was highlighted in the press, that's when 4-5 NGOs joined together by name of Vishaka, and they support her case and take up the case to the Delhi High Court against Union of India. And we have the Vishaka guidelines. And with respect to the Vishaka guidelines, in the year 2013, the law was passed, the Sexual Act, that is the Sexual Harassment at Workplace Act. I'm going deep into this because I think it is very much required for institutions and colleges and all that. So with respect to the Sexual Harassment at Workplace Act, any working place is definitely a workplace. For example, your college for the students is a working place. If you travel from college to your home by college bus and something happens in the college bus, then it is definitely. When you go for field visit, when you go for camps, if anything happens, then of course it is definitely sexual harassment at workplace. There are 2 types in this. One is the quid pro quo and another one is hostile environment. So quid pro quo is you do this for me and I'll do this for you. So usually you do this for me is, a sexual favor that, your boss or your colleague is asking. So it will be usually, if it is a college, university, because I've filed in Pondicherry universities and all cases wherein which your guide forces you to have a sexual relationship with him, and he says that unless and until you abide to me, I wouldn't give you the grace mark, or I wouldn't give you the internal assessment mark, whatever. Those kinds of things normally comes up. And if you don't oblige to it, if it is a workplace, it will be like, I'll give you an increment, or I will give you a promotion, or a transfer as per your request, but you have to be with me. So it is usually like that. And if you're going to refuse such a request from the respondent, that is when it turns out to be he creates a hostile environment for you, in the sense he sees to that your name is spoiled. He says that she's a call girl, you can call her for sex, she's very much available, you just have to pay her 500 rupees and she comes. He sees to that your working environment turns against you, that is your colleagues turn against you. There is also invitations from others based on his suggestions that you are easily available. And comes a stage in which you kind of discontinue your education, or you resign from the workplace and you leave. So these are the 2 what do you say, the types of sexual harassment that you will be forced to. So it is again physical, emotional, financial, everything abuses that happens to you. There are cases where in which people really don't understand whether it is a sexual violence or not. So when they come to us for counseling, because I was a chairperson for sexual harassment at workplace for the government for the past 3 years, I've seen around 73 cases, and most of them come with the doubt because they're confused whether this is a sexual harassment or not. So that we have to explain things to them so that they understand, or maybe while counseling they also come to know, okay, this is nothing, this is just something simple, or I kind of assume that it was a sexual violence or harassment. And with respect to filing of complaints, the incident should have happened like within 3 months, or the committee can decide whether it can be extended to another 6 months. The same thing can also happen, an incident that is regularly happening for the past so many years, which means the last incident had happened just 3 months before. We can definitely file such a complaint. And it all depends on the internal complaints committee, or the IC can decide, giving leverages to the aggrieved women, because she might not be aware of such a committee functioning, or she was like very much mentally disturbed, so she didn't know, or her friends had stopped her from filing a complaint, and so she was, but it needs a lot of guts for somebody to come forward and file a complaint against her seniors or her boss or a colleague, and that takes a lot of mental strength to do it. So once she comes forward with the complaint, if it is not a big harassment that has happened, and she feels okay by just getting a sorry or a written apology from him is enough, then it can be settled before the committee takes up the case. So it's like the out of court settlement. But money exchanges do happen at that time. But once she says, no, it is a serious crime, I definitely want the committee to take it up, then the committee takes up the complaint. So when she gives the complaint letter, it should be like, the date, the time it had happened, who has witnessed it, or no one has witnessed, whatever. And how many people, if it was something, a gang rape, or people ganging up and trying to molest her or something. So all those information should be given, and she has to give the names of the witnesses. For example, most of the time you won't find any witnesses, because these all happen on that, it's always on the darker side. But you always share something with somebody very personal, saying that this has happened to me. If you can trust that person, and if you believe that he will stand by you when the complaint is being taken forward, yes, you can put her or his name in it. And second is, like, you have to provide all the evidences. For example, if there was a CCTV camera footage, then you have to give that. If there is any messages or any kind of Gmail letter transfers, or any kind of photographs that has been sent to you, obscene videos sent to you, all those things has to be given as evidences for the committee. So committee will look into it, and definitely the respondent and the aggrieved women, if they don't sit together and the committee doesn't decide things, it is always done separately, and it takes 90 days for the committee to arrive at a conclusion. Normally, the respondent can be given suspension for those 90 days till the case is completed. Second, he can be transferred to, for example, the Vinayaga mission has got colleges elsewhere. So if this incident has happened in Arpade Vida, he can be transferred to Karikal, or he can be transferred to Salem. That in the sense that, he shouldn't come in face-to-face, or the aggrieved woman shouldn't come face-to-face with the respondent. Because again, there are chances that, it might turn, he might try to turn her hostile, or try to harass her and all that. So that, And we also have something called as a special leave, wherein which 90 days leave is given along with the salary. This is something special. It doesn't come under your normal CL and all that. So once the once the inquiry is done, then on the 90th day, the resolution or the recommendations of the committee is handed over to the head of office. So in your case, it will be, if it is the whole university, then it is your chairman, or if the colleges have their own ICC, then it would be to the head of office, your dean. So normally what kind of recommendations? It can be, dismissal. It can be a long-term suspension. His salary can be deducted. His increment can be cut, maybe 6 months, 1 year. And if it is a very serious crime, for example, a severe molestation or severe rape, then definitely a FIR has to be filed. That is, the committee has to support the aggrieved woman in filing the complaint. The committee doesn't do it directly, but in support of the aggrieved woman, it has to be filed. She has to file, but the committee will be supporting her and giving her all kind of support. And also we can give a monetary gain, or cut down the salary and pass on the money to the aggrieved woman for her to use it for, like, for example, she has got severe psychiatric problem. She's going through a lot of mental depression just because of the incident. So she has to go through series. I know a case wherein which for the past 3 years she's on psychiatric drugs, and she still has it because the case is not complete. So these are the recommendations that you normally give. And once you submit the recommendations to your head of office, the head of office has to implement it within 90 days. And if the respondent or the aggrieved woman are not happy with the recommendations of the committee, then the appeal is there. So they have to go for appeal. Appeal is again never with the ICC again, but to the court. They have to take up the case to the court. And every year, ICC has to file returns with the district collector of that district. So whether it is ICC or District Local Complaints Committee, the returns have to be filed. So that's with sexual harassment at work. Now coming on to online sexual harassment. Shall I continue this?
Mute everybody.
Sir.
One Asmita Keshali, thank you. Can Asmita please mute herself?
Ma'am, please
Can the
continue.
organizers mute everybody?
Okay. So with respect to online sexual harassment, it is unwanted sexual content on social media. So social media can be Twitter, Instagram, Facebook, Gmail, or instant messages. That's unwanted sexual content. So it would be on a public or a private platform. It is like non-consensual non-consensual sharing and taking of videos or photographs, which is usually sexual in content. And then you have sexual bullying, you have sexualization. So all this happens when these are the categories. But how does this happen? It's like, normally your photographs are taken and it is morphed in the sense like it is edited. Your face is, cut and posted on an obscene body, which is kind of, photographed, or it's the other way around. an obscene body is being pasted on your photograph, and it is being used, the pic is taken and it is being posted. Either they open up a new profile of yours and invite all your friends and then post all these images onto it, and they start sexually threatening you to participate in the sexual act. So usually it is for money, and or definitely it is for the sexual participation. So it, or the third, it is for money as well as for the sexual participation. So this is something that is coming up very seriously. Even last week we had taken up a case, and usually it is in the sense unwanted sexual content, unwanted requests or unwanted comments are sent to the particular person, and then from there the incest, the blackmailing starts. And it is usually the women who are targeted, like sexting and for trafficking, prostitution, everything, they use this medium. And in the year 2021, at the global level, if you see 4.80 billion calls complaints were filed with respect to online sexual harassment, which means 61% of the world population was affected. And in that, 33% were the youth. In India, the National Crime Records Bureau says that they have filed in the same year, 2021, 50,035 cases of cyber stalking, cyber blackmailing, fake profiles, fake messages, impersonation, and all that. So it is, this cyber act or the cyber crimes is fast increasing, because the bullier is always there is anonymity that is maintained here. The bullier can attack you by hiding himself on the internet. So you will not have any idea who the person is who is attacking you and who is trying to do such acts. If you know the person, it's fine, but 99% you are unaware who the person is, and you need to be very, very careful. With respect to sexual harassment at workplace, you have your internal complaints committee where you go and file a complaint. There is also district local complaints committee at the collectorate where you can go and file your complaint. Now, with respect to online sexual harassment, it is definitely the cybercrime that you need to approach, and their helpline number is 1930. So either you call up 1930 and inform, or they also have an online registering system wherein which you register and then you can track. So this is something very, very important, because I myself have taken up cases related to cyber issues, wherein which children have undergone such problems during the COVID, when they had online classes. And certain cases I could inform the parents and ask them to have a normally there is a parental guidance that they sit with their children even when they are playing games or anything, videos. But then since the online classes started, the Android phone is always with the child. So the parents, they are also at work, so they don't have time to see what is happening to their child. So things started happening, and certain things I was able to explain to the parents, and they became very much aware, and they were sitting with the child. But one or two cases we definitely had to take it up with the cybercrime, and it kind of got resolved. But it is something that is kind of epidemic now. So we all need to be very, very careful when we are online, and the type of people that we accept as friends, and what type of photographs that you post, whether it is for private or public. All those things you need to be very much aware. Okay, and then now next to crimes related to children. So issues that the children normally face, or the crimes, it is the
sorry to interrupt, ma'am. Can we wind up in another 2 minutes, ma'am?
Yes, I'll just
okay.
Finish this.
Thank you, ma'am. Thank you, ma'am.
Yeah, so it's any issues related to children, you need to approach the child welfare committee, or you need to approach the child line, that is 1098. And I mean, crimes related would normally be like, child abuse, that is POCSO related cases, and child marriage, child labor, prostitution, pornography, and it goes on and on. So many cases. I get calls from various hospitals and also medical colleges, where in which the clinical psychiatry department, they say that they receive cases of child abuse, but the parents are not willing to come forward and file the complaint. So what should we do? So normally you can approach such agencies, which I said, the Child Welfare Committee, which is a bench of magistrate, and I was the chairperson for 6 years, and I filed around 316 cases at that time. We also have something called as the one-stop center, and the phone number is 2914964, and the email ID is oscpuducherry@gmail.com, where you can online file, and it is in 9th Cross, Venkateshwara Nagar, Sara. So anything above 15, anything less than, above 18, less than 18, you can use the services of one-stop center, where we have all the protection officers and the lawyers, the doctors, where in which all the it is a one-stop center basically. And you also have a she box, which is connected to the Ministry of Women and Child, where you can file online complaints. So anything to do, any kind of crimes, especially with women, women's issue, you can definitely go to the she box and file. It will be transferred to the concerned state, and the district or the state DGP will initiate the process. So the Child Welfare Committee is also responsible for adoption. So any adoption issues that is happening, where you come across any orphans that you come across, you have to inform the Department of Women and Child, or the Social Welfare Department. But now it's the Women and Child Department. We have two types of adoptions: inter-country adoption and in-country adoption. So everything is processed through the Child Welfare Committee. And also filing of cases. Child Welfare Committee is a criminal court, wherein which we file cases immediately with the police department. Next, with respect to you doctors, abuse is in the sense it is a healthcare issue. So when you are with a patient, I think you should also be asking a question about domestic violence when you do a health assessment, and it will be a first step towards healthcare. And definitely you should know what the laws are, where the Child Welfare Committee is, where the JJB is, where the Women Commission is. I mean, I'm running out of time, so I'm just brushing. What is POCSO? What is Protection of Domestic Violence Act? What is Dowry Prohibition Act, Sexual Offences Act? All that should be at your fingertips, so that you can help someone. So I would definitely say, listen when your patients talk to you, and please take necessary action. And hearing them is more important. Be the voice of the voiceless. And thank you so much for this opportunity.
Thank you so much, ma'am, for a wonderful and elaborate session on this session on Help Me Doctor, the silent call of a survivor of violence. Like you in your talk have cited so many types of violences that a woman or a child is being subjected to, and the various measures or the various kinds of help and where to seek help. All these things were aptly addressed by you. And who can be a better person than you to address this kind of a session? And we really appreciate your time and effort. And is there, okay, yeah, we'll come to the query. So ma'am, like you have enumerated so many things, like all ICC guidelines, what kind of recommendations, like if there is a complaint, what kind of recommendations to be given to the management, a kind of punishment. So all those things, like our center, like we are, whatever you told, we are following it in letter and spirit. And as per the UGC guidelines, all these helpline numbers like child and women helpline number and the even the like your online complaints, all those cyber crime, all those numbers we have already displayed on our website. Like when I go to take, and you were talking about the dowry related harassment. Like, according to me, dowry in any form, whether it is a gift or whatever, should be condemned. And another thing, what I wanted to tell you is when I go to take sessions, awareness sessions for our non-teaching staff on sexual harassment at workplace, most of them will complain that, madam, it is not the women who are being subjected to harassment nowadays, it is the men who are being subjected to complain. And then it is very much true, because when I see in the like the CDC report of 2010 to 2012, they found that 1 in 17 men have reported sexual harassment. So do you see that the men also will be included in the sexual harassment guidelines soon, ma'am?
Yes, ma'am. I think that, definitely the talks are going on for National Commission for Men and Sexual Harassment at Workplace for Men.
Okay.
But I don't find any sexual in nature when men come to me and complain about the harassment that is happening in their office or institution. They usually say, my boss, who's a lady, she's having a major ego issue. She's like, stopping all my promotions and those kinds of, but nothing like, sexual advances or anything has been reported.
Okay.
But men do have issues.
Okay, ma'am. Thank you for that. And there is a query. It says that if there is an autonomous body in a district where such complaint is there, then can aggrieved go to district collector to make a committee for making a committee when not satisfied with own institution committee findings.
No,
I think
see, the powers of the district local complaints committee or the purpose of a district local complaints committee is for establishments which have, workers less than 9. If, like, for example, a domestic worker in a house, there will be only one. If you go to a shop, it will be only one person or two person. In a hotel, maybe, a small restaurant, it might be only 5% working there, 5 people working there. So less than 9, where do they go and complain? And also for, those contract laborers and all that, and head of offices. For example, if your dean is the person who has committed the crime, then it would come to the district complaints committee. If it is a chief secretary who has done this, then it comes to the district. So these kinds of categories are the ones that are included in the the district complaint committees can take up such complaints. But if you're dissatisfied, you can always come and meet the district collector, and maybe, as I said, appeal is never there. You can always request. The appeal is always with the court. You can complain, but then your complaint wouldn't be taken up by the district local complaints committee because you already have an ICC. Where there is no ICC, then the district committee can play. So recently, for the past 2 years, I've been fighting a case with respect to a teaching faculty in a government college here. And from the DLCC, we had given compulsory retirement. He's got 4 more years to retire. And ultimately, now the governor has signed that, our recommendation is final after the due CCS processes and everything was done. So, those kinds of things can happen, but can't come saying that,
But ma'am, UGC has already laid down the guidelines that wherever there are more than 10 workers, ICC has to be constituted. Yeah. So that has to be followed in all the institutions. And yes, apart from this, UGC also says that we have to appoint gender champions in each college. And these gender champions will be helping the internal complaints committee in overall monitoring of various kinds of harassment.
Yeah, so they also, yes, ma'am. And also they come with no knowledge of how to draft a complaint. So
Yes,
normally
ma'am.
we sit and help them. So if you have somebody like this, there's a support system, then it is easy. They can help them in drafting the complaint and, explaining things for them, and saves your time.
Yes, ma'am.
And do I have 2 minutes to talk on a case, which I think is very, very important?
Madam is asking for 2 minutes. Is it possible? Ma'am,
Okay, you
ma'am,
can
it will
finish
be,
the queries, and if
yes,
there
ma'am.
is.
Ma'am, what we'll do is, like, for the sake of our employees, probably we will organize a session with
Okay.
you, and we will take an appointment, and we would definitely love to have you in our campus
Okay.
to address our staff and everybody else. So that would be nice. So because the inauguration, like everybody has joined in for the inauguration, kindly
Okay.
stay back for inauguration, ma'am. Thank you so much for a wonderful deliberation. Thank you.
And good luck with your conference.
Thank you,
so
ma'am.
much.
Thank you so much.
Thank you so much, ma'am. On behalf of the management of Vinayaka Mission Research Foundation and Arupadai Vidu Medical College, Puducherry, I take immense pleasure in welcoming you all to Forensis Pondi 2023, a virtual national conference come offline workshop. This year's theme for Forensics Pondi is responsible forensic practice from hospital to courtroom. Objective of this conference is to bridge the knowledge practice gap between what is expected versus what is being done by medical professionals in dealing with medical legal situation. Prayer is a way to connect with the Almighty. Now, I would like to call Ms. Sri Lakshmi M. Nair for the invocation song.
Saraswati Namastubhyam Varade Kamarupini Vidyarambham Karishyami Siddhir Bhavatu Me Sada Siddhir Bhavatu Me Sada Siddhir Bhavatu Me Sada.
Thank you so much, Sri Lakshmi. Now, I would like to call Dr. Jia Shambhavi, HOD Forensic Medicine and Toxicology, to give the welcome address. Over to you, ma'am.
A very good morning to one and all. With the blessings of God Almighty and the benevolence of our founder late Dr. Shanmugasundaram sir, and with blessings of Mrs. Annapurni Shanmugasundaram madam, I have taken privilege and pleasure on behalf of the Department of Forensic Medicine, Arubadi Vidu Medical College, to welcome you all for the 3 days virtual national conference come offline workshop Forensis Pondi 2023 on the theme Responsible Forensic Practice from Hospital to Courtroom. It's a moment of pride and honor to thank our patron, Honorable Chancellor, vmrf Dr. A.S. Ganesan sir, for the conference. I am deeply honored to welcome our respected director, vmrf Dr. Anuradha Ganesan ma'am, for the national conference. Welcome, ma'am. I am pleased to welcome the guest of honor for his valuable presence for today's conference as chief guest, Dr. Pratik Kumar, Dean, Manipal Tata Medical College, Jamshedpur. I welcome you and I am grateful to you for accepting our invitation and making your valuable presence here, sir. I am delighted to welcome our Vice Chancellor, Dr. P.K. Sudhir, sir, for this occasion. I extend my warm welcome to Mr. Suresh Samwell, Board of Members, VMRF, for the conference. Welcome you, sir. I am happy to welcome our respected Dean, Dr. P.S. Kotu, sir, for the national conference. I would like to extend my special welcome to the Vice President of Medical Legal Association, Puducherry, Dr. Flemington Marat, and Dr. Seetalal Rathore, General Secretary of Medical Legal Association of Puducherry, for the program. I welcome Dr. Anil Agarwal, Ex-Director, Department of Forensic Medicine, Maulana Azad Medical College, New Delhi. Welcome, sir. I am pleased to welcome Dr. V.N. Mahalakshmi, Dean HPE Madam, I am delighted to offer my welcome to Dr. Vishnu Bhatt, Director Research. I welcome our Medical Superintendent, Dr. Satish Kuruvilla, sir. I feel happy to welcome our Vice Principal, Academics, Dr. T. Rajan, and Vice Principal, Students Affairs, Dr. Arunachalam, sir. I am overwhelmed to welcome our TNMC Observer, Dr. Prasad, sir. I would like to extend my warm welcome to all HOIs of different institutions, HODs of different departments and faculties from various departments, postgraduate and undergraduate students. I feel happy and proud to welcome all the participants who have shown their immense interest in participating in this conference. Once again, I welcome you all for the gathering. Thank you.
Thank you, ma'am. Now, I would like to call Dr. Aarti Amarnath, Organizing Chairperson, to tell about the conference. Over to you, ma'am.
Thank you. It's not the severity of the conviction, but the number of conviction that sends out a message to the society. And forensic medicine, medical practice, and forensic science has an important role to play in this. And that is why we took this theme, responsible forensic practice, from the waiting room to the courtroom. Yes, as introduced itself, one of our objectives was to bridge the gap between what is taught in the textbook and what is supposed to be the practice, and what are the challenges, real-time challenges, as we saw in the first session, what comes to the society. So we wanted to bring in experts from different fields. We also wanted to address specific areas. So the areas that we took in were toxicology, traumatology, sexual offenses, and medical legal autopsies. Along with it, when it comes from waiting room to the courtroom, yes, we go as experts to the court, all medical practitioners across various fields. At some point, we are called in to give evidences in the court of law. But at the same time, the other way is also happening, right? We go to the court at times, unfortunately, as defendants in cases of medical malpractice claims. So we wanted to address areas where the defensive medicine is coming in, but how much can a defensive medicine progress towards, and what should be the border for it? We also wanted to bring in some practices which we are all good at saving patients. We all get trained very good to save patients. But one thing that we always forget is the degree that hangs behind us. So we also wanted to bring in some practices which also protects our degree, but at the same time is actually a way to help the patients also. Some responsible practices. So some forensic responsible practices that we introduced through this conference, and we are planning to go ahead with the workshop whereby we are introducing is a simple example that I would like to give is like when a snake bite case comes or a patient has taken a seeds and comes, one of the responsible practice we thought is like the casualty can have a small chart which shows, and the patients can be helped to identify the snakes. It might not be right always, but it can give some direction to us. So the same with sexual offenses. So one of the things that we are planning to tell all our participants and to even assist in the delegates is that a kit to prepare, which we tried to prepare, doesn't cost much. Even if we have to buy all the sexual offense examination kit, it costed us only 1,100 rupees. But in a medical institution, when we can indent product and we can get stuffs, what extra needs to pay is 100 rupees for a kit. That's all we saw, a simple nail cutter, a simple scissors. That's why the extra products which we had to actually purchase. So that small responsible practices where it assists the patients, but also protects our own self is what we want to address. And one last thing that we also wanted to address in responsible forensic practice is to have policies, to know the policies which are at the national level, which are at the state government level, and which are policies in this institution itself, which everyone should be aware of. And this is I hope this platform is an opening to all. And as an organizing chairperson, I welcome you all again, and thank you for joining us for this conference. Thank you.
Thank you so much, ma'am. Now, I would like to call Dr. Flemingston Morak, Vice President, MLAP, to address the conference. Over to you, sir.
Sir, we are not able to hear you.
Can you hear me?
Yes, sir. Good.
I would like to share the screen if you will allow me.
Sir, you should be able to share now.
Can you see that?
Sir, it's loading. Yes, we can see it now.
Okay, okay. Yeah, good morning, everyone. It's nice to be part of this virtual conference, national conference, and offline workshop. I have been asked to just share about the aims and objectives of MLAP, which stands for Medical Legal Association of Puducherry. Just a minute, yeah. So our Medical Legal Association of Puducherry was registered under the Societies Registration Act of 1860 at the Office of the Registrar of Companies in Puducherry. So we got it registered and got a registration number on 10th March 2017 with a registration number of 2-1-2017 SRA/NA. So since then, this association is under the registration of the Societies Registration Act, and we exist in Puducherry officially. So these are the aims and objectives that we have. So the first objective is to encourage the study, improve the practices, elevate the standards, and promote the progress of forensic medicine and toxicology. And many of us, we all know what forensic medicine is all about. It is normally deals with medical legal cases, and we apply the knowledge of whatever we learn in medicine, medical, paramedical knowledge for administration of justice, mostly in a court of law, can be both civil as well as criminal. And as a forensic person, we deal with what normal people say, with police case. Even our doctors, they are scared of going to court because they feel that it's a police case. So most of the medical legal cases are dealt by us, and we try to help the investigating officer to give the information regarding the cases. Normally we deal with injury cases and issue injury certificates. And these injury certificates, the doctor usually give regarding the severity of injury. And it is either simple or grievous. That is the information that we give. If the person dies, of course, it becomes a case of murder, and post-mortem examination is done. And once the post-mortem examination is done, we find the cause of that and manner of that cause, the time since that, etc. And there's a very good example of Sidhu road race case where he had a fight with one person, and of course that person died, and ultimately it went to court, and he was given punishment for 1 year. Of course, in the High Court, they've given him culpable homicide not amounting to murder, which is a jail term for 3 years. And later on in the Supreme Court, he got it for 1 year and with a fine of 1,000 rupees. So we give information to the investigating officer, and in case of death, the cause of death is normally given. In case of different road traffic accidents, because the police, they are not well versed with the injuries, so they take help from us, and we give the information to them, and they charge the case and bring it to court. Of course, we have to go for oral evidence and give our deposition in the court. It's not about forensic medicine. The second objective is to highlight the importance and raise the standard of medical legal work in relation to the administration of justice, as I've already told. Third one is to encourage and publish journals with important research in all branches of forensic medicine and toxicology. Yes, most of our faculties who are in medical colleges, they are doing a good job and publishing journals in reputed journals. And they are also continuing doing the research in different fields. And now we have postgraduate students. They are also doing researches, and they are also publishing journals, especially those postgraduate students in JIPMER. They have been doing a good job there. Now, in IGMC also, we have started post-graduation. So we are also doing studies and research in different branch and fields. Fourth objective is to organize and arrange meetings and symposia on forensic medicine and allied subject with academic integration among all the medical colleges in Pondicherry. So this is what is happening actually. Most of the different colleges are conducting CMEs, workshops, conferences, and under the aegis of Medical Legal Association of Puducherry. And Dr. RT has also been active in doing that. And this is also the workshop and the conference which is under the banner of MLP. So we thank you, Dr. RT, for bringing our association in the highlight. Then we have the fifth objective, to serve and administer funds, grant endorsement for the furtherance of the research in forensic medicine and toxicology. So this is something which again is difficult for us because we don't have much funds in the association. We are encouraging people to register and become a member of MLP. So those who have not been a part of it can apply, especially those who are in Pondicherry can be a member of the association. So sixth aim is to own and acquire, administer and dispose of properties, movable and immovable of the association. So that is, I think we don't need to explain that. And of course, lastly, to generally do all such things as may widen, improve, and develop the education and the knowledge of those actively concerned in the pursuit of forensic medicine and toxicology. So here we are indulged in medical education, mostly for the undergraduates and postgraduate in all the different colleges of Puducherry. And I'm very sure most of our faculties are coming up with innovative ideas and trying to give the knowledge of our subject to our undergraduate as well as postgraduate students. And they are doing their part in their own field, in their own respective colleges. And they're actively involved in different CMEs and conferences that are being conducted under our banner within Pondicherry. And of course, another CME, National Short Film and Poster Competition, is coming up under the banner of MLAP. And it is organized by the college, Sri Lakshmi Narayan Institute of Medical Science. Dr. Shitalal Rathore is heading the department. And I'm happy to say he has enough faculty now to help him. Earlier, he was a one-man army. Now, he has enough people to help him, and they are coming up with different CMEs and workshops. And it's a very nice to see, and it's an encouragement for others also to continue to improve the subject and get more involvement, especially of the undergraduates. So this is a national short film and poster competition, mainly for the undergraduate students. So you can encourage your undergraduate students to take part in this and be informative about the subject. So I'll end here. Thank you, Dr. Arti, for giving me this time. Yeah, over to you.
Thank you, sir.
Thank you so much, sir. Now, I would like to call Dr. V.N. Mahalakshmi Dean HPE AVMC, and Dr. Vishnu Bhatt, Director Medical Research AVMC, for the facilitation.
Whom do you want first?
Sir, please go ahead, sir.
So, good morning to all the dignitaries, resource persons, and members of MLAP, resource persons, and delegates for this important conference. A lot of hard work has been put in by the organizers to arrange this program. They have a very small department which has to develop into a big shape, and the work done by them is highly appreciated, and they have taken care to mobilize a lot of resource persons from all over the country in order to arrange this conference. I'm sure that it will succeed in the objectives in the next 3 days of the conference. And as told by the MLAP president, it is a very important aspect of research as well as fact finding the medical legal problems. So continuous research has to be done because a lot of issues may come up. So we have to find a new way of investigation and also find out the truth in whatever happens. So it may be a criminal case, it may be a medical negligence case, or it may be related to poisoning or any issues. We have to look for the cause. The idea of cause, one is prevention. We can take steps for prevention. Secondly, we can see that these problems can be handled in a better way. So I'm sure that the deliberation of the conference, which is will be conducted along with the workshop, will go a long way in improving our knowledge, skills, and also it will help in collaboration of different people working in the medical legal aspects. So people from legal, people from the medical side, people from the social worker side, all brought together so that we will have a combined approach to the whole problem. And I am sure that all of you go back with a lot of knowledge and skills from the workshop, which will help in developing the future forensic subject in our country. And I wish the conference all the best. Thank you very much.
Thank you, sir. Ma'am, over to you, ma'am.
Good morning, friends. On behalf of AVMC, I welcome everyone who is present here, and a special welcome to our chief guest, Dr. Pradeep Kumar. It's nice of you to join, sir, and also nice to see Mark presenting about the objectives of the Pondicherry Association of Medical Legal Practitioners. And we've gone through this conference program, and it actually is very broad-based and practice-oriented for the practicing physicians. And I hope that this would go a long way in increasing the awareness about medical legal problems. And as Vishnu Bhatt sir said, that remove the fear about courts and medical legal issues from doctors. I wish the program all success and happy learning to everyone. Thank you very much. Nati, I'm done.
Yes, ma'am. Yes, ma'am.
Thank you so much, ma'am. Now, I would like to call Dr. Pradeep Kumar, Dean Manipal Tata Medical College, Jamshedpur, to address the gathering.
Good morning, everybody. Am I audible?
Yes, sir. You are loud and clear.
Yeah. Greetings to all the delegates of this workshop and conference. At the outset, let me thank Professor Kotur, my good friend, and the Department of Forensic Medicine at Arupadai Veedu Medical College, Puducherry. I see a lot of my friends, Dr. Pushpa Kotur is there, Anil Agarwal, I could see, my friends and several other people are there. Dear friends, thank you for inviting me to address the inaugural function, and the theme is from hospital to courtroom, and the apprehensions are about the doctors visiting the court of law and to go there. Now, this apprehension and fear can be eliminated if only we ensure competencies and knowledge in our students. So, glad there is a change in the attitude of the MCI to NMC, where we are in the process of going competency based. I feel a challenge to impart these competencies among the students of different medical schools, because many schools do not have, many medical colleges do not have the facility of one of the important elements, which is autopsy. And Karnataka leads from the forefront that almost all the private colleges have been permitted. This should be extended across the country. And the wisdom of the NMC or MCI, whenever they are inspecting and approving or giving permission to start a medical college, they are looking at various facilities that include hospital, beds, infrastructure. But when it comes to forensic, they do not make it as a mandatory checklist that autopsy permission should be part of it. And the state government, which gives clearance for starting a medical school, should incorporate these things and ensure that the skills are imparted. Dear friends, the society has given us a responsibility of making doctors or healthcare workers who do no harm to society when they go out into the community. And it is our responsibility to ensure all the medical students and medical graduates who are leaving the portals of the medical school should be competent, and we should have the courage to go as a patient to our students in case a need arises. So that is the level of competencies which we must ensure that the students are involved in the training part of it. Now, to do so, the important things is, the fear, what you said, Aarti, is because he is not competent. He does not have knowledge. He does not have skills. As teachers at every level, we should ensure that they are competent. I was very curious to share with you, the attitude of teachers is becoming very different these days. I've seen 5 deemed universities and also a state university and a national university that in the pre and paraclinical, no student is failing, but when it comes to theory, he is failing miserably. Now, there should be a match or correlation between the marks in theory, viva, and practicals. Then only it will be a good examination process. Most of the teachers have scared to give the right score to a candidate in practicals for the fear of backlash. I think to end that backlash, we should ensure we give adequate training to the students. Until he or she is competent, he must not be permitted to take the examination. Then only he or she will be able to face the challenges in the community or the courtroom or medical legal matters. Dear friends, I do not want to take much time in the inaugural function. All I want to say is, let us all get enlightened by the end of the day as we progress. And I would like to thank Dr. Kotur, Dr. Pushpa Kotur, and the Department of Forensic Medicine for giving this opportunity to be part of this. And I have a session coming up a little later on negligence. I'll join you in that session. Thank you, organizers.
Thank you so much, sir. Now, I would like to call Dr. Anuradha Ganesh, Director, VMRF, for felicitation and release of souvenir. Over to you, ma'am.
Thank you. Good morning and greetings to our Dean, Senior Leadership, esteemed Chief Guest, delegates, faculty, students, and all of you present at this virtual conference. It is an honor to be here with all of you today. in this conference, Forensis Pondi, as we all gather to discuss the latest advancement in forensic medicine and toxicology. I'm excited to announce the release of this special souvenir that I'm sure will be of great interest to all of you. This souvenir is a testament to the hard work and dedication of the professionals in this field. Each year, countless hours are spent conducting analysis, interpreting data, and presenting findings that help us better understand the complex issues of this field. This souvenir projects the progress that has been made in the forensic science and toxicology department. Without further ado, it is my great pleasure to officially release the souvenir on forensic medicine and toxicology. I hope you find it informative, interesting, and valuable. I invite you all to take a moment to view this souvenir, which showcases some of the important advances that have been made in recent years. This souvenir provides us a glimpse of the latest developments in the field, including artificial intelligence, and keeps us updated. Once again, I congratulate Dr. Jayas Shambhavi, HOD of Forensic Medicine, Dr. Aarti Amarnath, and Dr. S. Prabhakaran from the Department of Forensic Medicine and Toxicology, AVMC, and to all the professionals who have contributed to the production of this souvenir. Thank you.
Thank you, ma'am. So the souvenir at a glimpse. Here we have the organizing team and a few words about our college. Then we have in the department, we have developed our department over the period of time. We have STS projects which are ongoing. This is our department with full-fledged anthropology sets, and now we also have a toxicology garden which is introduced as a part of the conference. This is about our theme, and as we go in, we have the program schedules. We are also happy to tell you about the workshops. We have 4 workshops which are in plan, morning and evening. And next time we expect from across the country, we have more people to join us in Pondicherry. And we have the scientific papers. We are happy to say that we have received 8 faculty presentations, 20 postgraduates, and 20 undergraduate presentations too. So we go about, we have the messages from the board. We have messages from our institutional heads, we have the speakers, and we also have the scientific oral presentations. And in the scientific oral presentations, as ma'am pointed out, we have a range of topics ranging from the role of doctors to the AI's play that is being done in the current situation. So this is for our conference. It's a brief one, and the whole package will be mailed to you at the end of the conference. Thank you.
Thank you so much, ma'am. Now, I would like to call Dr. S. Prabhakaran to give vote of thanks.
I'm sorry. Yeah. I request our dean. Yeah. Ma'am, you want to say some words?
Yes, just, on behalf of this management, I would like to take this opportunity to welcome our chief guest, Dr. Pradeep Kumar, Dean, Manipal Tata Medical College, Jamshedpur. I want to tell him that I was a student when he was in Manipal, KMC Manipal, when he was one of the faculty there. And I would also like to welcome all the other members, Dr. Flemington Marak, Vice President of the Medical Legal Association, and all the other esteemed delegates from different parts of the country, the postgraduates, undergraduates, CRMIs, members from the judiciary, researchers, legal experts, police, and of course the faculty of forensic medicine and toxicology, the faculty of AVMC, and students. And I'm happy to note that the Department of Forensic Medicine is conducting this conference with such esteemed resource persons, and who are all very well admired in their fields. I'm sure that this session will be immensely useful to all our participants. It is quite interesting to note about all the several breakthroughs that have been happening in this field. And what I read is about the DNA analysis, which has become increasingly accurate and efficient due to new technologies. And another exciting one that I have read about is 3D forensic facial reconstruction using the reconstruction software and real-time human remains. We can actually give a possibility of exact physical appearance, and also the use of mass spectrometry in toxicology and for identification of unknown agents. Overall, I think all these breakthroughs in forensic medicine and toxicology have enabled more accurate and efficient investigations, leading to more just outcomes for individuals involved in legal and medical cases. And with forensic medicine, there is also a collaboration between multiple disciplines such as chemistry, biology, law enforcement, making it very intellectually stimulating and socially impactful. So, and to say, an example of a famous challenging case was the investigation and death of Marilyn Monroe. Despite numerous conspiracy theories and conflicting accounts of what happened, forensic experts were actually able to find through autopsy findings that she died of an overdose of barbiturates. Similarly, I think some historical investigations like the remains from Titanic disaster and ancient mummies, I think forensic science has played a very big role. So from the forensic science is so vast and continuously evolving, and it plays quite a crucial role in many aspects of our lives. Our very esteemed chief guest, Dr. Pradeep Kumar, the Dean of Manipal Tata Medical College, who's going to be talking about medical negligence, is a very, very important topic. He also told us a valuable point about allowing institutes to conduct autopsies. Coming to medical negligence, I would like to say a few things about it. I think it is a very serious issue that can have significant consequences for patients and healthcare providers alike. It is a situation where a medical professional fails to provide the necessary standard of care, resulting in harm, injury, or even death. The awareness of medical negligence is important because it highlights the legal, ethical, and professional responsibilities that doctors and other healthcare professionals have towards their patients. It can provide valuable insights into how to prevent and manage medical errors and improve patient safety, and have healthcare systems in place to ensure quality care. Ultimately, the understanding of medical negligence definitely serves as a reminder of the importance of maintaining high standards of professionalism, ethics, and accountability in the healthcare industry. I'm also happy to note that we have Mrs. Suhashini Rao from Vinayaka Mission's Law School who is participating, and our leadership under Dr. Kotur, Dr. Mahalakshmi, Dr. Vishnu Bhatt, Dr. Jay Singh, Dr. Satish Kurwala, Dr. Rajan, and others for all their guidance in conducting this conference. I thank all the external experts for sharing the knowledge and insights to all the attendees. I hope this is the beginning of many such collaborations and interactions. And to all the participants, I encourage you to continue learning and engaging with the topics discussed at this conference. As the Kural says, Tottanai Thurum Manarkeni, Mandarku Katranai Thurum Arivu. Here, Valluvar explains that the process of learning is referred to the process of digging a spring in sandy soil to get water. The more or deeper we dig in sandy soil, the more water we get. Similarly, the more and deeper we learn, the better and the sharper will be our wisdom. That is Valluvar's wisdom in Kural 396. The fountain of knowledge keeps flowing as the fountain of water keeps flowing. With these words, let me end my little speech, and I wish the conference big success. Thank you.
Thank you, ma'am.
Thank you so much, ma'am. Pardon me, ladies and gentlemen. Now I would like to call Dr. P.F. Kotur, Dean AVMC, for the presidential address. Over to you, sir.
Yeah, very good morning to all the esteemed guests, resource persons, participants. As the head of the institution, I'm indeed happy to offer the presidential remarks on this occasion. One thing is, the idea to conceive this conference dates back to almost a year back when our tiny department of forensic medicine organized one workshop for the FHS students. And I was a part of that. And it was one, the forensic medicine department in all medical colleges, with very few exceptions and across the country, is a very skeletal framework. Then I was very excited to see our tiny department doing a wonderful job. And I said, Dr. Aarti, it has to be here for our medical students as well. Then she was and she has gathered all police people, medical legal people, etc., from the city of Pondicherry. And it was a really wonderful physical workshop. And that thing came to my mind. She said, we will do it. Then incidentally, it so happened I traveled to Kolar, where I met our Honorable Vice Chancellor. He was Vice Chancellor at that time, Professor Pradeep, who is a good friend of mine. And I said, Dr. Pradeep, aisa karna hai. And he, with open arms, sir, karenge, he said. Then I came back with very pleasant feelings. Then he also promised me that he will put me across all these stalwarts in his field across the country and bring them on one platform. Professor Pradeep, thank you very much from behalf of AVMC for helping us to realize this small dream. And afterwards, I put them across. Dr. Aarti was in constant touch with Professor Pradeep, and he helped us to put across many resource persons, etc. Wonderful scientific program was coined. This is how the genesis of this conference. And I must, at this point of time, first the outmost, bring the greetings from our Honorable Chancellor, Dr. A.S. Ganeshan, and our Board of Management member, Dr. Suresh Shamwell, who have patronized this conference. Of course, our Madam Chancellor, Dr. Anuradha Ganeshan, who just now shared wonderful thoughts on this occasion, is also here. We are very privileged. I also like to acknowledge the presence of Dr. Anil Agarwal. I don't think he remembers me, because when I traveled to Maulana Azad Medical College sometime back, I used to come that time for skill lab, for anesthesia, then that kind of a thing. Hadke was my good friend. That time, I remember to have met him. Probably, he must be very happy to see his student Aarti doing so well. It is a matter of pride for any teacher. If they do their students are doing well, there's nothing better gift than that. And I'm also excited to note that around 300 registrations from across the country, resource from across the country, Andaman Nicobar, Kashmir, Pradesh, from all these places, the participants are. The attraction to a conference, it depends upon persons, what information is being shared. That is a proof of the scientific program that has been coined by our team. I also must acknowledge the office bearers of the Medical Legal Association of Pondicherry, who are co-hosts for this conference, their help. And the one special mention is, I acknowledge the presence of the representative from National Law School. I don't think he's still here, Dr. Nandimat, who happens to be my good friend as well. National Law School, Bangalore. That means the resource persons, apart from the medical institutions, they are from the other National Law School, we all know is a prestigious school. He's here to share his experiences. I think his session is tomorrow. We have Mrs. Dr. Subhashini from our National Law School, our own Padividu Law School at Chennai. And this laid down the foundation for our path for the future, for the tiny department. And one thought I like to share, I was just trying to Google out, our Indian legacy in this forensic medicine dates back to Chanakya's days, almost 2,500 years to 3,000 years back. In his Kautilya's Artha Shastra, he has mentioned about the causes of death, the need of the autopsy, and fingerprinting, etc. That means we Indians carry, like in the yoga and all, we've got a legacy. Of course, only during the colonial regime, all this modern history, modern laboratories, etc., have been established, and we continue to do with that. And forensic medicine, according to me, is a multifaceted discipline. Forensic pathology, forensic psychiatry, and see, all these things are a part and parcel of forensic dentistry, forensic radiology. So everybody will be a part of it. And now, the national alert of a Nirbhaya case and also many things, every day, this is very need of the hour. And at this juncture, this platform has been created, drawing all the experts across the country to share the platform. And it caters to the needs of the students, it caters to the need of the professionals, need of the professionals in this one as well. And our department of forensic medicine has got a certain dreams to come true in the coming years. Of course, one of them is we have conceived the idea of having a poison detection center here in the center that I was referring to. Certainly, we should have that. And to develop our existing museum into state-of-art forensic museum. Professor Pradeep has got a wonderful museum in Kolar. That one. And we like to have some kind of some short courses, certificate courses, or evaluated program, because this knowledge is very much essential for any medical practitioner. These are what the forensic medicine department has got in mind. And of course, our National Law School, which is a new model of Arpadi Video Law School in Chennai. We have some joint plans with them. And this is what. And finally, I thank all the resource persons, all the delegates. And I can't say virtually, I wish you all a pleasant stay on the virtual platform here at Pondicherry. With these few words, I wish a very fruitful deliberation to all of you. Thank you and namaste.
Thank you so much, sir. Now, I would like to call Dr. S. Prabhakaran, Organizing Secretary, for the vote of thanks. Over to you, sir.
Thank you. Am I audible? So on behalf of the organizing team, it's a privilege to propose the vote of thanks on this occasion. So first and foremost, I would like to thank our chief guest, Dr. Pradeep Kumar sir, for his help and the guidance throughout the conference. And we started with him initially, so he was the first person to be confirmed for the conference, after which we approached everyone else. And also thanks to the management and the college officials, our Honorable Chancellor, Dr. Ganeshan sir, our Honorable Director, Dr. Anuradha ma'am, Member Board of Management, Mr. Samuel sir, and our Dean P.F. Kotur sir for trusting us and giving us this opportunity, even though we are a small team. And I would like to thank all the speakers, resource persons for the conference and the workshops. And thanks to the Medical Legal Association of Pondicherry for collaborating with us and trusting us. I thank Dr. Fremington Marak sir, Vice President of MLAP, Dr. Sitala Rathore sir, General Secretary of MLAP. And I would like to thank our advisory committee for the conference, Dr. Vishnu Bhatt sir, Dr. Jay Singh sir, Dr. V.N. Mahalakshmi madam, and our vice principals, Dr. Rajan sir and Dr. Arunachalam sir, and DMS, Dr. Jaykumar sir and Satish sir. And I would like to thank the CME coordinator, Dr. Susmita ma'am, and observer, Dr. Prasad sir, for their help and the guide throughout the conference. And I extend our gratitude towards all members of the registration committee, invitation and hospital committee, Dr. Stephen and Dr. Kumar sir from the hospital and invitation committee. I would like to thank the scientific committee, Dr. Sitalal sir, Rohit Goyal sir, and Vinod Chaudhary sir for your support and guiding us with the paper presentations. I would like to thank Dr. Siva sir in the finance committee for his constant support. And I would like to thank Dr. Manju ma'am for helping us in the souvenir committee and also helping us in all other things wherever we were stuck. She helped us a lot. And thanks to Dr. Ashwin Nelson and Dr. Ravi Kumar sir for helping us for getting the sponsorships. And also I extend my special gratitude and thanks to the non-teaching staff of AVMC who have worked and have ensured that the conference should become a memorable success. Thanks to all the non-teaching staffs. And a special mention need to be given to our department tutors who have worked hard for the conference success, Dr. Anupriya, Dr. Kirtiga, and Dr. Mukilan. And thanks to all the participants for joining in the conference. And last but not the least, thanks to all the UG students of AVMC for the active participation, and thank you.
Thank you so much, sir. Now I request everyone to rise up for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल बंग विंध्य हिमाचल यमुना गंगा उज्ज्वल जलधि तरंग तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
Thank you.
Having an amazing start of the conference, let's move further. Now, I would like to call the second speaker of the day, Dr. Pradeep Kumar, Vice Chancellor, Sri Devraj URS Academy of Higher Education and Research, Kolar, Karnataka, to present on the topic Keynote Address on Medical Negligence. Over to you, sir.
To introduce this.
Can I request the host to disable me the screen sharing?
Yes, sir, I'll do that.
So I'll ensure my screen is there.
Yes, sir, you're there. Dr. Zakaria Thomas, sir, you're there?
Yeah, he's there.
Yes, sir. Sir, am I audible to you?
Yes, sir. Yes, madam.
Yes, sir. Sir, I request you to introduce our speaker and to chair the session. Thank you, sir.
Respected organizations, Department of Forensic Medicine and Toxicology, AVMC Medical College, Puducherry. Respected and distinguished Chief Guest, Dr. Pradeep Kumar, sir, Dean Manipal, Tata Medical College, Jamshedpur, who will be presenting the keynote address on medical negligence. So let me go to an introduction to this medical negligence. In India, it is estimated that nearly 52 lakhs of medical errors happen every year. And error is an error, but invariably the sufferer is the patient who takes the course of treatment or follows the medical therapy or takes the prescribed medicines inadvertently to pay the price, occasionally with his life too. In majority of cases, the errors are due to the lack of doctor-patient communication, illegible prescriptions, treatment notes, or look-alike or sound-alike drugs. So negligence, medical negligence is a global problem. The consequences are disastrous to everyone, to the patient, and the cosmetic changes in the law is not sufficient. So what is negligence? Negligence is defined by Baron Alderson, Blith versus Birmingham as negligence is the breach of a duty caused by an omission to do something which a reasonable man, guided upon those considerations which ordinarily regulate the conduct of human affairs, would do, or doing something which a prudent and reasonable man would not do. The 7th National Convention on Medicine and Law in November 2022 instructed that the Parliament must introduce special provisions to deal with cases of medical negligence, introduce special provisions not only in IPC, Indian Penal Code, Criminal Procedure Code, Indian Evidence Act, and setting up a medical tribunal to deal with cases of medical negligence. So with these introductory remarks, I am handing over to the speaker, Dr. Pradeep Kumar, sir, who needs no introduction, who is now working as the Dean of Manipal Tata Medical College, Jamshedpur, to highlight on this topic and to clear your doubts and the recent advances in medical negligence. Thank you, sir. Over to you, sir.
Yeah, I'm trying to open the. Is my screen visible?
Sir, no.
Not yet.
Not yet. That's what is it. I'm trying to. Is a challenge.
Hello.
Yeah, 1 minute. It's on the desktop. Just a minute. Yeah. Allow Zoom to share screen.
Zoom opens. Arrow there. What do you choose?
Don't sharing options. Share host.
It says only the host can share. Are you made the host?
Can you make me the host? Because
yes,
it's
sir.
only the host is able to share it. Yeah.
Sir, you are a co-host, so you should be able to share, sir. Sir, down, if you see, you can see the screen share option. At the bottom.
Yes. I'm aware of that, but it is not coming. I'm using a MacBook.
Mac, okay. So do you want us to share it from our end? Do you want to share?
That's what I'm trying to see.
Security issues it's asking. If you do this, they should have opened.
Yeah.
Sir, I'll suggest that you share the entire screen. Then it will do, sir.
Oh.
The share screen option is not there, sir. It's only accessing the desktop.
Allowing open system preferences, it's not letting it go. I don't know, is there any challenges? Is this visible?
No.
No.
Sir, I am seeing Kautilya behind you. He should be able to.
I know. This is why I took a youngster to help me out. Slides, virtual background.
Video
version. Sorry, gentlemen. I think I have to do it on another system. In the meanwhile, if the second speaker is ready, because
No.
I don't want to delay.
You can share, Dr. Pradeep, your presentation. It can be screened from here.
Yes.
That also is.
Looks like system.
System Mac is not letting you. I'll do one thing. I'll shift it to my Windows and then do it. My apologies for this challenge. I never expected that this will be a problem. iPad via AirPlay, iPhone, Microsoft. This is not
showing a PowerPoint, but it says open systems preferences.
Yeah.
And
it's not coming up. Can I need about 5 minutes time, or maybe I'm willing to do the session after the next speaker. Next speaker is ready. Arti?
Yes, sir. I'm just checking on it. Dr. Shan is not there. Agarwal sir is there. Sir, Agarwal sir, would you like to go ahead with it, sir?
Anil, are you ready?
Can you share the PowerPoint to them on chat or?
Can I share the PowerPoint to you? Arti?
Yes, sir. Yes, sir. You can.
That is the best thing.
Chat, I can send it.
Yes, sir, or WhatsApp or mail, whichever is your preferred method, sir.
Okay. I'll do one thing. I'll send her a WhatsApp.
Okay.
I have WhatsApp. Yeah.
Computer learning कर लो.
Minute.
Sir, you can.
I'm sharing you now.
Okay.
1 minute.
Sir, as you keep sending in, I'll ask ma'am
It
to
says
introduce
7.6
you,
MB.
sir.
Yeah, I've sent the slide.
Okay. Sir, mail, WhatsApp, sir?
Yeah, WhatsApp. Yeah.
Okay, okay. So while I keep loading, I'll just ask ma'am to introduce you in few words, sir.
Yeah, it's sent.
Good morning, everyone. I take privilege in introducing Dr. G. Pradeep Kumar, Dean, Manipal Tata Memorial College, Jamshedpur. Dr. Pradeep graduated from Kakatiya University, Warangal in 1980. He obtained his diploma in forensic medicine and post-graduation in forensic medicine from Osmania University. He also holds a diploma in criminology and criminal law from Annamalai University. Dr. Pradeep started his career as a lecturer at Kasturba Medical College, Manipal, 1985, and served the university in various academic and administrative capacities. He was the Deputy Controller of Examinations of Manipal Academy of Higher Education, Manipal, from 1995 to 96. Dr. Pradeep was deputed to Manipal Medical College of Medical Sciences, Pokhara, Nepal, in March 1998 as Professor and Head for Curriculum Planning of Forensic Medicine. During his tenure in Nepal, he had conducted a series of lectures on medico-legal significance for the benefit of the government medical officers and the police officers at Western Range Hospital, Pokhara, Nepal. Later, Dr. Pradeep was deputed to the Commonwealth of Bahamas from January 1999 to December 2000, where he served as consultant forensic pathologist for the Bahamas. During his tenure, he has delivered guest lectures on the applications of medical knowledge to the law graduates at Royal College of Bahamas. He has also delivered the lectures to the police officers at the Royal Bahamas Police College of Commonwealth of Bahamas. Dr. Pradeep served as the head of the Department Forensic Medicine, KMC Manipal, from 2001 to 2003 and from 2007 to 2013. He was appointed as the Associate Dean of KMC Manipal in 2004 and served the position till 2012. He was elevated as a Dean of KMC Manipal in 2013, the year college observed its Diamond Jubilee, and held position till 2015. During his tenure as Dean, he brought in academic reforms and streamlined the curriculum for the undergraduates. He also served as the Director of Quality and Compliance, Mahe, Manipal, for a short stint. Later, he served as a professor at Melaka Manipal Medical College, Manipal, from 2016 to 2019. He has been associated with medical education since 1986 and has conducted several workshops pertaining to teaching, learning, student evaluation, postgraduate orientation, and learning skills. Dr. Pradeep, to his credit, has more than 65 publications in various national and international journals to repute. He has been invited as a resource person for various workshops and has presented scientific papers in several national and regional conferences. He has membership to many academic professional bodies like Indian Academy of Forensic Medicine, South India Medical Legal Association, Karnataka Medical Legal Society, and Indian Medical Association, etc. He was conferred the Lifetime Achievement by Indian Academy of Forensic Medicine. He was a former Vice Chancellor of Sri Devraj URS Academy of Higher Education and Research Scholar. Over to you, Dr. Pradeep Kumar, sir.
Yeah. Can you, Aarti is sharing the slides?
Yes, sir. I'm sharing the slides.
Yeah. What I'll do is I'll do parallelly here so that I'll be able to sync with you.
Yes, sir. Done.
All right. Can you start sharing the screen?
Yeah. Yes, sir. Share without sound.
Yeah.
Yes, sir.
Yeah. Can you go for slideshow, please? Yeah. Yeah. Hello.
Yes, sir. You're good to go, sir.
Yeah. Good morning. Greetings to all of you from Manipal Tata Medical College, Jamshedpur, a constituent unit of Manipal Academy of Higher Education. Dear friends, let me express my gratitude to the Department of Forensic Medicine and Professor Kotur and his team for giving me this opportunity. And I'm glad all my colleagues and friends in forensic are also joined. And I'll be very happy to share the slides. Can you go to next slide, please? I've been given the topic of negligence, and it's an important element for all the healthcare workers, not just doctors. A wrong can go anywhere, everywhere, and for everybody. So it's important for us to know what are the challenges we as healthcare workers are going to do it. Next slide, please. Now, there are various words we can use for negligence, which could be carelessness, disregardful, neglectful, unconcerned, inconsiderate. Actually, negligence is an inattention to one's duty, resulting in some harm to the patient. Next slide, please. Dear friends, can you go to the, it's a, 1 minute.
Sir, is this the correct one?
Next slide.
Okay.
Yeah, okay. Right. I just wanted to share with you that in August 2015, a resident doctor attempted a pleural tap procedure, which was done in haste without consent. There were no seniors around. He punctured the left lung instead of the right, sending patient to shock, and the patient died, and the death certificate was given as a cardiac shock. Next slide, please. Can you go next slide? Aarti? Yes. Another case wherein an IV analgesic went in artery, gangrene of 2 fingers, where 3 consultants were associated and 2 different drugs were prescribed. Who gave the orders of instructions? Who is responsible when multiple people are involved in such areas? And the challenges of not documenting in the slide are important elements. Next slide, please. Now, NCDRC asked Apollo Hospital doctors to pay 1 crore for medical negligence. So the amount of compensation, which were to be in lakhs, is now going into crores. Next slide, please. Most of my colleagues are familiar, the senior colleagues, that the landmark judgment was a windfall compensation in the in the Calcutta case of Amri Hospital, where Dr. Anuradha Saha, whose case is a landmark judgment for India. Can you go to next slide, please? What happened was in May 98, Anuradha Saha was admitted at Amri Hospital, Kolkata, and she had toxic epidermal necrolysis, shifted to Mumbai, where she died. Now, Dr. Kunal, who lost the case at state level, went to the National Consumer Commission and found the hospital and doctors guilty, and a compensation of 1.7 crore was awarded. Not happy. Next. He approached the Supreme Court and claimed 200 crores, calculating the deceased's annual net income into 30 years of an anticipated working area of life. And the court ordered a compensation of 5.96 crores. With interest, it was 11 crores. These are the highest compensation ever in India for a doctor's wrongdoing. So it's very important for us as doctors to have adequate protection. It's not just the money, but today the trend is people come and beat us up in the hospital. Bengal doctors are beaten up, hospital ransacked by angry relatives, hospital refuse to treat accident victims, people ransack. Now, this is a new trend which is happening across the country, and it's going to be a big challenge for us as doctors. How do we handle this particular entity? Next. Next slide, Aarti. Now, what happens is there's a lot of protests and dharnas, and political people do not support for their political gains, and doctors are being beaten up. We are also asked to pay compensation. These are the new challenges which the medical fraternity is facing. And as doctors, what is it we can do to prevent such challenges? Next. So these are some of the areas where things can go wrong, which most of us are familiar. It could be orthopedics, it could be medicine, it could be radiology, any department where a wrong can happen. Now, let us see what is that we have challenges. Next slide. Now, the question is, who is responsible for when things go wrong? Is it a doctor? Is it the paramedics or the nurses? Or the hospital administration? Or the patient attendants who cause sometimes contributing to the negligence? And we have limited resources. Can we blame the institution or the hospital for not providing, or the laws which are not adequately protected for us?
Sir, you have another meeting, sir. Aditya sir asking.
Kotur sir, can you please mute, sir? Thank you. Next slide. Now, this is some of the triggers which can happen because of emotional challenges which happen in the emergency room or the trauma or ICUs. Sudden death, denial of admissions, delay in providing care, absence of equipments and drugs, negligence by staff, junior doctors communicating about death to the patient and not the seniors. Very often when death happens, the junior doctors are pushed in the forefront, seniors do not come into the picture. Now, the relationship of a doctor and patient is based on trust and faith. And this is one area we are lacking in the days because, next slide. The fundamental thing which I would like to share to all my colleagues is primum non nocere, the most popular phrase for me. First, do no harm. It's okay if you can't do good to a patient, but please do not do harm. If you do not know, let us not meddle with a patient until you seek help from somebody. Next, please. As Paracelsus said, medicine is not merely a science, but an art. The character of the physician may act more powerfully upon the patient than the drugs employed. Arti, when I give a pause, we can move on. Yeah. Now, litigations against doctors are not due to lack of skill, but due to lack of professionalism. Poor consent and communication are the major reasons. If you observe several cases in the country, only the allopathic doctors are sued and not the Ayurveda, homeopathy, or other systems. Let us look at some of the reasons for rise in litigation against doctors. Patients grumble that doctors, Arti say, please move on. Yeah. You can stop. Patients always grumble that doctors have no time, doctors are rude, doctors don't listen and don't explain. Very often, doctors do not even listen to the patient when the patient gives complaint. The first thing he does is give a list of investigations. He says, get these investigations and come back. Very often, a patient would like to be touched, auscultated, or palpated, which is not happening in these days. As Kobe said, most people do not listen with the intent to understand, but they listen with the intent to reply. This is the challenge. They'll be preparing an answer as the patient is complaining, and these gaps will result in a huge gap of the wound between the doctor-patient relationship, resulting in challenges. Now, miscommunication is a fundamental challenge for all of us. Miscommunication could be because of language, it could be because of the media, it could be because of the inability of the patient to understand, or inability of the doctor or the nursing staff to communicate. Now, continuing with the reasons to rise in litigations. Continue, Arti, please move on. Yeah. One of the reason is falling standards. I do not know how many of you agree with me. I can ask only a fundamental question. When your graduates pass out, do you have the courage to go to them as patients? If yes, then the medical students in a school or college are adequately trained. Most of us do not have the courage to go to our students because we do not trust the level of competence in our students. Another important reason is documentation and medical records. This is the biggest challenge I've been facing as a dean and as a vice chancellor have seen in Kolar. Doctors are reluctant to put records properly. They do not write the time, they do not sign, they do lot of errors in these things. And the ego of reluctance to get a second opinion is one thing which is one of the reasons for rise in litigation. Now, please continue. Yeah. Another issues which people feel is doctors ask for unnecessary investigations, admissions, and procedures, and also prescribe expensive medications of brand of the highest and not generic medication. These are one of the complaints or the reasons where patients are not happy with the doctor. And also, patients are aware of the modern gadgets of Google doctors or Google patients, and they have a lot of expectations from patients. If these expectations are not fulfilled, they will feel unhappy, they have a grouse against us, and it's time for us to keep update. Probably, if not Google, there are other areas for us to be a step ahead of our patient who comes with a lot of questions. Now, other challenges include inadequate doctor-patient ratio, especially in the emergency room. I'm sorry to state, corruption by certain healthcare workers is also a contribution, and inability of the patient's participation in decision making. Very often we take for granted that the patient doesn't know and I will decide for the patient. Paternalism has taken over, and it's time for us to involve the patient. And also the challenges of advanced technology coming up, and if the doctors do not keep pace and update, this can cause undue expectations and not being fulfilled by the doctors. Now, why law is important? Because as physicians are preservers of the sick, so are the laws for the injured. We should not have a grouse that we are taken to court. If there are no courts and no challenges, we will be still more complacent because the laws are there, people are watching us. We'll try to be attentive and create a better healthcare for our patients. Dear friends, it is two important elements for us. On one side is the doctor-patient relationship, which is a bad behavior, we call misconduct. On the other side is bad treatment, we call it negligence. Okay, there are two important components. Very often we mix up these two issues. Bad behavior is misconduct and bad treatment is negligence. I'll focus primarily on negligence for the next 15-20 minutes because we are lacking behind time. Next slide, please. Negligence is treatment of a patient by a doctor in a manner contrary to the accepted medical standards, resulting in injury to the patient. I'm not interested in the terms what he used, but as long as the doctor does not do as expected and the patient suffers, that's the only important element for us. Next. Now, as Baron Alderson stated, the omission to do something which a reasonable man, guided by those ordinary considerations that ordinarily regulates human affairs, would do, or doing something which a prudent and reasonable man would not do. Now, this will look complicated and complex. Can you go back to the previous slide for a second? Yeah. All I want to say here is, we must do something which every doctor does. If we do not do what every doctor does, then it is wrong. And the second one is, we must not do a thing which others don't do. Simple. So be a part of the medical fraternity. Do what others do and don't do what others don't do. Next one. Now, as a part of this, please go on. One more, yeah. One more, I think. Yeah. Now, the important thing here is a patient must prove that we, the doctors, owed a duty of standard of care and we breached that duty. Because of this breach of duty, the patient must suffer some harm that is called as damage. And there should be a causal connection between the carelessness of the doctor and the harm suffered. And this is what is called as a direct causation. And the harm suffered was a foreseeable one or an anticipated one. A doctor should foresee or anticipate. Next slide. I think, yeah. I don't want to discuss much. Most of the textbooks mention about this civil and criminal negligence. But all I want to say is civil negligence is important because law of torts is an important component which most of us do not go through it. It's important as healthcare providers, we should do a little bit of this tort law. And of course, in criminal negligence, there are a lot of CRPC, IPCs, and the consumer forums which can come into picture to take action against doctors. Next one. Now, this is all given in standard textbooks, the intelligence negligence. I would not want to discuss each of them, which I already stated in the previous slide. Next one. Now, what does the law expect from a physician? A physician is required to possess and exercise that degree of knowledge and skill, care, and judgment which other physicians possess working under similar conditions. Now, for example, if a patient is treated in a PHC for a chest pain, the law does not expect the PHC doctor to do an angiogram or angioplasty. If he can stabilize the patient and treat conservatively, provide adequate support and shift him to the next hospital, that is what is expected by a law. A doctor in a taluka hospital also is not expected to do an angiogram or angioplasty unless it is a big center. So there is something called as standard of care which differs from place to place and center to center and doctor to doctor. Next one. Yeah, I think go on. I think anything else below that? No. Now the standard of care, who decides? Please remember, it is not the judges, it's not the courts. The standard of care is decided by us. We, the medical fraternity, will decide because law is always guided by the doctors and healthcare workers. I just told you in the previous slide, Harley Street Standard cannot be equated with the ship engine. What is appropriate for a hospital or a center with equipment is equated, and that's what is the standard of care. Next one. I think I would not like to go much detail. I just want to say is we owe a duty and to exercise reasonable skill and care in detecting, to take up a case, in deciding what treatment to give and what to administer. These are all important elements for us. Next. Not only when a patient pays, but also when we treat freely or without any reward in emergency, we should exercise reasonable skill and care. Just because we are giving some advice to a doctor, to a driver or an attendant or a maid in the house without taking fees, still we are liable. Next. Now, please remember, we have no legal obligation to accept a case, but a moral duty to treat an emergency. We are not liable if we refuse to treat or assist in an emergency. But if assistance provided is deficient, patient suffers harm, doctor is negligent. Dear friends, while traveling in the train or aircraft, if somebody gets a chest pain and has a cardiac arrest, if we rush and try to help to do a cardiac massage, if the patient's ribs are broken because of our careless CPR and the patient dies, we are liable for contributing to the cause. If you do not know, do not treat. But if you treat, you must treat with adequate care and skill. Next one. Now, the burden of proof to show the doctor was wrong lies on the patient, and he must show that the doctor deviated from the standard of care, prove there's a connection between the damage and the act of the physician, and demonstrate the existence of wrong which has happened. Next. Now, when does the onus or burden of proof shift from patient to doctor? Next slide, please. It happens when we use the term re ipsa loquitur, that the thing speaks for itself. Normally, when a patient has to prove doctor is negligent, he takes the help of another physician. In such cases of re ipsa loquitur, there is no need of an expert because the presence of a scalpel or a scissor in the chest in X-ray is a proof by itself that there's no need for the patient to prove doctor is guilty, but the onus shifts on the doctor to do that. I can give an example. Sometimes at autopsy, we see swabs in the abdomen. Please do not jump to the conclusion that the treating doctor was negligent. Swabs are put in the abdomen in an emergency. If the bleeding is not stopping, they put pressure packs and close the abdomen and try to take up the case at a later stage. Now, in the middle, if the patient dies and is brought to the autopsy, please do not jump to the conclusion that the doctor negligently left swabs in the abdomen. It is not so. It could have been a part of the treatment. Next. Now, what is the dereliction? What is the explanation or examples? Failure to keep proper records, obtain consent, or failure to employ diagnostic and prophylactic procedures, or failure to remove instruments from body cavities, and failure to instruct the patient properly will amount to carelessness or breach or dereliction of duty. Next one. Now, I just wanted to explain to some of the younger students, if there are any, and the people who have forgotten forensic, the difference between damages, and the fine. Please remember, damages is not plural. Damage is the harm suffered. Damages is the penalty or the compensation which is given by a doctor to a patient. Damage and fine are two important things. Fine goes to the government when you negligently cause any harm to a patient through traffic, where you are taken to court for a criminal negligence, or under which circumstances this fine goes to the government. Now, warning and warning notice are two important elements that very often we confuse. Warning notice is a list of do's and don'ts which a doctor should follow, which is mentioned in most of the textbooks. Whereas warning is given by the medical council for misbehavior. So please remember, these terms should be clear for you. Next, please. Now, damage or the harm suffered by the patient includes surgery on a wrong part of the body, leaving foreign objects in the abdomen, infant discharge to wrong person, hemolytic reactions, incompatible blood. These are some just examples to tell you what is a harm which a patient could suffer. Next. And why punishment? Because compensatory punishment and punitive punishment. Compensatory is for the pain or the suffering or the financial loss, lost wages, and loss of earning power. Compensation is given to the patient. Punitive because punishing and deterring an erring doctor for reckless conduct will keep others on their toes from doing wrong. Next slide, please. Now, damages or the compensation includes actual costs incurred, compensation for injury, loss of earning capacity, loss for prolonged stay in the hospital, and decreased ability to enjoy life, sleep, disturbances, or sexual dysfunction. So these are the various harms. Now, when does a doctor-patient relationship break? When the patient does not follow the advice of a doctor, or when a patient consults another doctor and the patient does not go back, please. Yeah, patient does not reveal fully, or the patient is malingering or pretending. Under these circumstances, the doctor-patient relationship breaks and the doctor is not liable for any action which the patient tries to bring against us. Next, please. Next slide. Yeah. Now, what are the remedial measures and options for the patient? He may approach the medical council for disciplinary action, criminal court for imprisonment and fine, civil court for compensation, and also consumer forums for compensation. Next. Next. Aarti, can you hear me? Can you hear me? Yeah. Criminal negligence is booked under 304A. Death by rash act not amounting to culpable homicide. The maximum punishment is 2 years with fine or both. If the patient is alive, doctor can be charged in section IPC 337 or 338. Next slide. Next. Yeah, what happened if a patient dies? I think they already mentioned about it. Doctor may be arrested if police believes that would not be available. Otherwise, it's available from the police station itself. Please remember, we need not worry about these things now. Doctors will not be arrested straight away because the law has modified itself to protect us. So let's not fear about this. Next slide. Next slide. I think civil courts are the other options where you have fees and lawyers' fees and procedural formalities for a long time. Limitation period is 3 years, and any amount of monetary compensation can be given. Next. Next slide. I think I would like to quote my former Vice Chancellor vmrf, who said, "We have taken medicine to the marketplace, so market forces are working on them. Healthcare has become a commodity, hence the patient has become the customer and sues the doctor or the hospital if he is not satisfied with the service." So from the holistic care, we have gone up. It's time for us to wake up. Please move on. Yeah, please remember, consent is an important element. Sex or rape, the difference is consent. Treatment or battery, the difference is consent. So it's important for us to keep consent as an important element. Bernard Knight, this is one important statement I would like to share. Dear friends, all of us following medical legal work should remember what the doctor puts into his report at the time of examination must be of sufficient resilience to survive intense cross-examination in the courtroom, which months or years later. Very often the cases will come 6 months, 1 year, 2 years. In fact, I've gone to Manipal a few months back for a case which happened 10 years back. So what will help me is my documentation properly. So please remember, please document properly. That's the most important thing, and it is the only remedy and safeguarding your future when things can go wrong. Next slide. Now, Justice, I would like to quote Justice Markandeya, unless there is a prima facie evidence indicating medical negligence, notice either to a doctor or hospital cannot be issued. There cannot be an assumption that doctors cannot be negligent while rendering care and treatment. Next one. Move on. Next, I think there are, yeah. A surgeon with shaky hands, fear of action, cannot perform a successful operation, and a querying physician cannot administer medicine to his patient. If the hands be trembling with the dangling fear of facing a criminal prosecution, in the event of failure for whatever reason, whether attributable to himself or not, neither a surgeon can successfully wield his life-saving scalpel to perform an essential surgery, nor can a physician successfully administer the life-saving dose of medicine. Next slide, please. This was Chief Justice Lahoti. Please remember, two important things for us. Try to speak less and hear more. What I'm trying to depict here is open your mind and hearing and keep a little bit of plaster on us, because we should talk less and allow the patient to speak. Then please listen and understand. Next one. Yeah, I think please few more. Yeah. I just would like to state, no doctor intends to convert a scalpel into a dagger, nor does a patient comes with a weapon to trouble doctors. Communication and care will establish trust and goodwill with our patient. One more, I think, are things. Yeah. Let's resolve to provide a trouble-free healthcare to our patients. Next one. Thank you, dear friends. I would like to conclude my session. Aarti.
Thank you, sir. Dr. Zakaria, sir, you're there?
Thank you, sir, for the excellent presentation, elucidating each and every point, highlighting every point, and the importance of communication, documentation. And we have one or two queries in the chat box, sir. Would you please like to answer one query from Dr. Anil Agarwal, sir?
Anil, unmute, Anil.
Agarwal, sir, you have to unmute yourself, sir. There's a button.
The question was why Ayurvedic and homeopathic doctors are negligence against, they are not coming up. That was the essence of that question. And the IMH versus VP Shanda case.
No, I'm sorry to be asking that question, because I forgot that no questions can be asked.
Anil,
sorry.
You want to make a statement, Anil? Please go ahead. My dear good friend.
No, Pradeep. I enjoyed this thing, but I forgot to ask that no questions can be asked in keynote. So I actually deleted my questions. So let us forget about it. And because since I'm your personal friend, I will ask you later.
Okay, sir.
Okay,
sir.
thank you.
So one thing regarding documentation, poor record is poor defense, and no record is no defense. That's the point which is to be highlighted. Poor record is poor defense, and no record is no defense. But see less patients and spend time for more documentation and for obtaining informed consent. And if you uphold the basic principles of bioethics like justice, autonomy, beneficence, and non-maleficence, much of the negligence against doctors or medical professionals can be avoided to some extent, sir. So any queries from the participants?
Sir, no queries, sir.
So thank you, sir. Pradeep Kumar, sir, for the excellent presentation. So see you, sir, in future also. Thank you very much.
Thank you.
Thank you, sir. Thank you, Dr. Zakaria, and thank you, Dr. Pradeep. And Dr. Pradeep, please do visit our institution whenever you come to Pondicherry. We would really like that because sir has said so high about you, and for workshop, I really wanted you to be there, but then you're in.
My apologies. I had to travel to New Zealand.
Yes,
and come back and join. I'm just 1 week old in this infant medical school. The first baby is yet to be delivered, and I'm nurturing the pregnancy of Tata Manipal Medical College here.
Sir, and I'm sure you will get through it with a safe and a good outcome also. Thank you, sir.
Thank you.
Thank you.
And once again, thank the organizers and especially Pradeep Kumar, sir, for chairing your session. I take it as a privilege, sir. Thank you very much.
Thank you, Professor Zakaria.
Thank you very much.
Thank you.
Thank you all. Thanks to the delegates too and the resource persons. We will now take a quick 5 minutes break, and at 11:20 we will join in for our next session by Dr. Anil Agarwal. He's my professor, and I'm, sir, so excited to hear from you after nearly 5 years now. I sit in all your classes, but now after 5 years. Yes, so we'll take a 5 minutes break and we will join at 11:20. Thank you.
Hello. Hello. Hello.
Yes, sir.
Audible, madam?
Yes, sir, you're audible. Sir, but some echo is there. Can that be corrected?
Is it now correct?
Yeah, now it's good. Well and good, sir.
Okay, madam. Thank you.
Thank you.
Good morning, everyone. It is indeed great pleasure and privilege for sharing this session with my idol and one of the pioneers. Okay.
Welcome back, everyone. I hope everyone is re energized. Again, Kindly keep your mic mute, and any doubt or queries, kindly put it in the chat box, which will be addressed later. Now, I would like to call Dr. Srinivasan, Professor and HOD Forensic Medicine, Chettinad Hospital and Research Institute, Chennai, to introduce our next speaker, Dr. Anil Agrawal. Over to you, sir.
Thank you, madam. Good morning, respected senior professors, faculties, and all participants of this conference. It is indeed great pleasure and the privilege for sharing the session with my idol and one of the pioneers in the subject of forensic medicine in India. Namaskar, sir. I thank Dr. Aarti Madam for providing me this wonderful opportunity for sharing the session with the sir, and happy to know that you are also the student of the great sir. We are really fortunate for that. I think most of the participants are also still the students of him. To say a few words about Dr. Anil Agrawal, sir. He has completed his MBBS from Delhi University in the year 1977 with the honor of securing university first rank in the subject of forensic medicine and toxicology, the exam conducted during the year 1976. So he is the university gold medalist in the UG period itself in the subject. Then he has completed his MD forensic medicine in the year 1982 from prestigious All India Institute of Medical Sciences, Delhi. Then he proceeded for a higher training at Edinburgh, considered as a hometown of forensic medicine. Then he was further trained in the countries like Japan and the USA under prestigious WHO fellowship. Dr. Anil Agrawal is the former director, professor of forensic medicine in the prestigious Maulana Azad Medical College in New Delhi. He is the founder and editor-in-chief of popular Anil Agrawal's Internet Journal of Forensic Medicine and Toxicology. He is a member of an editorial panel in the various international journals also. He has published more than 50 research articles in the various national and international journals of good repute. He has written more than 20 books in the subject of forensic medicine and toxicology, including popular ones like Forensic Medicine and Toxicology for MBBS. The book I am almost reading daily, at least for 1 hour, for past 4 to 5 years. Then other popular books being Textbook of Forensic Medicine and Toxicology, Injuries, Forensic and Medical Legal Aspects, and his recent book on toxicology being a comprehensive work titled Clinical and Forensic Toxicology, which is published in 2 volumes. Sir is going to talk about today about defensive medicine, waiting room to courtroom. Defensive medicine means ordering every test or X-ray on a patient to have a good background of hard data and avoiding using a potentially risky treatment, which may offer much benefit to the patient. That is withholding good treatment due to some statistical risk to the minority of patients, affecting majority of patients. Thank you very much, madam, and I call over to you, sir.
Thank you, Dr. Srinivasan, for this introduction. I had a good time talking to you yesterday. And if I can give a very short introduction to you, you run a YouTube channel. And I saw some videos which are really very, very good. So probably you may want to share that link in the chat box. I never knew about that. So that's very short introduction to you. Actually, I like short introductions. All right. So now, what we are going to talk about today is defensive medicine. And as Dr. Srinivasan has very rightly said in his introduction, that defensive medicine is actually prescribing of too many tests for simple, diseases. Good example that I can give you, and which I have seen many doctors doing, is that a patient comes to you for simple headache, and you prescribe some kind of MRI or CT or whatever. Now, there are two ways of looking at it. There's one way is that you are prescribing unnecessary tests so that you can probably earn some more money. I mean, I don't know what is correct because I've never done that. But another way people see it, especially doctors who prescribe it, that they are engaging in something which has come to be known as defensive medicine. Now, their sole, excuse for this extra or unnecessary tests is because I asked one or two people, now, why do you prescribe CT or MRI? Because a tumor, head tumor, is found in around 1 in a million patients with headache. So you have got a 1 in a million chance that you will discover a tumor. And the answer is that I do not want to take that chance because the compensations are very high, as we learned in the previous session when Dr. Kunal Saha, he was awarded almost 6 or 7 crore rupees. Now imagine a person giving this much compensation to a patient. Now, of course, many doctors are insured by professional medical indemnity and all those things. Now, if they're insured, sometimes there's a cap on what they can be reimbursed with. But if there's no cap, the insurance companies will actually have to give, and insurance companies will naturally raise their premiums. Now, this has happened to some extent in India, but it has happened to a very great extent in the US. I was in the US, I was recently returned. I was there for 6 months with my son, and I had a lot of, good interaction to talk to many doctors, all of whom were former MAMC students, and they are very successful doctors in US now. They told me that, medical insurance is so high in some parts of US and for some specialties. For example, a neurosurgeon will have to pay much more, premium than a radiologist, because neurosurgeon will be charged for, will be sued for far more than a radiologist can. So they say that many doctors are actually leaving practice. They don't want to be in the practice anymore. And with the result that there are lesser, doctors which are available, which actually is compounding the problem of the patients. So we have got a very strange problem here. On one hand, we have, high compensations as we had in Kunal Saha's judgment, presumably to help patients. But for the very same reason, doctors are leaving the practice. They call it medical malpractice crisis. They call it medical malpractice crisis. That is, people are leaving practice. Fortunately, this has not occurred in India, but it may occur. So, the situation is this. It's very interesting because, in VP Shanta's case, as I wrote in the chat box, very interestingly, when the lawmakers made this Consumer Protection Act in 1986, they never wanted doctors to be seen as a trader. Because please remember, consumer protection is meant only for traders and consumers. And by no stretch of imagination, a doctor can be seen as a trader when he accepts money. And I'll tell you why. Because, let us, for example, talk about dichotomy. Now, what is dichotomy? When a doctor prescribes a test to another, he asks the patients to go to another doctor and get an X-ray done or get a CT done or whatever, and then later he takes money from him. It's dichotomy. Now, do you know this fact that if you take this same complaint, let us imagine that he takes this money by check, and it is, yes, somebody's asking something.
Sir, go ahead, sir. Go ahead.
All right. So, he is taking money by check. And let us say somehow it can be proved that he took money for recommending that patient to the CT. If you go with this evidence to the police, there is absolutely no, IPC section under which he can be sued. There is no law against which this sharing of profits can be sued. As a matter of fact, this thing is prevalent in our society. I mean, very, very commonly. Let us talk about, let us say,
before you came, it's to be known.
All right. I'm hearing some sounds. I mean, is it, all right. So now the problem is that, this sharing I was talking, for example, let us say a seller of, let us say, textbooks. What does the publisher say the bookseller? And I know this because I have written books. He says, whenever a person asks to come for a forensic medicine book, you give him this book and say that this is the best book. If you do this, I'll give you so much cut. And this is a very well-known thing, and it is actually converted into medical profession. It is dichotomy. Now, please take this case to police station that this publisher is doing dichotomy with this bookseller. Nobody will listen to you because there is no law against it. Despite that fact, and even, till now, even as we are speaking, if a doctor is caught of dichotomy, he can neither be fined under any civil law, nor he can be jailed under any criminal law. Only his name can be, removed by the National Medical Commission. So it's actually an ethical blunder. And why an ethical blunder when he's a trader? He can do anything like a trader. After all, when a manufacturer of medicines tells the shopkeeper, that is chemist, if somebody comes with beta blockers, you give him mine, because it's a generic medicine, you just give him mine, and he does that, and he gets this thing. But if a doctor, for example, from the same manufacturer gets a ticket for a foreign conference, now please remember, he is not taking ticket for his personal Sair Sapata or whatever. He is taking it for attending a conference so that he can increase his knowledge regarding heart disease, of which he is a doctor. And he has got proof of that. He is showing you attendance certificate, he is speaking a lecture, anything. So there's absolutely no hampy about it. Yet the doctor will be sued. And again, for the very same fact, he cannot be jailed, no civil compensation. So the fact is that this NMC, we already have National Medical Commission sitting over us. In my time, it was Medical Council of India, who believe that we are not traders. We should not engage into trader-like practices. We are above than traders, we are like Devta, angels. So when we are dealing with or we cannot have even boards, advertise. We cannot advertise while a trader can advertise. We cannot have huge boards. And the list of this, we cannot have touts, soliciting patients. All these things are not written in IPC at all. You can take it from me or you can check IPC yourself. Yet the doctor is sued. So basically, the doctor is being hacked with a double-edged sword. When it comes to this trading practices, he is not a trader because he's an angel. But when it comes to Consumer Protection Act, then he's a trader. And now you have to pay. So I actually believe, it's my personal belief and it's not written anywhere, so you are free not to admit to it. But it's my personal belief that the 1995 VP Shanta's judgment till 1986, when this Consumer Protection Act was, made, from that period till 1995, doctors were spared of this. but in its wisdom, and we cannot criticize a court's judgment, the Supreme Court said that doctors are included in it, and this Kunal Saha case came after that. Now you look at a history of this defensive medicine, because I have been in medicine since 1970s, early 70s. This defensive medicine word we had never heard of. I had never heard of this defensive medicine. Thus, this defensive medicine actually took birth after this judgment. If previously anybody was doing it, he was cheating the patients, and for that he can be, charged under Section 420 IPC. There is an ample, because for example, he has got a pain in the leg, and you are prescribing, MRI of the head. Now this is cheating. So for that, there is ample provision even in the IPC. So, if that was being done before judgment, surely he should be prosecuted and under the proper acts, proper laws. But when, there's a case of headache and he has got a 1 in a million. Now, suppose I say that you are doing something for which there's 1 in a million probability that you will be paying 7 crores. But if you do the other way, there's 0 probability. So I think everybody will say, let me do the CT. Why should I take even 1 in a million probability for 7 crores? So that's what they're doing. So this is prime, I think, problem as far as I think, and this is completely my personal opinion, is the inclusion of doctors in the Medical Protection Act. And now please see the irony. What is the irony? The irony is that if you read the judgment of that VP Shanta's judgment, I have read it word by word. The reasoning of Supreme Court was that we want to protect the patients against erring doctors. And what a better way to do this than to include doctors in this Consumer Protection Act. But precisely that medicine that they gave to the patients increased their problems, because now they have to go to and they have to spend more. And so sometimes I remember Ghalib's couplet, which he wrote in 19th century. दर्द मरीज पे रहमत कर खुदा, दर्द बढ़ता गया जीजू दवा की. My disease went on increasing as I took on more and more medicines. So, one of the causes of defensive medicine is excessive laws, which I think are not needed. What happened in earlier times? There was a thing called paternalism. We heard about it in the last this lecture, and patient autonomy is the key thing here. Now, of course, I'm not an advocate of paternalism. And to give you a simple example of paternalism, in the 16th or 17th century, if somebody had an osteosarcoma of the femur and required an amputation of, let us say, one leg, and the patient said no, then the doctor would still cut it for the benefit of the patient, because he thinks I'm your father. Actually, paternalism comes from the word pater. Pater means father, from which you also get words like paternity suits or paternity determination, things like that. So he acts like a father. Now, there has been a rise of ethical thinking in the foreign countries, and they have said now patient is the boss. And now, anybody who dislikes paternalism, can anybody tell me a single case under paternalism in which the doctor did anything wrong to the patient? Really, I don't know of any case in which, certainly I don't know, and I would love to know in which, because of paternalism, he cut a wrong leg, or he cut a leg of an enemy, or he cut a leg of a religion he doesn't like, or something like that. No, there's instances are unknown, or maybe one or two. So the reason is that there was a lot of trust between doctors and patients, a lot of trust. With more and more this patient autonomy, this and that, I think a lot of trust has gone. I'm not favoring paternalism by any means, because then you might label me as a 16th century man or whatever. But we have to think what has happened that you heard of absolutely no, medical negligence cases in 16th to 19th century? Never heard. I mean, I have gone through history of negligence. Go through history of negligence. You won't find any this thing. Until, I was an intern in 1978. During internship, I did some mistakes, serious mistakes. And you won't believe, those of you who belong to the new generations, the patients still touched my feet. And they said, Doctor, aapne bahut kiya. You did a lot for us. So, I mean, that is the time I have seen myself. And now I have seen time when in my mortuary, I was doing a case where somebody died because of doctor's negligence, not our negligence. And she was a nurse actually, and she was admitted in our own hospital, GB Pant Hospital, for 15 days. And there was some delay in autopsy, and that too not because of our fault, but because we hadn't received the papers. And these relatives, they broke all the windows of the mortuary, all the windows of the mortuary. And my attendant said, Doctor, just hide somewhere, otherwise they're going to beat you. I said, let me talk to these people. I went outside and said, what is our mistake? We are just waiting for papers. I sympathize with you. And he said, Doctor, they said it in Hindi, but I'll translate you in English, because many of you probably are not conversant with Hindi. They said, Doctor, for 15 days, we people have been folding hands before you. Now our patient is dead. So now we are going to kill you. So what happened is, till their patient was alive, they were folding their hands, because the patients can be, let us not pick up a fight with doctors. But now they can pick up a fight. But with whom? Who had absolutely no role in treatment. So this violence is sometimes misdirected. And I'm not saying all the time it is on forensic people. Most of the time it is on the treating doctors, but violence against doctors is also cited as a reason for defensive medicine, and I agree with that. Now, what are the solutions we have? Ultimately, there's no problem in, there's no issue in, discussing the causes. Causes, I told you, the root cause, according to me, is inclusion of doctors in all kinds of laws. These inclusion of doctors in all kinds of laws have actually increased the distrust between patient and doctor, and a lack of distrust. And that's one of the main reasons. The solutions, now, the one that comes to my mind, now, Arti, do tell me when my time is over, because I just don't know how much time I've taken. Now, the solution that comes to my mind, and they're completely, again, my solutions, and they may be wrong because they have not been tried. Exclude the doctors from all these laws, all these laws. And then patient, I was talking to someone, and he said we should have a law where the patient can't sue you. I said, look here, you give more medicines and the disease will increase. Mars badhta gaya jo dawa ki. The mistake is in giving more medicines. The solution is in removing some medicines which are already been injected in the system. And one of them is excessive laws. Now they say that let there be a law against violence, patient violence against doctors. Now we do have some laws also in some states. Now why you should see, first thing is, the moment you have such laws, patient immediately thinks, oh my God, I'm the only one who is punished. So anybody can do violence to anybody. He's not punished, but if a patient does violence to doctor, he is punished. So I'm the one who is on the receiving side. So why not sue this doctor? So from the waiting room, he comes to the courtroom, as our organizers have given the topic. Now, all those people who are in the favor of these violence against doctors, Suppose we don't have any law specific law for patient doctor. Can't these patients still be prosecuted? Violence against anybody is bad. So you just strengthen and implement your own laws. You know, I just don't see the need, any need whatsoever for specific laws for patients, specific laws for doctors. The present laws, as I told you, in cutting a wrong leg, whatever, you or prescribing a wrong test, I mean, a test which is patently not needed. And let me tell you, once these laws are not there, doctor will himself not prescribe this CT scan for why will he prescribe? Because he knows that nothing is going to happen to him, and there's more trust. He will, now, for example, now the same doctor, suppose his father gets a headache, is he going to have a CT? Probably not. Probably for 10 days or 15 days, he will give some kind of an analgesic, and after 15 days, if the pain persists, then only he will do it. But for a newcomer, he will immediately do it. Why? Because he is afraid. So one thing is you remove some of the medicines which you have already injected in the system. Now, two very new things that have come, and they have been tried in some countries. One is what they call, and this should be interesting because they have been tried. I'm not saying that they've been tried in all countries, but they've been tried in many countries. One is so-called apology and disclosure laws. Now, this is a very interesting law. In this law, suppose a doctor has committed a mistake. Now, before the mistake is even discovered, he goes to the patient and apologizes to him. Look here, I have done some mistake. There are going to be some repercussions of it, but I am there to rectify them. And I apologize for this mistake. Now, in current scenario, absolutely no one will do it. Why? Because his own statement will be taken as an admission of guilt, and he will actually be sued more. But in this apology and disclosure laws, if a doctor does that, first of all, this statement will not be, and if the patient wants to sue him still, first of all, this statement will not be taken into any court proceedings, number one. And number two, if he has already apologized and disclosed the mistake, the punishment is very less. So this is a good law for treating this disease that we call defensive medicine. Another thing, and I'll leave some time for questions, because I love questions more than my talk itself. What we call exculpatory contracts. Now, exculpatory contracts, before this word, bogs you down, it comes from the word culpa. Culpa means blame. From the same word, we also get culpable homicide or culpability or things like that. So exculpatory contracts means X means away. So you put the blame away from the doctor. So there's a kind of a contract. Again, it has been tried in very few countries, where a patient signs up an exculpatory contract with the doctor, where he indemnifies him. He says, whatever happens to me, I'm not going to sue you. When this kind of a contract is there, then they say that they feel that the environment is far better for the doctor to work. So these are the 2 or 3 solutions that I can offer. Number one, take these laws out of the back of the doctors. Exculpatory contracts and apology and disclosure laws. They are new things, but something we need to think about. Thank you very much.
Thank you very much, sir. Thank you very much, sir, for your wonderful and enriching talk.
Somebody has asked some questions, so let me answer these questions.
Yeah.
Actually, sir, for ethical issues, no question of suing. Then I don't understand this question. If you can tell me the question in detail. And actually, sir, my question is vice versa. Can native medicine doctor? Oh, this is the previous question. So no question in my talk. So anybody, if you want to take quite good, I'll be too happy to answer. Anybody? And maybe you don't agree with some of my ideas and something.
Sir, I think question is for you only, sir.
Yes,
Dr.
yes.
Mohammed Anis has asked, can native medicine doctors prescribe OTC drugs?
No. It was the previous, because Dr. Pradeep, I think, said in one slide that homeopathic medicines and allopathic medicines doctors cannot be sued, and that was news to me. I put that question actually, but I removed it. Actually, one person, I thanked him also. He posted a very good, the link which takes us to a homeopathic doctor being sued. So I think it is. Otherwise, Mr. Mohammed Anis can speak if he were, because this. I mean, I have said nothing regarding OTC drugs or whatever. Or maybe Dr. Anis would like to clarify whether he wants to ask me. It doesn't look like my question at all.
Sir,
But
actually, nowadays, good afternoon, sir. This is Dr. Anis.
Good afternoon.
In current generation, I see many homeopathy doctors and Siddha doctors prescribing allopathic medicine. Is
There
that
is
allowed?
no, it is not allowed. I mean, I am forgetting that judgment. There is one specific judgment. I'll give you some details, and if you can Google it, you'll get it. There was a homeopathic doctor who gave, chloramphenicol for typhoid, and he was an homeopathic doctor. And chloramphenicol is an accepted drug in typhoid. He gave that, and somehow the patient died. Now his case went to Supreme Court. Supreme Court made a panel of 5 doctors from All India Institute asking whether this was a correct treatment, and the 5 panel doctors said yes, it is a correct treatment. Even we would have given this. So yet this person was prosecuted. I mean, if you write these facts somewhere in the Google, you'll get the correct.
Yeah. So the judgment is actually Mukhtar Chand versus State of Punjab, which went to the Supreme Court. Yes, so the same case that you're saying.
Which one? Mukhtar.
Mukhtar Chand versus State of Punjab.
All right. So maybe I've completely forgotten because I had something else in my mind. But anyway,
same case, sir.
Same. All right. So I mean, and the problem, what was the argument of the Supreme Court? That since you are not allowed to prescribe other medicines, you can't do that. Now after that, there was a repercussions from Ayurvedic doctors also, because allopathic doctors are prescribing actually Tentex Forte or Spearman Forte or some kind of health tonics, which are actually in the Ayurvedic pharmacopoeia. They are not in our pharmacopoeia, but they are prescribing that. So there was a lot of argument. I attended some talks where they were saying that even we can sue you, but I am not aware of any such case where a allopathic doctor was sued for prescribing a homeopathic medicine. Of course, he cannot because he does not know much about it, but Ayurvedic, because some Ayurvedic tonics are there. So, I mean, and again, I would believe that let us not jump to another system when our own system is helping very well. Thank you. Any other question? Because
Kalyani ask.
Sorry.
Sir, one more question we have, Dr. Kalyani. Yeah.
Now there's one. Yes, I can see some questions. Let me. One question has been asked by Dell. So there are many cases on FIR is not immediately not taken by police in case of violence, and sometimes doctors strike. No, I'll tell you why they don't take, because the police is not doing their job, and why they're not doing their job, because these people with the patient side, they are actually very well connected. I have myself received phone calls from politicians and state president of such and such party and that party, and I'm sure they are threatening the police people also not to register cases. So this is, look here, let us imagine that this is a fact. I know this is a fact, that these people are actually well connected. So is a law against doctors, patient violence, doctors, are they going to register FIR then? No, they are not still. Probably you can have a law for police people. Now, let us say what is there in rape law. In rape law, there is a specific law, and that shows that legislature has done it. They only lack the will to do it. In rape law, there's a provision that if a police officer does not register an FIR on the request of a rape victim, then that police officer can be put to jail behind the bars for 2 years. There's a specific law. Why can't we have the same law against this violence? Not for doctor-patient violence, against any violence, or for that matter, against any crime. There should be a law. I have myself gone to register so many complaints, FIR, in our own police station, in LNJP Chowki. They will not review this. Doctor Sahab, एक केस आ जाएगा, investigate करना पड़ेगा, ये है वो है, इसको ऐसे बना लो, वैसे बना लो. They are not interested. So these people are actually afraid. That is the reason. There is absolutely no other reason. Now, another good question that has come is, so are you satisfied, Del? If you are not satisfied, I can take counter questions from you. Del, are you happy with this? All right. Now, can disclosure of medical mistakes actually help doctor in judicial? Not to my knowledge, it helps the doctors in so much as he will have if sued, he will have a very minor punishment, something like treating somebody with kid gloves or things like that. So, but I am a great believer in admission of mistakes. I'm a very great believer in this, because it shows that really you are an angel. Now imagine taking a God to the court when he has not fulfilled your wishes. Can anybody do that? So you cannot take God to the court when he has not fulfilled. But if a doctor who is a God, you can take him to the court at the, so you don't believe that he is a God. You're simply saying it for a cosmetic sake. So let us be gods, real gods, and real gods are going to admit their mistakes. Now, so
sir.
Yes, please.
Yes, sir. Sorry to interrupt, sir.
No, please.
Yes, sir.
I like interruptions actually. Yes.
Yeah. Thank you, sir. I am Dr. James. I am an associate professor in CMC Vellore. So I would like to thank you for the wonderful presentation. I'd like to ask a few questions and clarify one of the.
Ask me as many as possible. Aarti must allow.
Yes, sir.
She knows I love questions.
Yes, sir. Thank you, sir. So the regarding question by Dr. Arpan Kumar, can disclosure of medical mistakes actually help doctor in judicial proceeding? We have a Supreme Court judgment, if I may quote, that Lakshman Balakrishna Joshi versus Trimbak Babu, that the doctor has sent written an apologetic letter, and the Supreme Court has considered that apologetic letter as evidence of guilt, and then convicted the doctor.
I have heard about that case, but this particular fact I'm not remembering right now, but I would not be surprised. No, it's all right. I'm not contesting that thing. And I can actually believe that this happened. Now, this is one reason the doctors are not going to. That's exactly what I'm saying.
Yes, sir.
In some US states, I mean, if you Google this, you don't have to do anything. Just Google it. Apology laws and disclosure laws. In some states where you apologize, your statement cannot be used in a court of law. That is the thing. And number two, even if you get sued, ultimately, you will be sued for very less, if only for your honesty, that you honestly admit it. Now, imagine how nice this law is, because the law is giving you such a long rope that you admit your loss, you admit your mistake, and then you are free. So doctors will be encouraged to admit, and the patient also believes that you are actually God. Now, when hiding your mistakes, no God hides his mistakes from anybody. So this must have happened in that case. I'm not contesting that, although I admit that I don't know of this fact right now, although I've heard of that case.
Yes, sir. Just a clarification, sir. This was happened in 1968. So we are also evolving as a country. So I think we can come up with, maybe the legislators, if they think about this in the long term, they may come up with some reformation, and then we might.
My dear James, the problem is we believe in more medicines. We do not believe in withdrawing medicines. इसीलिए मैं कहता हूं, गालिब का शेर मुझे याद आता है कि दर्द बढ़ता गया ज्यों-ज्यों दवा की. I mean, हिंदी वाले इसको सुन के बड़े अच्छे खुश होंगे. My disease went on increasing as I took more and more medicines. This is what we are doing. This does not help. Sometimes taking away the medicines also helps. So you don't have to explain why you asked. This is a good question. I salute you for that. This should have been asked because it clarifies where we are wrong. Any further rejoinders to this? I would love.
Yes, sir. One more query, sir, which I'm not sure whether it's particular to this, but I would like to clarify from you.
Please do, please
This
do,
is regarding gossipy boma. If at all a hospital is retrieving a gauze piece, by whatever reason they found it in a patient during the surgery, and then if they are retrieving it, at that point of time, they don't, the patient has not filed any complaint, either criminal or civil case against whosoever X or Y hospital, but we suspected gossipoma and we retrieved the gauze piece during the surgery. So what is that retrieved gauze piece? What is the role of doctors or the hospital who has retrieved this gauze piece? Should they, how long should, if at all they need to store it, how long should they, because they don't know whether the patient is going to file a case or not. Even if they file a case, the doctors, they entitled to store it for indefinitely, because even though the limitation period is 2 years, they may file a case later and the continuation of delay can be, happen in the court of law.
First of all, I'll clarify the limitation period is 2 years, not from the operation or it is from the discovery of the, mistake.
Yes, so, sir, the cause of action, when it is revealed, then from that time, the 2 years starts.
But gossipoma, because I am not a medical expert, but if I understand it correctly, it is if the patient is ingesting something, maybe bandages or whatever, so they can actually form a concretion inside your stomach, which is called gossipoma. But if you're talking of gossipoma in the abdominal cavity, are you talking about the abdominal cavity gossipoma or something which you find in the stomach? Because in the stomachs, we have received trichobezoars and other kinds of omas because they are compulsive eaters. So
no,
where,
sir, not the,
what exactly
not the compulsive eaters. I am talking about the later one, which you said that during the surgery, some retrieved gauze piece, which was held up during the previous surgery.
Yeah, then of course, because if it is discovered, let us say today, so the doctor, the patient has 2 years from today, and this limitation period is for a very good reason, because you cannot keep a doctor in suspense forever. So you have to give him some kind of freedom. So for 2 years, if he wants, he can do it. And I mean, and the worst thing is that the doctor has not admitted it. Probably he himself doesn't know about it. Now, the problem here is, let us say he has had 5-6 surgeries before, then it will be more or less a forensic problem as to which, surgery this gossipoma has originated from. And then they'll be, everybody is going to say, look here, this is not my case or my case. So this is, and as I'm talking to you, I'm thinking, suppose such a case comes to me, then how am I going to find it out? Probably I don't have any good way to discover it. However, if he has had only one surgery in the last 20 years, then definitely this is a very, very good evidence. And you said that how long it should be preserved. My belief, not belief, it's actually is a fact that as soon as you recover any evidence from this thing, immediately hand it over to the police. You have to report to the police and immediately hand it. Once a surgeon phoned me from somewhere in UP, I'm forgetting, probably Kanpur, and he said, sir, ye bullets kitne din tak raha? For how long we have to preserve these bullets? I said, which bullets are you talking about? He said, sir, the bullets which we have retrieved from these homicide victims or accident victims or whatever. So I said, don't you hand over immediately? No, we don't know. And now we have got bullets collected for the last 10 years, 15 years. Now we have got so many bullets with us. I mean, I was so amused to listen to this. And these very people, when you ask them to attend your lectures, they will say, sir, हमें क्या पढ़ना है? Forensic में तो एक ही question आता है और ये वो. They will not read forensic medicine, and this is some problem with us also. We will tell them about rigor mortis, we'll talk them about adipose here, but we'll hardly tell them about medical jurisprudence, that is laws, which will interest the people. And even if you're talking about rigor mortis, let it be connected to the clinical things. That is, look here, if a dead patient comes to you and you find that there is no, I mean, there was a case which was coming to me from somewhere from Agra. And when he came to me, I found that he's dead. I mean, the casualty people. They called me because they wanted to know how long has he been dead. Now, this is, of course, a question which he did not answer, but when we can answer, why not? Then I went there, he called me, I went there, and I by some rigor or something, I could say he's been dead for about 3 hours. So that means he was probably, when he started, a little bit after that, he was dead. Now, this makes some sense to people who are listening to your lectures and who know for sure that they're not going to be forensic specialists. You know why people don't listen to our lectures? As Aarti will tell you, I never used to take any attendance in my class, because if I take attendance in the class, then I'm actually armed to sting them. So I said there'll be no attendance in my class, and yet, I mean, I never found anyone missing there. So this is a good question that you have asked about gossipomoma. This is my answer to that.
Sorry for interrupting, sir.
Yes, yes.
It's a time to conclude.
I knew, because
Thanks,
Dr. James, I was looking at Aarti and she was very uncomfortable. So I knew about it. So
thank you.
The moment I started enjoying, you stopped it. So you are guilty of that.
Yeah. Maybe we have class at additional 5 minutes.
Right.
Thank you, sir.
Yeah.
Thank you, Anil sir, for the clarification.
Thank you. God bless.
Thank you very much, sir.
There are two new messages. I will answer them. I'll answer. I'll answer them. I'll answer them by chat only. So those of you who has asked me via chat box, don't worry. I'll be answering in the chat box itself, so that your questions are not left unanswered, and I don't rob anybody of his time also. Thank you very much, and God bless.
Thank you very much, sir, for your enriching lecture on these various topics, including this defensive medicine, dichotomy, paternalism, apology and disclosure law, explanatory contacts, etc. Thank you very much, sir. Thank you, Aarti madam, for providing me this honor. Thank you for the participants for putting many interesting questions also. Thank you, sir.
Thank you so much, sir. Let's carry on this energetic spirit forward. Coming up next, now I would like to call Dr. Sanjay Kumar, Professor, Forensic Medicine and Toxicology, Vardhaman Mahavir Medical College and Hospital, to introduce our next speaker.
Okay. Am I audible? Hello?
Yes, sir, loud and clear.
Yes, okay. Okay, very good afternoon to all the participants. I am here to introduce I'm very privileged to got the opportunity as a chairperson. Dr. Vikansu Verma is currently working as an associate consultant at Emergency and Trauma Center, Medanta, Gurgaon. He has completed his MBBS from JLN Medical College, Ajmer in 2004, and he is a postgraduate in forensic medicine and toxicology from SMS Medical College, Jaipur. And Dr. Verma is the youngest Indian doctor to get fellowship in toxicology from the Indian Society of Toxicology in 2019. He introduced the Indian Society of Toxicology Life Support course, and he's also an honorary toxicology expert with the Central Bureau of Investigation. There are lots of achievements in the name of Dr. Verma. He's as I've told, he's the first forensic professional to be awarded fellowship in the toxicology in India. He's the first forensic postgraduate to get fellowship in toxicology in India. He is first DFM, that is Diploma in Forensic Medicine holder, to get fellowship in toxicology. He is the youngest Indian doctor to get fellowship in Indian Society of Toxicology. He is the youngest medical professional among the 5 awardees, all over 50 years, to get fellowship by Indian Society of Toxicology. He is the first and only North Indian doctor among all 5 to get fellowship in Indian Society of Toxicology. He is the first doctor from Rajasthan to get fellowship in toxicology, and he is the only forensic expert among the 5 awardees to get fellowship by Indian Society of Toxicology. He had ranked first in PG Foundation program at SMS Jaipur, SMS Medical College, Jaipur in 2009, and ranked first in RUHS, that is Rajasthan University of Health Sciences, in PG Diploma in Forensic Medicine and Toxicology in 2011. There are many academic awards in the name of Dr. Verma. like awards of excellence in field of forensic medicine and toxicology by Indian Association of Forensic Medicine and awarded in annual IFM conference at Jodhpur in January 2019. And next is the award of fellowship in Indian Society of Toxicology in Toxicon 13 at Poison Control Center AIMS Kochi in December 2019. The list is very long. I am not taking much of time. In nutshell, Dr. Verma is a unique combination of a clinical toxicologist, author, editor, and forensic poet, clinical forensic physician, medical examiner, instructor, skill trainer, and medical legal expert. So he has authored and co-authored in many international and is the editor of internationally published 47 booklets on toxicology and 30 case papers in paper reviewed journal of international repute. So now over to Dr. Verma for the presentation on legal duties in case of intoxicants. Dr. Vivekansh Verma.
Thank you, sir, for
over to you, Dr. Vivekansu.
Yes, sir. Thank you. Thank you, Dr. Sanjay, for giving an introduction. And I thank the organizers of AVMC to invite me for this lecture. So we will, after attending the interesting lectures by Dr. Anil Agarwal sir as well as Dr. Pradeep Kumar sir, we will discuss about the legal duties in case of intoxicants. Can you see the screen?
Yes, sir, we are able to see it.
Okay. So when we focus on the medical legal challenges as a doctors, we see that there are duties of registered medical practitioner towards the patient. So they are duty to exercise reasonable degree of skill and knowledge, duties in regard to attendance and examination of the patient, duty to furnish proper and suitable medications, duty to give instructions, provide counseling and prognosticate about the illness, duties towards the children and elderly who are vulnerable patients, and consultation with the specialist. And especially in cases of poisoning, we can consult the Poison Control Center, we can refer the databases, and duties in regards to psychiatric patients because they are considered as mentally ill under the recent updates. So we have to respect and we have to always see that they do not do further self-harm, especially the psychiatric patients, the children, the elderly, because they are vulnerable and they can injure themselves while inside the hospital also. And duties in regard to poisoning, that is managing the case, giving the antidotes, taking the samples, investigating further, giving the consultations, and duty to notify certain diseases. Like if there is a mass casualty of a case of poisoning, then you have to notify to the appropriate authority so that further spread can be applied for that. With the help of others, you can proceed. And then duties in regards to the operative procedures, if any surgery is required, especially in corrosive poisons, and the duties under Consumer Protection Act do not neglect, as described well by Dr. Pradeep, and the professional secrecy, that is, you have to maintain the confidentiality. That is, sometimes when a mass casualty occurs, the media people try to approach you to know about the status. So you have to maintain the professional secrecy and confidentiality for the patient while managing the cases. So there is a new duty, that is reporting an adverse event inside the hospital. As per JCI, that is Joint Commission International, and NABH. These are the guidelines to prevent future litigation for the doctors. That is, if there is a physical injury to the patient or if there is a chemical injury to the patient. So if the person falls from bed, falls in the washroom, undergo wrong surgery, wrong limb rib surgery, wrong side surgery of the eye, wrong time surgery or delay. So if there is anything wrong happening to the patients and it is by mistake or by the error by any of the nurses or the doctors, then the duty of the hospital as well as the treating doctor is to rectify the injury, to save the life further, so to prevent no further harm. That is our goal while reporting that if the wrong patient undergoes the surgery, violence by the staff or attendant occurs, then also we can notify. And then if there is a chemical injury to the patients, that comes as if a person gets a wrong dose of a drug in the wrong time, that is, it is repeated more than what we can prescribe, so it can cause overdose, or it can be given to the wrong patient. Sometimes if you identify a patient wrongly, by same name, two patients come in the emergency and they are not identified properly by checking their unique identity number, their age, and you give the wrong medication or to the patient, then it can lead to fatality. Then wrong route, sometimes a drug which can be given by intravenous route, it is given by intraarterial route, as discussed by Dr. Pradeep, in which the gangrene occurred. Then the wrong drug is given. This may happen with the similar drug, similar name of the drugs which are available in the market. And if you write a brand name and the brand names are similar, then it can create a mistake. And then drug reaction and allergy during blood transfusion, it can occur. So these are all the cases in which it is the duty of the treating doctor to report it and manage further. So now the duties of the registered medical practitioners towards the state is to take the consent, to maintain the confidentiality, maintenance of the records that is necessary, and then collection and preservation of the samples. And if a person is in a critical state, then arrange for dying declaration. Now, what is the role of a doctor in a medical legal case, especially if it is a case of poisoning? So doctor working for the law, doctor working against the law. There are two circumstances which can occur. Like if a person is injured and comes in the hospital, then the duty of the doctor is to recognize it as a medical legal case. If it is suspected foul play is there, you have to report it as a MLC, noting the injuries. And if sometimes the doctor work against the law, some of the doctors are doing a criminal act, or sometimes they are doing they are being negligent in providing the care, then illegal acts of identifying female fetus while doing ultrasound, doing illegal abortions, female feticide, or procuring for illegal organ transplantation. So they are the doctors who are working against the law. So it again becomes a medical legal case, although it is not, don't make a medical legal report, but we have to report to the hospital, to the appropriate authority, so that it is a whistleblowing policy which occurs, in which you blow a whistle that there is something wrong happening at this center and that needs to be stopped. Then insurance fraud, which are becoming quite common. Then manipulation of the hospital records, like issuing a wrong medical certificate for sickness or fitness. Then euthanasia, mercy killing. If a doctor is practicing active euthanasia in India, it becomes a criminal offense. Although passive euthanasia with the permission of the court, it has now become legal, but active euthanasia is still illegal. So these are all the role of doctors, and the intention of the accused doctor is seen. So while if it is a carelessness, it is a lesser crime, and if it is an intent to harm, it has become a major crime. So negligence in driving, it becomes roadside trauma. Even a doctor is driving and he injures someone, or if a person is taken in the ambulance and the ambulance hits someone, and then it becomes a roadside trauma. So that becomes a medical case. Workplace accidental fall can occur. Negligence in the hospital while attending a patient. Suicide, that is harming self. Sometimes the patient get admitted and they attempt suicide inside the hospital. And intent to harm, that is assaulting a female patient, then it becomes aggravated sexual assault. Then strangulation and hanging. Then mercy killing and poisoning a patient who is admitted under your care and you are intentionally trying to harm, then it becomes a criminal offense. So criminal abortion, that also comes as a criminal act, and illegal organ trade. Now, when we focus on the evidence, there is evidence-based medicine. That is, we refer to the journals, we read the current medical literature, and we practice accordingly based on the evidence of what the studies have been done. Similarly, in cases of legal cases or in medical legal cases, there is evidence-based law, that is the reported judgment. As discussed in the previous session, the reported judgment, they help us in guiding further to manage a case or to understand what may happen, to prognosticate that what is the evidence-based law says. So that is the role of forensic toxicology is interrelated in whether it is evidence-based medicine or evidence-based law, and that's why it becomes evidence-based medical legal issues. So there is a interesting homonymous chain in toxicology. We can discuss that to understand what it can help in managing a case as a legal duty of the doctor, as well as the other persons who are involved in cases of injury and intoxication. So there is always a dilemma for a doctor to make it a medical legal report or not. Then there is a dilemma of the police to arrest the accused or not, based on the medical legal reporting of the doctor on visiting the scene of crime, and if there is a suspect, then the dilemma of the police to arrest or not. Because if it is a cognizable offense, then they have to arrest the accused. Then dilemma of the court to bail out the accused or not. So that is a simple way of understanding this complex process. There is a chain, and the chain has different meanings in different perspectives. So if you see a person who is attempting a suicide, so he says, "Chain se marne de," wants to die, and a person who is a doctor, who is a treating doctor, and he makes a medical legal report, then he feels that he will have to go in the court for court evidence, and then it becomes more bothering for him. So it becomes difficult that he says that "Chain se jeene na de." So that is a medical legal case, sometimes challenging, because you get a call from the court after 2 to 3 years and you don't know what may have happened and what you have prepared until unless you see the court fight. And then the chain of custody that you have to maintain. That is, if you are identifying and investigating case, then in case of poisoning, you have to collect the samples and maintain the chain of custody. That is, it should be handed over to the concerned investigating officer so that it can reach to the forensic science lab, and that's how you can identify the toxin which is involved. And then the role of police comes whether to handcuff the accused in case of cognizable offenses, to arrest the accused or not. So that is applying chain. And then the sequence of events, what may have happened, that is chain of events, that is the storytelling to the public when there is a mass casualty is there, so that we can reach to the source of the poison or the source of the toxin which is getting released in the society. So that is important when you are addressing a mass casualty, like in midday meal poisoning. If the children are dying while consuming the food provided in the schools in the midday meal, so you have to identify what is the source of the toxin. It is contamination of the floor, or sometimes there is food products which are supplied. And then the role of the court comes is to chain out the custody of the accused, that is to bail out or not. So if it is a cognizable offense in which he can destroy the evidence, then the court does not bail out. Or so that is the role of the duty magistrate, especially in cases of attempt to murder. It is non-bailable offense. So that is how easy to remember the duty of the doctors and other people. So is every offense a crime? That is a challenge for us to understand in case of medical case. Like as a citizen of India, or as per the law of the land, we have to report any case of crime which occurs before us, or which we becomes the witness when the person who is a sufferer, who has become the victim, he comes to us and he reports to us that he has suffered a poisoning, he has suffered an assault, or he has suffered an accident. If it is a roadside accident, then it is the duty of the doctor to report it to the concerned appropriate authority. So it is reportable or not, that is the role comes, whether you have to inform to the media or not. Is it dangerous or not? So that is the role of paramedics and doctors, that if you get a call from a nearby place that there is a mass casualty which has occurred, so you have to send the ambulance and procure the victims. And sometimes there is on spot you have to provide the first aid. Is it related to the human body? Then the role of FSL sampling is required, and the role of scientists to report it, what may have been the toxin. Is it cognizable of the or not? That is the role of the police. Is it done in self-defense or not? That is the role of defense lawyer, which comes mostly in cases of assault. Sometimes the defense lawyer says that it is in defense the person has injured, the accused has injured the victim. and it is available or not, as we have discussed, the role of the court comes. So, what is a medical legal case? It is a case of injury or ailment where an attending doctor, after taking history and clinical examination of the patient, suspects foul play and thinks that some investigation by the law enforcing agencies is essential so as to fix the responsibility of causing the injury regarding the case in accordance with the law. So, receiving an MLC, the doctor can receive a medical legal case brought by the police for examination reporting, already registered medical legal case referred from other healthcare system, or after taking history taking and thorough examination, doctor suspects that there is a foul play or their circumstances or findings are there in which he has to register his medical legal case, then it is warranted, or sometimes it is the director of the court to give an opinion, then also it becomes a medical legal case. Or sometimes the person who is in custody and he gets injured or intoxicated, then the role of the doctor comes to make it a medical legal case when it is brought to the hospital. So who can report it? Any doctor who possesses permanent registration with the Medical Council of India, National Medical Council, or State Medical Council, and has some experience. The doctor who has first contact with the patient should prepare a medical legal case report. Like in cases of sexual assault, it is preferable to be done by a female doctor. Now, where no specified areas is defined for MLC, emergency department is an area where majority of medical legal cases are prepared. Why? Because emergency is the gateway for all the medical legal issues which are entering the hospital. Either they are cases of injuries or assaults or cases of intoxication, because they are all become the medical emergencies or surgical emergencies and they land up in the emergency department. Or sometimes a case of medical negligence, then also it becomes a medical emergency if the person has undergone wrong surgery or it has been wrong medication which has been administered, then also the emergency becomes a gateway for entering any case which is a medical legal case. That's why the screening of that has to be done in the emergency, and sometimes you do not notice that and it gets admitted in the ward or ICU, then also you can report it later if the person reveals later that he has been intoxicated and he has suffered the injuries. So why to make an MLC? MLC cases are just like non-MLC cases, and doctor's duty is bound to treat as well as document the details, and the crucial piece of evidence has to be collected. So communication to law enforcing agencies is required under section 39 of CRPC, and failure to do so will attract legal penalty liable to be prosecuted under section 201 of IPC. So when we have to report, so it is not always, it is a pre-labeled, but there are common examples which are enumerated here in which you have to make it a medical legal case. It occurs that it is a suspected or evident poisoning, or if it is a case of suspected suicide, person comes with a case of suicide hanging, then he might have consumed some poison before attempting suicide, or if he had been strangulated, then also the role comes for suspecting it is an intoxication along with that. In sexual assault cases also, if the person is unconscious, you have to suspect that she might have been given some medication to stupefy sexual assault. So there are again few cases like snake bites, scorpion stings, chemical injuries, burns and scars, pesticide poisoning, cocktail drug abuse, drug withdrawal symptoms in addicts. They also becomes reportable because they are overlapping symptoms. You don't know whether it is a drug withdrawal or sometimes a drug overdose. So you have to always think, investigate, and report it. Criminal abortion by the drugs, then it also becomes undiagnosed acute coma or the death occurs within 24 hours hospitalization without establishing a diagnosis, especially in young females, then it becomes a medical legal case. You have to suspect a poisoning if there is no injury marks. So they are all becomes a medical legal case in poisoning. What to write in MLC? There is a simple way to remember. It is all case, that is कौन है victim, identify कितनी age of the victim, कहाँ रहते हो, that is the address that is needs to be identified to identify sometimes the crime scene investigation, or sometimes to approach to the patient who is a minor or who is dependent right now and a guardian needs to be called. Then you need to know the address that where the person lives. Then कब हुआ crime, the time, it becomes important to prognosticate for the fatal period, that what may be the fatal period for a person who has ingested the toxin. कहाँ हुआ, the place of crime, you can collect the evidence from the scene of crime, any tablets, injections that can be found. Kaise hua, whether it is accident, assault, poisoning, that the person can answer, or the people who have brought the person, they can give a clue that can help you in unconscious patients to manage further, to investigate. Kitni injuries are there that you have to note. Kaise type ki injuries, whether it is grievous or not, whether it is dangerous to life. If it is dangerous to life, then you have to think of taking a dying declaration. Kisne kiya? It is only in dying declaration the doctor notes that who has done the crime to the victim. Otherwise, it is a matter of investigation mostly. So our role is basically to report the police and identify the victim and identify the toxin so that we can save the life of the person. So this is an easy way to remember a mnemonic. Now the laws which affect, if the doctor fails to report a criminal poison to the police, he or she may be punished under section 193 of IPC. If the doctor deliberately fails to preserve samples, he is liable to be punished under section 201 of IPC for causing disappearance of evidence. So these are the laws which regulate our practice. Now, according to the law, if you go for legal purposes in India, however, the exact definition of poison is not essential because the law usually paraphrases in explanatory form its reference to poison. Thus, in causing hurt and grievous hurt by poison, 324 and 326 IPC state that any poison or any corrosive substance or any substance which is deleterious to the human body to inhale, to swallow, or to take into the blood. Hence, for conviction under these sections, it is not necessary to establish that the substance by means of which the hurt or grievous hurt was caused is a poison. It is sufficient if it is proved that it is a substance which comes under the above stated description. Then under 328 of IPC, causing hurt by means of poison, whosoever administers to or causes to be taken by any person, any poison or any stupefying, intoxicating or unwholesome drug or other thing with intent to cause hurt to such person or with intent to commit or to facilitate the commission of an offense or knowing it to be likely that he will thereby cause hurt shall be punished with imprisonment of either description of a term which may extend to 10 years and shall be liable to fine. So here again, it will be observed that the addition of the words any stupefying, intoxicating or unwholesome drug or other thing renders the exact definition of the term a poison unnecessary for the purpose of this section. It should, however, be noted that the other thing must be read other unwholesome thing, as administering a substance as to whose nature or no evidence is given, which was intended to act as a charm was held to be milder offense. Now, fatal criminal poisoning, homicide under section 329 of IPC declares whosoever causes death by doing an act with the intent of causing death or with the intent of causing such bodily injury as is likely to cause death or with the knowledge that he is likely by such act to cause death commits the offense of culpable homicide. Hence, if A administers a substance to B with such intent or knowledge and thereby causes B's death, A may be convicted under this section of the offense of committing culpable homicide, irrespective of whether the substance administered may or may not be strictly be called a poison. So anything which can become a poison, then it comes under definition of section 299. If a person gets injured, chemically injured, and he is in a state in which the person can die. For it is the intent which suffices to constitute a crime, irrespective of the dose or even the nature of the substance. So, act of criminal poisoning, many Indians consider the taking of life by bloodshed a greater crime than poisoning or strangling, etc. Note the use of the word "khun," literally means blood, as a synonym of murder. A medical witness is puzzled by the persistence with which a lawyer will cross-examine to know if there was any blood spilled on the clothes, etc. or not. If no blood is shed, in their opinion, the manslaughter does not amount to murder and the punishment should be less. So this is in one of the case, books, it is a medical treatise by Lyons, in which it has been described that the word "khun" is commonly asked by the defense lawyer that was any bloodshed was there on the clothes of the patient. So what are the 4 legal principles to prove the criminal poisoning during cross-examination? First is the motive. That is, there is a clear motive purpose for an accused to administer the poison to the victim. Second, that the victim died due to poison said to have been administered to sick him. Then third is that the accused had the poison in his possession to chemically kill him or her. And then he had an opportunity to administer the poison by poison to the victim. So that was in one of the infamous case of Chintamani Lagu, the definition of 4 legal principles to prove criminal poisoning during cross-examination. So that is important to know, because when you undergo cross-examination as a doctor, then you will be asked about these, that what may be the, was there any possession, was there any, the person died due to the poison or due to the medical complication later on. So that is always asked, whether the person died due to poisoning or due to the medical complication later on. So it is a dicey situation for the doctor, because if it is alleged that he died due to medical complications, then the case of medical negligence may be filed against the doctor. So you have to always careful while investigating a case, while giving a statement in the court that the person died, even in cases of OP poisoning, like organophosphate, the person can die even after a month later. So it is due to the chronic poisoning, or sometimes due to the complications of the poisoning, the person can die, and that's how you can justify that the person, if it is a case of alleged homicide, then it can be the poison which can kill the person even after 1 month. Similarly, there is paraquat that can also lead to death after 1 month due to medical complications of the poison, not the medical complications of the treating physician, the person who is trying to treat because there is no specific antidote for paraquat. Similarly, in aluminum phosphate, there is no specific antidote. So you can give good supportive care, but not you don't know what you can administer or what not. It is evidence-based medicine you go by, and if the person survives, then it is the duty of the doctor to further investigate that who must have attempted. So that's why we make a medical legal case. So was there any visible bleeding? We have already discussed. So this is this was perspective of the cross-examination, which is asked. The misnomers in medical science that also creates a problem for the doctors while attending, like food poisoning. It is common word which is given for if a person gets a stale food. So it does not become a medical legal case. But if it is a mass casualty which is occurring due to stale food, then it becomes a medical legal case. Like similarly, there is a word endotoxins, which are the person gets investigated for Clostridium toxin. A case of immunocompromised patient suffering from diarrhea, and he gets investigated because the person can develop Clostridium infection. But that toxin does not make it a medical legal case because it is a bacterial toxin. Then the infamous case in which there was toxic epidermal necrosis, as described by Dr. Pradeep sir in previous lectures, it is an infectious disorder. It became a highlight in a medical legal case, but it is not a medical legal case in say. But since it became a medical negligence case, then it became a medical legal case for noting down and learning from the evidence based. Now, similarly, there are few words which are not an MLC, like a threatened abortion. So it is not abortion caused by threatened by the in-laws, as understood by someone. Sometimes the lawyers say that it is a threatened abortion, so it may be someone has threatened the pregnant lady, or birth asphyxia. So it is not caused by negligence of the obstetrician in child delivery. It is a phenomena which can occur when the person is pregnant and she is delivering the child, and the birth asphyxia can occur in prolonged labor. Then heart attack. It is not an MLC. It is a myocardial infarction. Similarly, brain attack. It is cerebrovascular accident. Again, accident in itself is not an MLC. It is a medical disorder. Then cardiac arrest. So arrest, here you are not arresting anyone. It is the heart is getting stopped from pumping further. So that's why the word comes arrest. Similarly, there is acute kidney injury, acute lung injury, acute liver injury, which can occur due to infections. But it is not actually traumatic. And the hypoxia can cause acute kidney injury, lung injury, or liver injury. But it is not a medical use. Even sometimes chemical injury can cause liver injury. Then also, if a person is consuming a drug like paracetamol and he is regularly taking it, and he suffers from liver failure, or sometimes person consuming alcohol chronically, then it does not become a medical case unless it is unintentional and it is consumed in acute dose. Then only we report it as a case of medical case in cases of liver injury. So these are few examples. Similarly, some accidental poisoning by self is not always an MLC, like petrol ingestion in minor amount while sucking it out through the pipe. So if the person has not aspirated, it does not become a medical legal case. You can just investigate the person. If person looks stable, you can just manage the case. Inhalation of pyrethroid insecticide like good night, owl out at home. So it does not become a medical legal case as per. Then overdose of digitalis and warfarin by the patient. It is a regular, they are taking it regularly, and they suffer due to the overdose, or sometimes they are not able to metabolize it properly due to any medical illness. Then that causes delay in PTINR and warfarin. In digital, it can cause arrhythmias. So it will not become a medical case as well. So you just have to manage the case as a case of overdose, and you can treat the patient without making it a medical case. Only if it is unintentional and it is consumed by a child, the grandparents' medication has been consumed by a child, then it becomes medical case. Similarly, button battery injection, it does not require to be a medical case. You just have to get it removed endoscopically. Then food poisoning, we already discussed. Seafood poisoning, they are as such not an MLC. Now, why to label illicit drug abuse as an MLC? Like drug of addiction, they are illegally procured. So to stop the drugs, illegal sale, police tracks the addict, diagnose and treat by the treating doctor. Sudden death can occur in drug addicts as they hide the cocaine or opioids by swallowing it in a packet of condoms and tied with the thread of teeth. Thus, any one of the youngsters who is traveling in the flight internationally, if collapses suddenly, is suspected to be a drug mule. That is, he is carrying the drug inside his body, and you have to investigate for this, and then it becomes a medical case. So in our center, we are having a airport nearby. So many times youngsters come in the emergency from the airport and they are brought in unconscious state. So you have to always suspect that there can be some poison which the person may be carrying inside, especially the people who are coming from poor countries like Africa. They have been reported carrying the drugs of illicit drugs, and they have died on spot while getting the first aid, and it becomes a medical case. You have to do a post-mortem, establish it, and manage the case, and you have to send the samples and remove it endoscopically carefully. You have to remove it. Now, alcohol drinking is as such not an MLC if it is voluntary drinking by the person himself who is consuming it regularly. So unless the patient is under the influence and intoxicated and creating a public nuisance in a public place, it does not become a medical legal case. Only if the police arrest a person who is causing a nuisance and is intoxicated, then they bring the police, then it becomes a medical case. You have to make a report of intoxication and take the samples, assess the patient for signs of intoxication. And sometimes breath analyzer test has been done and they report it, they document it, and then it becomes important. While if the person is driving a car, he is a driver, then also it becomes relevant. If a person is a pilot and he has consumed alcohol, then it is a crime because they can harm others while driving the vehicle. So that's why it becomes a medical case. So section 304 of IPC is causing death by rash driving, and section 510 of IPC is misconduct in public by a drunken person. And section 185 of Motor Vehicle Act regulates about a person who is driving while drinking. So it is a punishable offense. So even if the person has done an assault or firearm injuries with alcohol intake, you have to always take the blood alcohol samples. If a person is an accused, or if a person was drinking and driving, because there can be delayed reaction time which can cause the fatal accidents. Then drowning after alcohol binge, then you have to always take the samples. There are a few cases, youngsters, they are doing party together and they are brought in unconscious state. In case of drowning, you have to make it a medical case and investigate for anything which the person has consumed. Because a normal person, we received one case recently in which there was 2 feet of swimming pool was there, 2 feet deep only, and the person died due to drowning. So how can an adult person who is well built and he was partying with others and he died due to drowning? You have to always investigate by investigating an intoxicating substance which might have caused the drowning. Now, in cases of domestic violence and damage to the hospital property, sometimes the patient attendants, they become violent and they are intoxicated. You can report it to the police, and the police can arrest them and get the sample of the person who is the accused, so that you can prove this in the court of law that they were intoxicated and creating public nuisance in the hospital. So these are all the medical legal cases become important to understand. Now, why to label snake bite as an MLC? This was a challenge for me when we were doing post-graduation, and most of the time in the government hospitals, they don't report a snake bite as an MLC because they say that it is the person was working in the farm and he was accidentally bitten by a snake, And if a person is not, how will he claim for compensation from against? Why will he file a case against the snake? Is it that? But since recently you must have seen few cases which have been reported in which the snake has been implanted there inside the home. So that becomes important. The forest department gives compensation to the family of the patient who is a working farmer and who is bitten by a venomous snake and requires doctors to certify it that the person died due to snake bite, and that how they can get a compensation from the forest department because it is an endangered species, and the forest department regulates that if any snake comes in the public place where there is like a farmhouse is there, then you have to call the forest department. They will come and they will rescue the snake and remove it. But accidentally, if someone is get bitten, then you have to report it as a medical legal case. Homicide by hitting with sewage simulating snake bite. There were few cases in the past in which there
Hello,
was attempts
Dr.
were raised and then
Vivekansu,
multiple
sorry to
attempts of
interrupt you.
Ali's homicide by a
Hello,
husband to his wife, leaving
Dr.
snake in the room of
Vivekansu,
pitcher water.
sorry
There
to
was
interrupt
a
you, but
recent case in
you
Kerala in
have to
which
bind
the
within the
husband
2-3
was
minutes.
found guilty for this. So every snake bite in which you suspect that it is a venomous snake bite, you're suspecting that the person is getting injured, it becomes a medical
Dr.
case.
Vivekansu,
So
sorry to
by
interrupt
this,
you. Please
I
bind up.
summarize.
Yes,
If you have
yes.
any questions, you can
Okay.
ask.
That's all. Thank you, Dr. Vivekansu, for an elaborate discussion regarding the legal duties of doctors and other people in all the situations like an injury or intoxication.
Dr. Sanjay, you are not audible.
Hello.
You have to unmute
Yes,
yourself.
Hello. Am I audible now?
Yes, sir, you're loud and clear.
Okay. Thank you, Dr. Vivekansu, for an elaborate discussion regarding the legal duties of doctors and other people, all in all the situation like any injury or intoxication. Can you focus some light? Can you put some light on legal duties of police officers in maintaining chain of custody or timely disposal of medical legal cases? Please.
Yes, sir.
Legal duties of.
Yes, sir. You can repeat the question, please.
Put some lights on legal duties of police officers in maintaining chain of custody or timely disposal of medical legal cases. Is there any legal provision of timely disposal of medical legal cases for the police officers?
So just like doctors, even the police officers, they have been prosecuted for not collecting the evidence on time or destroying the evidence when they ignore it that the doctor has collected it and they hand over to the police and the police does not deposit it timely to the FSL department. So whenever we give a sample to the authorized person, that is an investigating officer, we should always take a receiving from them that we have given them the sample for as soon as possible they can deliver it. So then they become legally liable for submitting that to the nearby forensic lab, and even in few places in our hospital also we are having blood alcohol. We can collect it and we can report it from our own institute. So similarly, few toxins are there which we can detect. So
they generally receive samples from the hospital and keep in their malkhana or in lab. Is there a time limit for disposal?
As soon as possible, as per the law of the land. And just like a citizen of India, we are responsible for managing a case. We are reporting a case. We are collecting the evidence. Similarly, it is the duty of the police officer. As soon as possible, they have to deposit to the FSL. If they are delaying it, because everything is dated. If you collect the sample on the same day, the person came to your hospital and you have given the receiving to the person who is the responsible police officer, then it is the duty of the police officer. And in the police manual, it has been described. Many police manuals have been published by the state departments from different institutes, and they have that guidelines in which they have to submit the sample to the nearby center, and it has to be carried in a chain of custody. That is the role of chain of custody is there, and it is very well documented. But
as soon as possible, but no maximum time is not mentioned here. Minimum or maximum is not mentioned. Okay, one question is from the participants that furnishing false information to police is punishable under 177 IPC or 193 IPC.
What is the
Furnishing
question,
false information to police is punishable under 177 IPC or 193 IPC.
So it is in the 193 IPC. If you are furnishing any information to the police, if you furnish it, then it is a punishable offense. If you are giving a false certificate, then it becomes a punishable offense.
What is the duration of punishment? 3 years or 7 years?
It is 7 years.
Okay.
So sorry for interrupting. But, 177 IPC also talks about this furnishing false information to the public servant and all. But there, I think the punishment is lesser, some 2 years like that only. I remember. But I'm not sure about this.
No, this is a question we can forget because this is a legal question and we can all check our books. So let's not. I mean, the more better questions are where some kind of opinion is required. It is simply a fact you can check anywhere.
Yes, sir. Thank you.
Thank you, sir. Thank you. Thank you for clarifying. Okay. Thank you, Dr. Vakansu.
Okay, sir.
Thank you so much, sir.
Dr. Aarti. Yes.
Thank you so much, sir. Good afternoon, everyone. We have come towards the end of the first session of this conference. Before going to the last speaker of the day, let me just acknowledge all the speakers who presented today so far with their amazing spirit and presentations. We all definitely learned a lot. Moving on, now I would like to call Dr. Ashokan, Professor and HOD Pharmacology, AVMC, vmrf, to introduce our next speaker, Dr. Krishnadat Chavli. Over to you, sir.
Thank you, ma'am. Am I audible, ma'am?
Yes, sir, you're loud and clear.
Okay, my video is not opening. I don't know why. Okay, anyhow, we are in hypoglycemic state. Now, thanks for the opportunity given to chair this session. I thank Dr. Aarti and the Department of Forensic Medicine, as well as our management, Dean HP, all for given this chance. You know that wide variety of chemicals are designed for devices, diverse uses in day-to-day life. Though their benefits are enormous, yet they are associated with great risk if misused. The probability of ingestion of these substances products either accidentally or intentionally has increased manifold. Acute poisoning is one of the commonest emergencies throughout the world. To ensure chemical safety framework for prevention and management of eventualities, resources is the need of, and the resources are need of the hour. So the topic is today is resources available for dealing with poisoning. Our resource person is none other than Dr. Krishnadat Chavli. He is none other than the professor and head forensic medicine toxicology, AIIMS Raipur, Chhattisgarh. His qualification is MBBS, MD, Depend Me, DG, PG, DHA. So his achievements are, he started the DM course in medical and forensic toxicology, the first of its kind in the country. Thank you, sir, for your efforts. Krishnadat Chavli, sir. And teaching experience is 25 years in Government Medical College of Gujarat, GMCH Chandigarh, and AIIMS Raipur. He is a multilinguistic. He is actually able to speak English, Hindi, Telugu, Gujarat, can follow Punjabi speech and script. And his professional membership are He is a professional member body in the memberships with the FIMC, SIA and MNAMS, life member of IAFM, IST and PAF, MD and so on and so forth. So he is a member specialist, Board of Forensic Medicine and the National Board of Examination 2019-2021. Sir, thanks for your elaborate introduction. Actually, you see that it will take time. We are in the hypoglycemic stage. So with this, I wind up your introduction. Over to you, sir.
Yeah, thank you so much for the kind introduction, sir. I'll just say, like Dr. Anil Agarwal sir had just said before his talk, the introduction should be kept short. I'm just Krishna Chavli. I don't claim to be a toxicologist or an expert in toxicology. A chance opportunity I got to start the course in DM was maybe anyone else could have got that. It need not be me alone. Having done that, I'm trying to justify the faith, that the trust that my administration has put in me. And with that, I'll just start my talk today. I'll try to be very brief because this is something which is very, very vague. I'm not really sure what exactly was expected of me. And I'm not really sure whether I'll be able to live up to the expectations of the people around me. If there's something that is lacking, please let me know so I can add that to my own resources. So one of the resources that I would look forward is your feedback. So with that, I'll just start with a brief introduction. The burden of poisoning, we say that almost around 40,000 to 60,000 chemicals. Okay, 40,000 to 60,000 industrial chemicals are available, of which around 6,000 to 7,000 account for most of the volume of poisons that we talk about. So these are the number of chemicals that we are actually dealing with day in and day out. And add to this some 6,000 plus approved drugs that we have that could be abused, that could be overused, that could be misused. Some 750, 800 psychoactive substances of these are there. And we have some 2,000 poisonous plant species. And add to that another 1,200 species of venomous and poisonous animals. It means poisoning is not something very small. It's a huge burden. If I look at the health aspects of poisoning that has happened, things are not, they may look very good, because as per the WHO document, it says the mortality rate is in India in poisoning is 0.4 per 100,000 population. Might look small, but if I look at it from a different perspective, in 2016 itself, we had some 106,000 deaths from poisoning alone in the world. And we also lose a lot of time. So almost 6.3 million years of healthy life have been destroyed by the effect of poisons. So that means poisoning is a huge burden. There are lots of poisons. So like we always say, there's nothing like a poison. Every substance can behave like a poison. So there are innumerable poisons, and the effects on them are a different matter of discussion. So we should be aware. This knowledge of the various substances and knowledge of how to deal with them is something that we should be equipped with, because with so many things that people are coming up with, and if we are not prepared, then we won't be able to deal with the poisons and the cases. So that is important for us. And for that knowledge, we need various resources from where we can seek help. So I think that is the objective with which the organizers have asked me to talk on resources, what to look for, where to look for, where we need to handle cases of poisoning. Many times we ourselves are confused. We do not know. Though we might be good in theory, we might have taught students, but when it comes to a family member who is exposed to a poison, then we are at our wits' end about what to do and where to deal with, where to get the information. So I just tried to compile some information that I could get from various places. So first thing is poison control centers. So poison control centers are a specialized units. They are specialized units which have a role in mostly a assistance and advisory role in treatment, in prevention, in diagnosis, in management of poisoning. Mostly it is there are two terms that I would like to clarify here. One is a poison information center. The second is a poison center or poison control center. Poison information center deals with mainly providing information about various poisons. So it does not deal with management. So information and advice is a poison information center. Poison control center or poison centers are those where we also include clinical management. You have diagnosis, you have lab diagnosis of the poison concerned. So you have equipment where you can diagnose the poison that the person has been exposed to. You might even consider, having an antidote bank or the poison center would be able to guide you to a place where you could procure antidotes for the concerned poison, and further down the line, this information gathered by the poison control center would serve as a nidus for research, for education, for training, and so that is how a poison control center would be of use. So we should know all the poison control centers that are there in our vicinity, where we can seek emergency help, and where we can go to for management of any case of poisoning, that or at least help in any case of poisoning. So this would be very important, where suppose a PHC, in a PHC, a doctor who is not well equipped with all the paraphernalia to handle case of poisoning, and who does not want to, or who is not in a position to refer a patient. So these poison control centers would be handy.
Excuse me, sir.
Yeah.
So your slides are not moving, sir. Please.
Okay. Can I just shut it and then restart?
Yes, sir.
So is this now visible? Does
No,
this move?
sir. Not yet.
Is
Not
it okay
yet,
now?
sir.
Not yet. Okay. Let me do one thing. I'll just stop control and then I'll go back. Is this good now?
Add. You are only now visible, your face only now. You're not in the slide.
Okay, not the slide. Let me close this, shut this.
Share the screen, sir.
Yeah, I have shared the screen, but somehow there's some problem. I'll just do it once again. I have just shut that. I'll just share screen again. Yeah, this is share the screen. Okay. So with that, I'll go and yeah, you can see my screen now with all the icons on the screen.
Yes, sir.
Yes, sir.
That's good. Now I think it should work. Yeah, that's Sometimes it does, technology helps, but sometimes it also causes a lot of frustration. Okay.
Yes.
Okay. So I was here. I was here where I was talking about.
Yeah. Now it is okay, sir.
Okay, good.
Now
Thank
it's
you.
okay.
Thank you so much. So most poison control centers have a toll-free number. So you can, or some also might have an email. So you can contact most of the poison control centers through a toll-free number where they collect some data, some information from about the caller, the information about the person who has been affected, and then they share the information so that that can be used. So that is how you can, one of the resources was that. Second is medical resources. So you should also be aware of the local hospitals. What are the hospitals nearby which deal with poison? Many times it happens, you think there's a hospital, you take the person to the hospital, and then you realize that they don't manage poisoned patients. Many people are not equipped. It's a good thing. They know that they are not capable of managing poison patients. But then if we realize it after reaching the hospital, we would have lost valuable time. So hospitals and emergency medical services which deal with poisoning cases, the list should be on hand so that you can rush, you know which place to go to in case of need for poisoning. This is, of course, for the general public. Maybe even for the hospitals, we should, where we need some referral services, where we think we need more advice, we need more help, we should be able to know where we can talk to, where we can seek help. And you know what sort of medical treatments are available in each of the hospitals. So where decontamination, what all those things that we talk about, whether these are available. Sometimes you might need advanced management like dialysis, whether that is available there or not. So you should, if you have a information about these things beforehand, then it becomes easy for the patient, and survival becomes very more promising. You need to know where to seek help for medical resources. Prevention and educational resources is, again, we always say prevention is important and education is always important. So prevention strategies, you should know, again, resources for handling. This may not be actual handling after you get a case, but this is about handling, preventing cases of poisoning from occurring. So many times we end up with cases. In fact, let me tell you an example. In Chhattisgarh, we have a habit here. That means it's a thing that they do. People who suffer paralysis are administered a quantity of kerosene. I do not understand why they do it and who started this thing, but they do it. Now that is something. Now the person already is paralyzed. Maybe his respiratory muscles are also affected, and on top of it, you administer kerosene through the mouth. Now this person is definitely, if he is not dying of the incident itself, of the disease itself, he is definitely dying because of the aspiration that might happen because of ingestion of kerosene. So these are things which should be identified and communicated to the public so that these can be prevented. So resources, once you have this thing, then you can also send out resources, you can make brochures, you can make education programs. And most important for doctors is poison databases. There are databases like ToxBase. ToxBase is a UK-based database. ToxINS is a New Zealand-based database. PoisIndex is a US-based database, and even WHO has a database. So these databases are available for a subscription, and these can be used. Many poisons are covered in each of these databases. So if you have access to one or more of these databases, you can definitely, you can find out the substance that the person has been affected by in one of these, and you can at least start the initial management, and you can see how you can help the patient. So that is why your education becomes very important. You can prevent poisoning even if you can begin from the school itself. Many children from class 9 onwards, if we can organize some sort of a session for the school children for teaching them how to handle case of poisoning, how to you can even simple strategies like CPRs. You can teach them how to administer CPR in case a patient is he is in a life and death situation. These can help. So education would help in preventing many cases of deaths due to poisoning. A little more about databases. We also have poison index and INCHEM. So poison index is there, INCHEM is there, which also have this a good resource, a good collection of chemical substances that can cause, and all details about these chemical substances which can affect the human body. Books, just a couple of books which I happen to just remember. Information Resources in Toxicology is one very good book which will give you a lot of information. Toxicology Cases for the Clinical and Forensic Laboratory is another book which deals with many cases of poisoning. So as they deal with case reports, these are many aspects of poisoning are handled in this book. There are multiple websites where you can look for information, like the Expert Toxicologist. This is a toxicology consulting service, which you can go to that and you can use that for help. Science Direct is, we all know that it's a collection of lots of research material. Similarly, you have PubChem, and NCBI has a PubChem site where again multiple chemicals are included in this. So information regarding these chemicals is included in this. And again, the INCHEM website is this. This is a WHO website where lots of chemicals are included in the INCHEM website. So I think there's some issue. Okay. Finally, community resources. We might, like I already said, education and community resources go hand in hand. So you might have to, empower the community to see how there are many young fellows, young people who are very willing. We have seen that in snakes handling. So you have many youngsters who are willing to help. Many times when there's a snake in the house, you call them, they would come at any odd hour to help you to rescue the snake and leave it in a safe place. So similarly, we have these Erula tribes in Tamil Nadu, where they used to catch snakes for their venom. Now they have been educated. These are community resources who will be of much use to us. You can educate them. They would be more than willing to help, and they would organize their own self into small groups, and they can be contacted through a network through which they can help persons in need in case of poisoning incidents. So first aid classes, local hospitals, support groups, you can organize those things. So with that, I would come to a conclusion about its poisoning is a big problem. It's a big issue, public health issue, and it's a global public health problem, in fact. And there are multiple cases of poisoning that we need to deal with. After we started this DM course in toxicology here, now we have realized the number of substances that people expose themselves to, and they end up in the hospital. We would have never thought about a person eating a mosquito repellent coil, or a person injecting himself with the mosquito repellent liquid. So these are some things, and an inadvertent injection of formalin, or inadvertent injection of drugs in the wrong route. So multiple things are there, and all these things have made us wiser about the ignorance that we have about various poisons, the ignorance that we harbor about the management. So we are still learning, and I hope we keep learning, and we increase our knowledge database, by using most of these resources. So we should educate ourselves and seek out resources in the communities. So we need to continue our attention to direct our attention to these things, use the resources in the best way possible so that we can handle cases of poisoning effectively. Thank you so much. I am open for questions if you have any.
So thanks for the nice and crisp talk, sir. There is one question from Marak, sir, regarding the recurring cost of subscribing the database.
On an individual basis, I have subscribed to this thing, what you call Talkspace, and Talkspace costs me just 650 rupees per year. So it's not a big amount. If a single person, one person subscribes to Talkspace, would it would be just 650 for a year is not a big amount.
Yeah.
Otherwise, the other
it is a meager amount only. Okay, for life saving.
Yeah, and WHO, I am told by Dr. Pillai is that if someone recommends your center to WHO, they provide their access to the database free of cost. So we still do not have access to that. So I'm not in a position to talk about that. But then, yes, that is also a possibility.
Okay, sir. Anybody wants to ask question? Please ask. Anybody is raising question other than Marak, sir? So no questions. So, sir, thank you for your nice and crisp talk. The talk on this poisoning resources regarding the poisoning control center, poisoning information center, medical resources on the hospital management of poisoning, referral services, and then community services and the support groups. All those things are which are very, very important. Everybody will know, should know, because we have to keep the golden hour to save the patient. They are in the, suppose referred in the time, particular time of reaching the hospital, we will be able to save the life. Thank you, sir. Such a nice and enlightened talk. Very much. Thank you very much. I am Dr. B.R. Asogan. Personally, thank you, Department of Pharmacology, HOD, Pharmacology, Arupadi Medical College, and thanks to Dr. Aarti and the HOD in charge of the FM department of Arupadi Medical College. Thank you very much for the opportunity given. Thank you, sir.
Thank you so much, sir. Thank you, sir.
Thank you, sir. Thank you for joining us. And that was this is one thing that we wanted everyone to know about the databases. And thank you, sir.
Yeah, thank you so much.
Thank you so much, sir. On behalf of VMRF, AVMC, Forensic Department of AVMC, and MLAP, I would like to extend my gratitude to all the speakers who presented today, and to all the dignitaries, professors, graduates, undergraduates of various institutes for making this session a success. Now it's time for a lunch break, after which we'll be having paper presentation, which will be starting at 2 o'clock. Thank you.
Thank you, Ms. Kalyani. And we request all those who are presenting a paper to be ready in their respective halls. Faculty presentation will happen in the same forum, the current one. So we will not be closing the forum right now. The rest of the PG and undergraduate presentations, the mails have been sent. If anyone has not received the mails, the participants have also been updated through WhatsApp group. Please do check your spam, because when we are sending it in bulk, sometimes it goes to the spam. So please do check your spam messages, and please do join for the undergraduate, postgraduate, and faculty presentation. Thank you all. Thank you, Ms. Kalyani.
can see here that I've milked out the veins. The vein was already marked and now I'm feeling along the vein. This is known as the Figan's method, and you can see here I can feel a blowout here.
Now we again ask the patient to look up. We pull the lower lid down and look up please. We stain the lower palpebral conjunctiva and the lower fornix.
The two vertebral arteries, they are uniting to form basilar artery. And the basilar artery is giving a terminal branch, the posterior cerebral artery.
When somebody wants to put a clinical question for a NEET exam or for a next exam, and if you are the examiner, what is the easiest way to put a clinical question, you ask me?
We are starting from the basics, trying to clear the basic concepts of each and every part.
I am holding with my two fingers, C and E technique. So this is C, this is E. So I am holding on the bony prominences.
As the cyst enlarges, right, the pericyst ruptures and the hydrated cyst communicates with the bronchus.
And if I have the entire bar in one go, that is an excisional biopsy of that chocolate.
Now, when the head of the baby gets fully extended, then it is face presentation, and in face presentation, it is submentopragmatic or submento-vertical diameters. సాంబార్
Dr. Ajoy Kumar. Dr. Ajoy Kumar. Dr. Aparna. Arpan Kumar. Yeah, Dr. Arpan Kumar. Dr. Dilip. Dr. Dilip. Dr. Ajoy. Can you unmute yourself? Dr.
Yes,
Ajoy?
yes, ma'am. I've joined.
Yes, sir. Sir, can you try to share your PowerPoint presentation? You're the co-host now, so you should be able to share. Yeah, Dr. Dilip is there.
Yes, ma'am.
Yeah, Dr. Arpan. Dr. Dilip, you're comfortable with sharing, right? You need any of our help for that? Dr. Dilip?
Ma'am.
You are comfortable with joining from this PPT from your device, right?
Yes, yes, ma'am.
Yeah. Dr. Ajoy, yours is visible. Can you put it in full screen mode?
I'm putting.
Yeah. Here. Sir, but it's coming as a plain screen. The first PPT is not visible. It's showing end slide or click to exist. Yes, that's good.
Yeah.
We will just wait for Sitalal sir to join. From instance, sir, am I audible to you?
Yes.
Okay, sir. Sir, Sitalal sir will join now. He said just 2 minutes. Oh, okay. Sir, so can we go ahead with the presentations?
Yes.
Yeah, okay. Sir, I'll just read through the rules once and we will go ahead with our presentation, sir. So for the faculty presentation, we have 8 presentations. So we request you to start with introducing yourself and then the topic. We also request the participants to stick on to the time. We have 6 minutes followed by 2 minutes for discussion. 6 minutes are available, followed by 2 minutes for discussion. The judging criteria based on which you will all be judged upon are the originality, the relevance to the practice, appropriate use of the PPT, presentation style, clarity, and answer to the queries. So again, I'll repeat, you will be judged on your originality, relevance to the practice, the appropriate use of the PPT, presentation style, clarity, along with answer to the queries. I hope I'm clear. So and our judges for the session will be Dr. Framington Marak and Dr. Sitalal. Dr. Framington Marak is the Vice President of Medical Legal Association of Pondicherry. He is also the Professor and Head of the Department of Indira Gandhi Medical College and Research Institute, Puducherry. Dr. Sitalal Rathod is the General Secretary of Medical Legal Association of Pondicherry, and he is also the Head of the Department of Forensic Medicine at Sri Lakshmi Narayana Institute of Medical Science, Puducherry. Happy to have you both, sir. Thank you so much for the support across the presentations and across the conference too. Sir, if you both are okay with it, we'll go ahead with the presentation.
Okay, ma'am.
Okay, thank you, sir. So the first presentation will be by Dr. B. Ajoy Kumar Josh. He'll be presenting on mutilation of body, intentional or accidental, a case report. Over to you, Dr. Ajoy.
Good evening, sir. I'm Dr. Ajoy Kumar Ghosh, working as assistant professor in Department of Forensic Medicine and Toxicology, Government Stanley Medical College. So today I'm here to present a case report on mutilation of body, intentional or accidental. So coming to the case report, the disease was last seen alive on 11th November of last year, and on 16th November, his body was recovered from nearby sewage canal in a decomposed state. So the history given by the police is the person used to visit regularly the scene of occurrence. He used to have alcohol near the sewage well along with his friends. So the body was identified by the relatives. So this is a picture of the sewage well near his location, and this is a body found floating in the sewage well. So in this picture, you can see that glasses used to consume alcohol, which is a place of they used to consume alcohol in that place. On external examination, this is a body which we recovered. You can see that the body is completely decomposed with peeling of skin all over the body. And you can see the amputation of left leg and right lower limb amputated at the level of thigh. There were also multiple cut injuries in the body, which I will discuss in the coming slides. So on external examination, there was decomposition changes like peeling of skin, protrusion of eyes, loosening of scalp hair, and there was diffuse marbling and grease discoloration of skin. So on examination of the back, there was a cut injury of size 30 cross 20 centimeters. Because exposing the thoracic cavity, there was rupture of diaphragm, and the right lung was not found in situ in the body. Only the left lung was present, and there was also a rupture of fracture of scapula and the underlying ribs. So left leg was amputated below knee with the length of 30 centimeters. The margins were irregular. The right thigh was amputated at the mid thigh level, and the skin, there were irregular skin tags were present. On the right forearm, on the posterior aspect, on the outer aspect, we were able to find cut injury of size 7 cross 6 centimeters in the bone deep with underlying fracture of ulnar bone. So on the right arm, there was a cut injury of size 12 cross 6 centimeters bone deep, and it is noted over the outer aspect of right arm. So on internal examination, there was a rupture of right side of diaphragm, and the lung was not found in situ. All other organs were decomposed, which were appearing soft and flabby. There was subscalpal contusion and pericranial hemorrhage over the occipital region. And on opening the skull cranial cavity, the brain was found liquefied. So on examining the gluteal region, there was a contusion of size 6 centimeters, 6 cross 5 centimeters over the left gluteal region. So the investigations which we done were the histopathological examination. We sent skin bits from all the injuries from the margins of the wound to rule out whether it is antemortem or postmortem. But the report came as autolysis because the body was decomposed, found a decomposed state of for around 5 to 6 days. On viscera, chemical analysis of viscera, it was, alcohol or toxin was not detected. On making a crime scene visit, we were able to find an iron pipe which is used to pump out the water from the sewage canal. So this is the iron pipe. So this is a schematic representation which indicates that the depth of the well was 10 meters, and the inlet of the pipe was placed at a height of 2 meters from the base, and this is the outlet. So the inlet is always immersed inside the water level. So the inlet of the pipe was fitted with suction motor which had heavy blades in it, and the diameter of the inlet of the pipe was around 20 centimeters. So in this picture you can see the inlet had heavy sharp cutting blades inside. So coming to the discussion part, we consulted with the technical person, that is assistant engineer of the department. He told that there is a suction motor which is fitted inside the inlet of the pipe, which works with the 40 horsepower and it has a high negative suction pressure. The diameter of the inlet was 20 centimeter, whereas the diameter of the human thigh is around 16 to 17 centimeters. So there is a high possibility of getting entangled, and it can get chopped. So this is a representation of a vegetable chopper in which we usually give pressure from upwards, and there is a blade rotating continuously. So this motor works in the similar mechanism where the pressure negative suction applies from lower to upper end, and that is a continuous blade, heavy blade rotating inside it. So due to motion changes, we were not able to clearly differentiate whether the injuries were antemortem or post-mortem injuries, because there were no visible features like extravasation of blood or blood clot found in the contents of the wounds. On doing histologic examination, we are not able to define any vital reactions such as inflammation. So we are not able to clearly demarcate the cause of death between drowning and sharp force injury, because the organs were almost every organs were decomposed, and the lungs, right lung was missing due to rupture of diaphragm. The manner of death could be accidental fall into the well, or it can also be homicidal, which also we cannot conclude based on the autopsy findings. So the conclusion is amputation injuries are commonly found in train traffic accidents and air crash injuries, or in cases of homicide due to aggression or to hide the identity of the individual. But it is unusual to find in a drowned body, which raised us with the suspicion of homicidal mutilation of the body. And doing a crime scene visit along with relevant information, receiving relevant information from the technical person, helped us in finding the cause of amputation, that it can be due to accidental amputation of the limbs.
Hello, sir. Hello. Hello, sir.
Hello. I'm audible?
Yes, sir. Yes, sir, you're audible, sir.
Thank you, sir.
It would be better if you keep, you have kept the skin along with the fracture, bone stumps. The fracture, the bones would be better. You will get at least a procedure wise completed, what has sample to get, but it would be added a fracture stump or limbs, and where the fracture ribs you have mentioned, subjected to histopathological examination. Would get better pictures whether injuries perimortem or either side.
Yes, sir, I'm not. It's not very clear, sir. I'm not getting you, sir.
No, now it's clear. I'm
yes,
audible.
Sir, yes, sir. A little bit clear, sir.
Hello.
Yes, sir. Yes.
Hello.
Yes, sir. I'm able to hear you, sir. Yes, sir.
Yes, sir. Yes, sir. You're audible, sir. Yes.
Hello.
Yes, sir. You're audible, sir, but the voice is not clear, sir.
That is a bone fracture. Bone stumps would have been saying that would be better. You will get a result of perimortem, antemortem, or postmortem.
Yes, sir. Yes. In this case, we sent to only skin bits. Skin bits from the.
Yes.
Hello.
Yes, sir.
Yeah, I have a question. You have mentioned about bone depth.
Sorry, sir.
You have mentioned about bone depth.
Bone depth, yes,
Bone
sir.
depth.
Yes, sir. Yes, sir.
What do you mean by that?
So the
Can you explain it to me?
So the cut injury was exposing the underlying bones, sir. And some injuries were also involving the fracture of bones, like femur and ulnar bones were fractured, sir.
You said cut fracture, huh?
Sorry, sir.
You said cut fracture.
Yes, sir. It has caused fractures, and the right lower limb was completely, both the lower limbs were completely amputated, sir.
No, you said cut fracture. Is it a cut fracture or some other fracture?
Yes, it was due to the chop injury caused by the suction motor, sir. There was heavy blades inside the motor causing the cut injury.
Okay.
It has caused the fracture also, sir.
The bone, or there is fracture of the bone also?
Yes, sir. Bone depth is up to reaching the level of bones only, sir. It does not. It may not include fracture of bones, sir.
Yeah, no question from my side.
Thank you, sir.
Thank you so much. The next will be Dr. Arpan Kumar Pan, Senior Assistant, ANIIMS, Port Blair, Andaman and Nicobar. Sir? Sir, can you please join? Thank you, sir. Thank you
Yeah,
so
I've joined.
much.
Am I audible?
Yeah, yes, sir. Thank you so much. Sir, you may proceed.
I am not enabled. The screen sharing is not enabled.
1 second, sir.
Hello, Dr. Arpan. You're having a Mac device or a iOS?
Windows only. Windows only.
Okay. Just let me check. So you should be able to share now. Can you try again?
It is still saying the host has disabled the participant to host screen sharing.
Okay, but you are the co-host.
No, I am not yet co-host yet. Yeah, now I am co-host. Yeah,
Okay.
now I am able to.
Okay. I apologize for the delay.
Okay, no issues, ma'am. Thanks. Is my screen visible, ma'am?
Yes, good. Good to go, Doctor.
Okay, thank you, ma'am. Good afternoon, everyone, and good afternoon, dear judges. Today, myself, Dr. Arpan Kumar Pan, Senior Resident in the Department of Forensic Medicine, ANIMS Port Blair, is going to present a talk entitled A Critique on the Criminal Procedure Identification Act 2022, a necessity or violation of rights. So I will be this is the overview of my presentation. So I will be going through what is new in this law and why this law was needed in first place, and the implications and significance of this act, and the issues which are arising of it, and what is the way forward now. Coming to why this was in news. It replaced the Identification of Prisoners Act 1920, a colonial era law, and now empowering the police officers to take measurements under Section 53 of CRPC of people convicted, arrested, or facing trial in criminal cases. The measurements which can be collected now includes fingerprints, palm prints, foot impressions, and photographs, iris and retinal scans, physical and biological samples, and even behavioral attributes like handwriting, signatures, voice samples, etc. Now the data storage is entrusted at the national level with the National Crime Records Bureau, which can store the data up to 75 years, preserve it, share it with the law enforcing agencies, and also destroy the record once the accused is acquitted from his crimes. Next, why was the law was needed in this place? So a Law Commission of India recommended several amendments in 1980, which mainly with the expansion of scope of measurements to be taken to include palm prints, voice samples, etc. Several states also made numerous amendments which reflected need for a change. Coming to the implications and significance of this new law. Firstly, the implications, it allows unique identification of those involved in crime and helps investigating agencies to solve those crimes. And any persons convicted, arrested, or detained under any prevention detention law will now be required to provide measurements, which raises the questions of privacy and ethical consideration. What is the significance of this act? It allows modern techniques so that we can cope with advancing forensic science and help the investigating agencies by broadening the ambit from whom the measurements can be taken, and to provide sufficient legally admissible evidence to establish the crime of the accused person, and to allow for efficient investigation and thus increasing the conviction rate. What are the issues with this new law? First and foremost is the issue of privacy, as it infringes the right to privacy under Article 21, not only of convicts of a crime, but also of every common Indian citizen. It even permits sample collection from the protesters who are taking part in political demonstration. Any obstruction in measurement taking will be punishable under the law. There are ambiguous provisions in the law, such as the phrase biological sample is not further defined, which raises worries about personal intrusion such as extraction of blood, hair, DNA samples, and tests like narcoanalysis and brain mapping. It also violates the subsection 3 of Article 20, which protects against right against self-incrimination, that is, to witness against himself or herself. Who can collect the data now? Now the rank of police officer who can take measurement is lowered from sub-inspector to head constable level, and even head warden of a prison can take the measurements. Coming to data handling concerns, now the preservation is up to 75 years, which raises concern about the preservation, sharing, dissemination, and destruction of such data. Mass surveillance of the person who are in database can happen, which can be combined with other databases. There may be unawareness among the detainees, like the detainee is not accused of an offense against a woman or child, may not know that he have the right to refuse biological sampling. Police also may ignore such refusal and claim consent was given. What is the way forward now? For collection of such data, a strong data protection law should be in place, which should have a strict punishment for any data breach. And we should not deprive our law enforcement agencies to use the latest technologies to fix criminal responsibility and deliver justice to the victims of crime. And so a better implementation of law should be there. As we speak now, a new data protection bill is already tabled for discussion in the monsoon session of the parliament. What are the resources required? More experts are required to collect measurement from the crime scene, and more forensic labs and equipment need to be set up for the analysis. These are my references. Thank you.
Can you show your references?
Yes, sir. Is it visible, sir? Is it visible, sir?
Okay, okay. Yeah, thank you.
Thank you.
Okay. Yeah, what is the reason for choosing this topic? Any idea?
Since this is a new law, sir, so many are not aware of it. So I wanted to create awareness among our peers through this presentation.
Yeah, they have said to preserve that digital format for 75 years.
Yes,
Any
sir,
reason for
NCRB.
choosing 75 years?
So they these terms they have not explained it why for 75 years and also just they have mentioned the storage is now with NCRB to maintain, and if the law agencies need, they may be shared with it. Hello, sir.
5 years, yeah, it's a very long years.
Yes, sir. Yes, sir.
In 75 years, we have new technologies coming up.
Yes, sir. So
Is it
this
possible
also raises the
to preserve
concern
it
that
for
if
75
data is
years without
protected.
any, I mean, will it be possible practically to preserve 75 years?
If they are using cloud data systems, sir, it is possible, sir.
How safe is the cloud?
Cloud storage of the data, then sir, it is possible. But it also raises the risk of some cyber attacks. So data may become public also. So this is the concerns also, sir, with such long period of preserving the data. Hello, sir. Hello, am I audible, sir?
Sir, you are audible.
Any other questions, sir?
Hello, sir. Yes, sir. Is the session over?
Any other questions?
Yeah, no
Okay, sir.
from my side. Sir Sitalal.
Thank you, sir.
Thank you so much, sir. Thank you, sir.
Can I
The
stop my
next-
screen sharing?
Yeah, yes.
Okay.
Thank you so much.
Thank you.
The next will be Dr. Dilip Vaishnav, Assistant Professor, Department of Forensic Medicine and Toxicology, Government Medical College, Hospital 32, Chandigarh. Sir. Sir, Dr. Dilip Vaishnav.
Hello. Hello.
Yeah, yes, sir.
Yeah. Am I audible?
Yes, sir.
Okay, I'm ready.
Okay, sir. Now we can join. Sir, now you'll be able to share the screen.
Okay.
Can you?
Okay. Is it visible?
Yes, sir. Yes. Thank you.
Good afternoon, sir. I am Dr. Dilip Vaishnav, Assistant Professor in Department of Forensic Medicine and Toxicology, Government Medical College and Hospital, Chandigarh. I am presenting a case of suspected case of Bader baby syndrome, which was resolved by histopathological examination of the fractures. So what happened actually is that we got a case referred from civil hospital. It was a 13-month-old girl who was brought to trials with shock and respiratory distress with alleged history of fall from bed 3 days back. So there was a history of progressive abdominal distension and dyspnea since last 3 days, and multiple episodes of vomiting and fast breathing and cold extremities since last 1 day. So on examination, like PLR was evident and vitals are like this. Her GCS was E4, V3, M4, and an emergency X-ray test was done, which showed a right third rib fracture in the anterior side, and there were also some callus on the 4th, 5th, and 6th rib along the posterior X-ray line. However, the USG abdomen did not reveal any obstructive pathology. So the child was diagnosed as a case of refractory septic shock with septic ileus, with polytrauma, and with query battered baby syndrome. And but the child could not survive for much time. She just succumbed to her injuries within 11-12 hours of her arrival. And a medical legal autopsy was done. With the police papers, we got this medical file in which there was an X-ray which showed the smooth nodular enlargements, history of callus, which was present on the posterior aspect of 4th, 5th, and 6th rib, which was evident. And on the when we started the postmortem, on the external examination, the abdominal distension was quite evident. There was one reddish abrasion, 1 cross 0.8 centimeter size, was present over the left side of the chest, 4 centimeter below the left temple. And another a reddish contusion was present over an area of 5 cross 4 centimeter in the front of right side of chest. On exploration, the right third rib was fractured, and with the extravasation of blood in the surrounding tissue. Can be seen in this picture. And on opening the abdomen, you can find about 800 ml of stroke. After this, when we opened the scalp, it was a shocking revelation of some this blackish contusion of person. Actually, these were two which were merging into each other. 6 cross 5 centimeter and 6 cross 4 centimeter, which was present over this frontal bone. And these are pictures of after the histopathology examination. I'm just showing to save the time. So this was the fresh picture of the brain, edematous, typical varus pattern, such as neurotic tonsil herniation was more evident in this fixed brain. And on cut section, we also found some particle hemorrhage in the cerebral hemispheres. This is pictures during the autopsy when we could find some nodular enlargement at the 4th, 5th, and 6th rib in the posterior X-ray line. And this is the fixed portion of rib after formalin fixation. So coming to the histopathological examination, all the organs were subjected to histopathological examination in this case, including the fracture sites. So on the the third rib, it showed the hemorrhage, peristral proliferation, scanty inflammatory infiltrate, and increased osteoid production, which was a history of flash fracture. And third, 4th, and 5th rib, the section from the callus point was there was prominent osteoblastic activity, woven bone formation, and bony trabeculism cartilage nodule, which was a history of new bone formation. Also, we took sections from skin. So the scalp skin showed important findings like flattening of the epidermis, and sections from abrated skin was also examined, which showed hemorrhage in subdermal tissue and varicose inflammatory infiltrates. Coming to this part of the bone, we with the periosteal thing, it was examined, and section from this frontal bone with periosteal. It showed the dense fibrosis with no proliferation, which was a history of mature collagen. And there was also new bone formation, evidence of new bone formation, which suggests that there is a united old fracture. So the cause of death in this case was opined as cerebral damage consequent to blunt trauma to head. And the nature of injury was given as the homicidal nature of these injuries cannot be ruled out. So after this, the receipt of the author's opinion, the IO further probed the case, but the parent insisted that the child didn't meet any other explained injury or assault other than the fall from bed. So IO further seek our opinion regarding the possibility of these injuries being caused by fall from bed. But considering the pattern and age of the injuries, the author opined that the possibility of these injuries being caused due to fall from bed is highly unlikely. So on getting this lead, the IO further investigated the case and got this picture that the mother revealed that actually her husband suspected her of and due to that, like regular fights were happening in the couple, and it was not uncommon that the deceased also got some injuries during this fight. So during one such occasion, the deceased fell down from her head in a head down position, and in another, the husband was assaulting her, and the deceased also got some blows on the chest and abdomen area by the foot. And after this, like in the last episode, the child started crying inconsolably, and this is the our opinion regarding the age and nature of these injuries and whether these injuries were inflicted at the same time or at different times. So based on the histopathological examination, we find that the fracture of anterior segment of third rib was 2 to 3 days old. Callus of posterior segment of rib 3, 4, 5 was age of like 1 to 2 weeks. And the periostal hematoma present over this cohort was like more than 28 days old. So like coming to the discussion part, sir, the battered child syndrome is defined variously in the other books, like the collection of injuries sustained by the child as a result of repeated mistreatment or beating, or non-accidental injuries sustained by child as a result of physical abuse, usually inflicted by adult caregiver. So if we sum up all these definitions, we could find that main constituents of battered baby syndrome are that victim is a child, like that is less than 18-year-old. The perpetrator is an adult who is responsible for the care of this victim. The victim has sustained multiple injuries, and the fourth that these injuries were sustained during different episodes of physical assault over the course of time. So we can see that the first and second are a matter of fact. Third can be seen during the during physical examination by a physician. But the fourth point, this fourth point is very tricky, that whether these injuries were sustained during different episodes or not. So to decide on this part, like whether these injuries were sustained during a single or multiple episode, we have to decide on the age of each injury. Sometimes it may be obvious, but sometimes it is occurred. So in present case, this similar situation was faced by us, and we resolved this dilemma with the help of histopathology. So in summary, this 13-month-old girl, which was brought to pediatric emergency in shock and respiratory distress, and with a history of fall from bed 3 days back, but subsequently she died, and on medical legal autopsy, successfully opined that hello, yes, hello, am I audible? Hello.
Yes.
Yes, sir. Yes. You're audible,
So,
yes, sir.
thank you. So after this medical autopsy, including histopathology, we could successfully opine regarding the age and nature of the injuries, and also clarified that these injuries were inflicted at different times. So this case report basically emphasized the importance of histopathology in aging of injuries and the consequent diagnosis of battered baby syndrome. Thank you.
Histopathology. Hello.
Yes.
This
yes.
is Dr. Rathod.
Yes.
Histopathology section, the processing histopathology, you have done, or you send the tissue to histopathology department?
Sir, we have done it, sir. Ourselves.
It would be very happy to see your slide in this, but I didn't see any slide included photo snaps of that histology section.
Sorry, sir. That is like one technical mistake in my presentation. I couldn't incorporate that.
I will be happy to see your histology section picture, snapshot. That's
actually
that
right
expected.
now.
Okay.
Yes, sir. Yes, sir.
Okay.
Right
Okay.
now,
Okay. But no, you did very good. But
yes,
would it be? It is a presentation, so I
Yes,
expected
sir.
you will add. Okay. Thank you.
Yes.
Yeah, I agree with Dr. Rathod, because your topic itself is histological aging of fracture. So it would have been good if you could show some pictures of histological findings, and if you could explain a little bit on that. Another question that I have is, any punishment for battered baby syndrome? I mean, battered baby or cruelty to children in India? Hello? Can you hear me?
Sir, Dr. Dilip Vaishnav. Sir, are you there?
Some issues there. Hello. Hello.
Sir, there's a glitch with his network, it seems, sir.
Maybe, yeah.
So let's end this session. Okay, sir. Thank you so much. And the next will be Dr. Nirmal Kumar, Senior Resident, Department of Forensic Medicine, Jitmar, Puducherry.
Ma'am, am I audible?
Yes, sir.
Ma'am, I'm not able to share the screen.
Yeah, now you will be able to do sir. Yes. Sir, now you're a co-host. Now you'll be able to share the screen.
Are my slides visible?
Yes, sir.
Next slides are visible, right?
No, sir, it's a blank slide.
I'm not able to share screen. One second.
Dr. Nirmal, do you have a
No, ma'am, it's normal Windows only, ma'am.
Okay.
I'm having some technical issue.
Okay, so sir, would you like to send the PPT to us so we will share it from our end?
Yeah, ma'am, sure.
Okay, so you can mail it to us. By that time, we will go in for the next presentation.
Yeah.
Dr. Kashif, you're there?
Yes.
Okay, sir, I'll just make you the co-host. KASH. Yes. Yes. Okay. Dr. Kashif, you're the co-host, so you should be able to share now. Dr. Nirmal, can you mail it to us at forensicmedicine? Yeah.
Yes, ma'am. I'll just share.
Thank you. Dr. Kashif?
Yes.
Yeah, you should be able to share now. Yes, Dr. Karif. Yes, your slide is visible, you're loud and clear, and you're good to go.
Good afternoon, everyone. Myself, Dr. Kashif Ali. I'm Assistant Professor, Department of Forensic Medicine, Jawaharlal Nehru Medical College, AMU Aligarh. And today, my presentation topic is about counterfeit gunshot wounds, that is fabricated gunshot wounds, means uncovering the truth, medical legal challenges in identifying counterfeit gunshot wounds. Coming to the introduction part, now what a fabricated firearm injury is. So it refers to a self-inflicted superficial gunshot wound that has been intentionally created by a person on his own body or occasionally caused by another person acting in agreement with him to give the impression that the person has been shot or injured by a firearm by some alleged individuals. Now, why these fabrication or counterfeited gunshot wounds are done? So the reason for it are usually first to establish a false charge against another person with an ulterior motive, to accuse an enemy for an assault or attempt of murder, to make simple injury appears serious or grievous, and to avoid arousing suspicion. So in today's environment, self-inflicted or fabricated injuries are increasingly widespread in order to benefit from false charges. And they are typically found on accessible body parts rather than in delicate places like eyelids, genitalia, nipples, face, and the vital body parts. Coming to material and methods, so it's a prospective hospital-based study. Time period was of 4 years, that is from October 2018 to September 2022. It was carried out on patients who presented to trauma center with alleged fabricated gunshot injuries. After that, a detailed history was taken, and after examination, data was entered on the pre-designed data sheet and tabulated. Coming to results, age group, the most common age group found to be was 19 to 30 years and 31 to 40 years. That is between 19 to 40 years, most of the cases were there. And among male and female, 41 were males and 12 were females out of 53 cases. Coming to the place of residence, 42 were from rural background and 11 were from urban background. Coming to occupation, so since 12 were females, so all were homemaker, and among males, the most important occupation means they were unemployed. And the next came, they were farmers. 8 were farmers and 17 were unemployed. Coming to the body part on which these fabricated injuries were present. So most of them were present over the extremities, that is upper limb and lower limb. That is 16 and 18 cases respectively. And there were no fabricated injury, gunshot injury over head, face, and chest. Coming to the management part, all 53 cases were admitted and conservatively managed. None of them was operated and none of them was fatal. Coming to the discussion part, so in this short period of 4 years, 53 cases of counterfeit gunshot wounds were there, which depicts that the foul play is at large scale. And these cases are usually coming from a particular area. So usually all these cases means approximately 90% of cases were coming from a particular area, that is Etah, Kasganj, all those district of Uttar Pradesh. And these all gunshot wounds are either just touching the body or targeting the extremities, thereby not coming in contact with the vital organs or part of the body. So this is not a common phenomena. And if it's occurring again and again, then suspicion arises or something is happening on a large scale. Just think, if 53 cases coming to a single hospital of one district, then think of the magnitude of cases in other hospitals. So these are other researchers whose findings were similar to my findings, means male predominant and 21 to 40 year age group, upper limbs were affected. They were coming from rural background or the agriculture sector. Now coming to conclusion, the collaborative efforts of all the investigating agencies and medical professionals can help to prevent the fabrication of injuries, which will not only decrease the needless court cases, but also eliminate the unwanted harassment of innocent people. Now, what are the medical legal challenges? So first of all, it is crucial for forensic professional to recognize and record the precise anatomical location of the injury on the body, their size, direction, and conduct a thorough examination of the victim's clothing and take into account their medical and psychiatric histories. It can be challenging to spot fabricated injuries if they are inflicted by a person with medical training, especially if local anesthetics or surgical equipment were used. Even in few cases, these people are taking help of some professionals who are lodging those pellets into them, or they are just making fake wounds, fake gunshot wounds. So they are taking help of, even professionals are there. These were told by the police people. So in each of the cases we examined, the lack of tattooing and blackening in the presence of burning raised the red flags. And even when we sent those clothes to the FSL, so there was no presence of gunshot residue or gunpowder. So the other factors which can be used to determine whether the injury is fake or not: first of all, variation in history with the findings, circumstantial evidences, and injury present on the easily accessible and non-vital part of the body. These are my references. Thank you.
I have one question for you, Doctor.
Hello.
Hello. May I ask you a question?
Yes, sir. Yes,
I'm Dr. Anil Agarwal.
Yes, sir. Yes, sir.
First of all, your talk was very good, and actually, I'm very interested in these fake wounds. So I was listening, and it was news to me that they're taking help of professionals. So I mean, I learned a new thing here. You have shown some wounds on the back also, and that actually immediately told me that they were taking the help of someone, because back is, as you know, is not an accessible area. But what I was most intrigued was that you say a very good point that there was burning but no blackening. And can we go back to that slide, please?
Yes.
I mean, if they are taking just one more, you said, yes. In each of the cases, we examined the lack of tattooing and blackening in the presence of burning. So this means these professionals, they were somehow producing burning, because if they were mechanical.
Usually, sir, what police was saying, like they are using some ice pick and they are heating it and then they are inflicting those wounds.
Oh my God. Is it?
Yes, sir. This is happening in this part of
you should have
district. In these districts, usually Agra, Aligarh, Kasganj, Etah, Etawah.
No, this is really interesting. I mean, you should have written it. It's a very good point. And I mean, this is new to me also. I've never seen these ice picks, you see, heating, and then because I mean, they took care to, they are anesthetizing the persons also, the locally, probably. Somebody was telling me they are anesthetizing them also. And
yes, sir. Yes, sir. This is also happening, sir.
And actually, I saw them because there's some needle marks I could see, which was just like a small hypodermic thing. So they are actually anesthetizing them. But I mean, this is very interesting. Of course, we have to ask them if they can go as far as burning them. They can probably do some kind of tattooing and blackening also, right?
Yes, sir.
But probably that will be too difficult. But very good talk. I really enjoyed it. Thank you.
Thank you, sir. Thank you so much.
Do you have any photographs of those?
Sorry?
Did you have any photographs of those cases?
Yeah. You should have given some photographs. Yes, that would have been lovely.
Yes, sir. I would have shown some photographs also.
Photographs, some findings. It would have been nice to see some photographs, because this is something which is not commonly seen. So it would have been nice to see those photographs.
Yes, sir.
In the date, on autopsy, we usually take wound of entrance skin that for the analysis, metallization. Did you think that it is a ice pick or maybe hot iron rod has been hit? So metallization, have you cross-verified? Sending. You think in this case, in such cases, if a person is dead, a similar case, and died.
Actually, sir, they are using like even they are using metal rods also.
Huh.
Everything they are using, ice pick or metal rod,
Okay,
or
okay.
all those things, but they are just heating it and just they are making it wounds.
No, we should have to find offending weapon. So Locard principle, you have to search again in future.
Yeah,
and give the clear picture. What is it? It should not be hearsay, has been used. We have to prove. Huh?
Okay, sir.
Thank you.
Okay. Thank you, sir.
Like this counterfeit you are telling, it is a criminal offense, no? Creating a wound. It is a criminal offense. Do you agree?
Hello, sir. Yes, sir. Sir, pardon, sir.
This counterfeit gunshot injuries they are producing.
Yes, sir.
It's a criminal offense, isn't it?
Yes, sir. This is a criminal offense, sir.
Are we informing this information to the police, or we are not intimating?
Yes, sir. We are informing. Actually, police people are coming to our department for final opinion. Then we both are discussing, and we are then coming to a conclusion.
I mean, did they arrest anybody?
Yes, sir. They are arresting also. That's what they are telling, that these are professionals and they accepted it, that how they did all these wounds or how they inflicted these wounds.
Under what section they are arresting them?
That I don't know, sir. I think mostly, I don't know.
I think
next time I'll ask them.
I think creating false evidence, that is 303.
No, since it's a prospective
Yes,
study,
do agree.
I'm asking because that is something which we are interested in, because ultimately it is a punishment for the wrongdoers. So anybody who's doing wrong, they should be punished. So under what section they are punishing, that also is important for us.
303. I'm almost sure about it. It's producing false evidence. 301. Sorry, 201. CRPC or CRPC.
Yes,
right?
sir. What I'm saying is, I'm concerned with the presenter. It would have been nice if you could have information from the police.
But I would not test his knowledge. I would rather appreciate the knowledge that he gave me. But
I understand, sir. But what I mean is, since it's a prospective
yes. That's
we
a
need to go to the conclusion of it. That is why I'm asking.
That's a good question. But very good.
Thank you, sir. Yeah, no question from my side.
Thank you, sir. Thank you so much. That was a really interesting session with you, sir. The next will be Dr. Shravan, Senior Resident, Department of Clinical Pharmacology, JIPMER. Sir, Dr. Shravan?
Yes,
Sir,
ma'am.
you'll be able to share now. Yes, thank you.
Is it visible, ma'am?
Yes, sir. Yes, it's visible. Yes.
Thank you. So, good afternoon, everyone. I welcome all of you for my presentation on genetic impact on carbamazepine maintenance dose in epileptic patients, a medico-legal challenge. I am Dr. Shravan, a senior resident in the Department of Clinical Pharmacology, JIPMER. So this talk will connect all these three pictures. Like this is the DNA and the reports the clinicians get and why they are not practicing according to the based on the reports, because they get afraid of ethical issues. So this talk will include all these three aspects and how to resolve the medical legal challenges faced by the clinicians. So pharmacogenomics is the study of how variations in a patient's genetic profile determine their body's response to specific medication. So how is it an ethical challenge? The medico-legal challenge of the study results is that clinicians do not practice based on genetic knowledge due to fear of ethical issues. Rather, they practice based on the clinical experience. So carbamazepine is an anti-seizure drug used for seizures, and enzymes having a role in drug metabolism are coded by the genes. The common gene involved is EPHX1, which has a role in metabolism of the drug. So to study the influence of this genetic change on requirement of maintenance dose in epileptic patients. Epileptic patients were recruited who were on carbamazepine monotherapy, and after blood collection, the component was used for DNA extraction and genotyping. In that, we can find the which gene is involved. So there will be 3 genotypes, and the differences in the requirement of the dose of carbamazepine were done by ANOVA test. So P less than 0.05 was considered to be significant. So these are the results, and mean age was 30 years, and male were found to be predominant in comparison to female, and the requirement of dose was 600. We didn't find any influence of this genetic polymorphism on the requirement of the dose, because all the 3 genotypes were found to have the same requirement of the dose. So discussing, we did not find any association. So 2 disciplines will be impacted, and that will be physicians as well as pharmacists. So physicians' liabilities will remain the highest because they prescribe medications, and there holds a standard of care which is practiced by all physicians. So from a legal perspective, the acceptance and use of pharmacogenomics is likely to result in legal liability of physicians. So physicians they should utilize the most accepted and evidence-based practice to treat, diagnose, and inform the patients regarding the risk-benefit profile. So physicians face challenges to stay up to date on the latest developments in pharmacogenomics indicated medication use. So what are the factors for physicians' liability is when he prescribes a drug without the warnings present in drug insert, that is drug label, and failure to test patients for genotypes that will lead to ADRs and misinterpretation of these results. So how are pharmacists liable? Because the courts treat pharmacists and base their negligence decisions on a professional standard, because pharmacists can also prescribe the medications and they are directly involved with patients, and they should also have a knowledge on these results. So how to resolve? The clinicians may need assistance from genetic counselors to explain the need and results of genetic testing. Lab reports should be in a form that is understood by an average clinician without training in genetics, and electronic medical records. This is to minimize the liability of pharmacists so that they need not fill the prescription form. So everything is available in electronic base. So to conclude, the study did not find any association between the gene change and requirement of dose, and managing liability risk will be a key factor, and failure to implement these principles will lead to substandard care of treatment, since this field is developing, and the clinicians should update their knowledge to prevent the risk of physicians to ethical issues. So these are my references. Thank you for the opportunity.
Dr. Shivan, may I ask you something?
Yes.
This is a very interesting paper. I mean, you mean to say you did genetic analysis on all these cases?
Yes, sir. Genetic by RT-PCR we did genetic change. So which there will be CC, CT, and TTs. So
no. I mean, I don't understand this. I mean, which college you are from?
JIPMER.
JIPMER. I've been to JIPMER. Have they got this facility to do you're doing sequencing, right?
Yes, sir. Not sequencing, sir. By PCR machine will be analyzing the results, sir. Genetic results.
No. PCR will only duplicate the gene. That's all. Ultimately, you have to do the sequencing. Otherwise, how would you know this is the? Let us go back to the name of the gene. How did you know it's that gene? Have you done it yourself, or did you ask somebody else to do it?
No, sir. We did, sir. But that gene from the literature, we will be knowing
No,
that.
no, no. Let us go back to the gene name. Let us, even I don't know the name. This is a genuine question. This is EPHX1C. This
Yes,
is
sir.
a gene, right?
So this SNP will recruit, will
Well,
get
look
it
here.
from
You're
the
talking
companies.
about. No, no, no. You're not getting me, or probably I'm not able to understand.
Yes,
Explain you
yes,
well.
yes.
You know, you are talking about short, this nucleotide repeats or whatever SNP polymorphisms. You can't know this until unless you have done sequencing. And you said we have not don't do sequencing. I mean, this doesn't gel with me at all.
No, sir. Actually,
you know the meaning of sequencing. Sequencing is knowing the base pairs, all the base pairs. Okay.
Yes, sir. Yes, sir. Yes.
Until unless you know all the base pairs, how are you going to know that this gene is there or not? That's my problem.
Okay, sir. Okay, because
have you no. I mean, I yet to see a medical college who does gene sequence. I mean, sequencing. Certainly, MAMC is not doing, where I taught for 45 years. So, and JIPMER, I have been there 2 or 3 times. It also doesn't do it. Did you get it done from somebody, some other place? I mean, if that is the thing, then I am ready to believe you. But otherwise, it's simply unbelievable.
No, sir. Actually, we did on SNP, sir. Like single nucleotide polymorphism.
How do you know single nucleotide? After all, that's also a base pair, right?
So that gene, SNP alone will get it from the outside companies. Sir.
Yeah, that you should tell me that. I mean, have you said that in materials and methods?
Yes.
Let us go back to, probably I missed that.
Okay. No, sir. Actually.
Because this was, I mean, I was astounding. I mean, you are doing sequencing. I mean,
actually,
such a young boy.
So
see, you simply say that we are collecting the blood and then we are extracting genotyping. You never mentioned here that a company has been used for it.
Okay.
Yes, you have to mention it, because it gave me the impression. I mean, from this point onwards, I was amazed. I said, now this boy is doing something very good. So you took somebody else's help. Okay.
Yes,
You should mention that.
Actually,
no
through
problem. No problem. No. I'm not here to put you in any. I only want to understand this. Thank you.
Thank you.
You did your statistics by yourself, or you took help from statisticians?
Yeah, that is also a problem, because I don't know any statistics.
Statistics, I did on my own.
Pardon?
Through SPSS software.
You did yourself.
Software itself, software itself cannot help. I mean, let us be very fair. Software itself cannot help you. You always get it done from a statistician.
Yes. Okay.
You need a statistician, because you are going to give a
conclusion for that. That's a problem with us, actually. We should be learning and teaching more statistics, actually.
Can you sort of slide the p value, something you said, no?
Yes, that statistics slides on. Yes, this one.
Yeah, static analysis you were telling, no?
Yes. So this was done by SPSS software.
Software cannot tell you anything. Yes, software cannot tell you anything.
We can use software. There is no this one, but it is always nice that we have a statistician's opinion, and they give a final, say on that. And that is the right way of doing it, because you're doing a study and you're coming to a conclusion.
Yes.
On that. So it's always good that we have a statistician opinion in that. Yeah, sir, if you have any questions, sir. Sir Athur? Yeah, no more question from my side. Yeah, Sir Athur also doesn't have questions. Thank you. Yeah.
Thank you. Thanks.
Thank you so much. Thank you so much for the session, sir. The next one will be Dr. Kritika Ravi, Senior Resident, Department of Forensic Medicine, PIMS. Ma'am? Ma'am, you're on mute. Kindly unmute your video, please.
Ma'am, can you hear me, ma'am?
Ah, yes. Yeah, yes. Yeah, ma'am, you're audible.
Can you hear me, ma'am?
Yes, yes.
Am I audible?
Yes, ma'am, you're audible. Yes.
Yes, ma'am. I'll start sharing my screen, ma'am.
Yes.
Hello. Namaste, kaisa hai?
Ma'am, can you see my screen? Is it visible?
No, ma'am, not yet.
Now, ma'am?
Give me a minute, ma'am, please. No, ma'am, we can't see your presentation.
One second, I will screen it, will share it again, ma'am. 1 second.
Yeah, sure.
Ma'am, I couldn't share my PPT.
You got some problem with sharing the screen?
Yes, ma'am. I am not allowed to share because I couldn't share it, ma'am.
Wait, I'll retry from my side, ma'am. Give me a minute. Ma'am, now you're a co-host. You'll be able to share your screen now, ma'am.
Oh, 1 second, ma'am. No, ma'am, I couldn't share my screen again.
Okay, ma'am. Give me a minute, ma'am, please.
Hello, Dr. Kirtika.
Ma'am, I couldn't share my screen, ma'am.
No problem, no problem. Dr. Nirmal, are you able to share your screen now? I'll give it to Dr. Nirmal also, and by the time we'll sort it out.
Host
has disabled participants.
Yeah, yes. No problem, Dr. Kirtika. We'll just sort it out with you. Okay?
Okay,
Just
okay,
Dr. Nirmal, let him go. Yeah. Dr. Nirmal, you should be able to share now.
Yeah. It's a screen share.
Yeah, can you make it full screen? Yeah, Dr. Nirmal, 6 minutes. Yeah.
Yes.
Yeah, thank you.
A very good afternoon to all. I'm Dr. E.S. Nirmal Kumar. I'm Senior Research Department of Forensic Medicine Toxicology. I'm going to present a case report on the topic, sudden cardiac death, which actually mimicked. So this is the overview of the presentation, introduction, the case report, then we go to the discussion, then the conclusion and references. The sudden cardiac death, it amounts to 10% total mortality in India. Acute aortic catastrophes are rare and carry high mortality. Acute aortic dissection incidence is like 29-30 per 10 lakh population. The case of ruptured aortic dissection is more common among male and also the older individuals. There are lots of the case studies which is based on the hospitalized patient then by biopsies. I'm going to discuss a case of ruptured aortic dissection with a history of a suspected homicide. The case history was that a 30-year-old male on 11/11/2022 at 12:25 p.m. was found unconscious on his day of marriage at Hotel Villa Pondicherry. Police even gave a history of quarrel between deceased and his father on the same day. He was brought to Jupiter and he was declared brought in dead on 12/11/20 at 12:48 a.m. And as per the relatives, he had no history of any comorbidities, smoking or alcohol. The PM examination was done on 12/11/2022 at 3:15 p.m. at Jupiter. The external findings were the body length was 162 centimeter, weight was 55 kg. The conjunctiva were pale and could see the tachinode on both eyes. The natural orifices were free. Triangle motif was present throughout the body and the postmortem staining was straight. You can see a puncture mark over the left side of the neck, and we can also see bruising over the right side of the neck. No external injuries were present with the body at the time of examination, and we can see the seminal discharge. But moving to the internal findings, brain was paid and other parts of the head, including the vault, base of skull, were intact and fractures were. On opening the thorax, we could see around 1 to 1.5 liter of the clotted blood, and both the lungs were paid and the right lung was adherent posterior chest wall, and the ribs were intact, no fractures. The heart was paid, and this is the anterograde bleed into the thoracic the cavity. Had it been a retrograde bleed, it would have gone inside the pericardial sac, causing a cardiac tamponade. And this the picture shows the ruptured aortic dissection, and we can see the aortic root dilatation and the transcranial tear, which was 2 centimeters into the. And this hemorrhagic infiltrations were due to the non-ultrasound guided central line. And this is the extension of bleed into the subcutaneous and the muscular layers of the neck. The neck, the cartilages, the hyoid bone, and the cervical, the column were unremarkable fractures. Other internal findings. Heart showed isolated left ventricular hypertrophy of 2 centimeters, but the weight was normal. Liver, spleen, and kidney were pale, and other organs were unremarkable. Histopathological findings, it noted the dissection along the thoracic and the abdominal aorta with underlying hemorrhages. The chemical report came positive for alcohol in the blood, and it was 133 milligram percentage, and no other poison were detected. Moving on to the discussion part. This was a type 1 of genetic classification or type A of Stanford classification, and has an extensive involvement. And the Marfan syndrome, OSD syndrome, type 4 Ehlers-Danlos are the close associates. Yes, emotional stress is a precipitating factor, because when a person is having a genetic predisposition, the matrix metalloproteases plays an important role, and it will damage the aorta, and on exertion or some emotional stress, it will lead to acute hypertension and rupture of an early existing aortic dissection. Alcohol, excessive alcohol can cause acute arterial hypertension through the catecholamine surge, and it is known to promote aortic dissection, and it's ruptured also. Yes, this is a case report of an 86-year-old male, where we can see the pseudo bruising on the neck, and we can also see the extension of bleed into the neck as in our case, and this is due to the high pressure belt of aorta. The case opinion was that the cause of death was caused due to hemorrhagic shock as a complication of ruptured aortic dissection, and as cause of death, the time since death was given as 12 to 24 hours by examination. The conclusion will be ruptured aortic dissection leads to fatal bleeding. Our findings indicate the need for studies on the forensic aortic dissection death, so that we can promote the screening program and to prevent death in young individuals. These are my references. Thank you.
Doctor, what are forensic aortic dissection deaths? I couldn't understand that.
Sir, actually, the cases have been studied on the hospital patients. So like we don't have a database which is based on the autopsies. So in that I just mentioned as forensic article.
I would be very, I mean, I'm not very sure whether this real term should really exist. But anyway, I'll not press on that. You see, suppose this came to me, I would be very worried about those ligature marks. I mean, how do you explain that? Can we go back to those ligature marks? I mean, I would really not be. And of course, we have to face the lawyer in the court. What will we answer them? You can explain definitely the subcutaneous tissue that I understood. You said that the needle, they put some needle or something, that I can agree. But why, how those, I mean, can we go back? Yes, this one is okay, because you said there is some needle, but just let us go a few slides back. A few slides back, where clear ligature, I would have sworn that was ligature. Even this I can understand. No, this I'm not challenging this. This is okay. Let us go a little bit back. I saw two very clear ligature marks. This one is also okay.
We could not see any
this one,
mark.
this one. I mean, one more before this, figure 3 probably. Figure 3. Yes. Achha, this is puncture mark. Okay. Okay. I was seeing it as a complete this thing. And let us go to the next. Good. I missed this. Next one. Next one. Yeah, but I mean these things. But yes, I think I can go along with you now, because the puncture mark is here. Okay, but very good.
So we didn't see any.
Yeah. Right. Good. I agree with you. Very nice paper. Good. Good. I'm through. If somebody else wants to ask.
Did we have any past history of any illness or anything here?
No, sir. No, sir.
I mean, you
Actually,
find out that.
the police and also the relatives came, but no history, sir. And then, sir, we had a discussion with the pathology people, and they tell that this person can have some secondary disorder. Then because the media of the aorta had some disarray of the elements, so they were suspecting something, but they were not able to cut short whether it can be a Martin or like syndrome or anything. But they were suspecting this person who was actually healthy.
You discussed with them also. Okay.
Yes.
Yeah. Nice case. Yeah, no question.
Yeah, thank you, Dr. Nirmal. Sir, can we have our presentation from Dr. Kirtika?
I will now try sharing it, ma'am.
Yeah.
Thank you.
Thank you, Dr. Nirmal. Thank you. Dr. Kirtika, are you trying to share? Dr. Kirtika? You're muted.
I tried sharing it. Yes, ma'am. Now I guess it's possible, ma'am. You have allowed me to share my. Ma'am, you disabled me from sharing, ma'am.
No. Now you should be able to do it. Check it out again.
Yes, ma'am. Now
Yeah.
can you see PPT, ma'am?
Yes. Your PPT is good. You're loud and clear. You're good to go, Dr. Kritika.
Okay, ma'am. Good afternoon, all. I'm Dr. Kritika Ravi, Senior Resident from Department of Forensic Medicine, PIMS, Pondicherry. Today, I'm here to discuss few medical legal aspects of POCSO versus MTP Act. There is more to it than meets the eye. So a law can be amended based on the changing trends in the problem's existence. It can be either an addition or a contradiction to the existing one. So there should be a proper legal provision to follow such amendments. If at all, if there is no clear explanation, it leaves a gray area which invites a lot of confusion. One such is for today's discussion. So, for example, a sexual intercourse with a married girl of less than 18 years, which was exempted from rape law, and it is, of course, punishable and considered as an aggravated sexual assault according to POCSO. So, the Criminal Amendment Law 2013 says the graver punishment is to be chosen. So, today is all about medical termination of pregnancy, that is MTP versus POCSO in terms of minor pregnancy. So, before that, POCSO Act 2012 prohibits any form of sexual violence or intercourse with a girl less than 18 years, irrespective of the concern, is a punishable offense. And Section 19(1) mandates compulsory reporting of anyone who come across such cases to the legal system, and failing to do which, it is a punishable offense with imprisonment or fine under Section 21 of POCSO. And coming to MTP Act 2021, the Section 3B of MTP Act now has added special category of women, that is unmarried as well as minor girls who opt for termination of pregnancy. And also 5A under MTP upholds, it's directing the healthcare professionals to uphold the confidentiality of the women who terminates her pregnancy under this provision. So, harmonious reading of both together. Now, can it be concluded a registered medical practitioner on request of the legal guardian is exempted from disclosing the identity of the minor girl to legal system? Is it an overlap? So before that, what is the impact of such mandatory reporting? A study between, or a statistics between the 2021 of April and September 2022, about 934 sexual offense cases were reported in Mumbai city, out of which 83% were POCSO cases, and to our surprise, 19% presented with pregnancy. So it all came to light only due to mandatory reporting. And why are we so concerned? Few examples, like case one, a 16-year-old girl residing in a slum along with her siblings, and she was being abused by her own father. Even the mother was aware of such abuse. And she presented once to the hospital with an abdominal pain where the pregnancy was confirmed. But here the mother and daughter refused to report, because here if you see the proximity of the offender is being her own father. And case two, a 17-year-old girl staying with her schizophrenic mom, and she was being abused by her own uncle in the name of love. She had got missed periods and pregnancy was again confirmed. Her aunt here doesn't want to report because of the social stigma which they are supposed to face. And case three, again, a 14-year-old girl and her two younger sisters who lived in Mumbai with her grandparents for schooling. And she was being raped multiple times by a nearby shop owner for exchange of gifts. She also had missed periods, and her neighbor found her pregnant, and the girl even had very scared to report the case, because they all, together with the sisters, they all will be sent to their village, which will affect their education. So if you see all the examples, the mandatory reporting only had brought them to light. And if you see here, the offender being in close relation with the victim, as well as the family members here, they want to put down the case. But due to mandatory reporting, it all came to light. So what next? A significant judgment by Chief Justice of India and few other panel members in Supreme Court in the month of September 2022 had read down the mandatory reporting into a new one. A doctor need not disclose the identity of a minor girl while reporting to the police. Here, the clause, the exact verdict is not disclosing the victim's identity and personal details and exempt them at their request from any future criminal proceedings. This clause invites a big or huge ambiguity. Without identity and personal information, how will the case get proceed? in considering all these ambiguity, the Supreme Court has taken a big step because to reduce the criminal abortion as well as to reduce the maternal mortality. So here our medical legal challenge would be, if not disclosing the identity, how will this case get proceed? Or if not going for legal proceeding, what is the fate of such mandatory reporting? Would there be a threat for a continued abuse if the offender being close to the victim? So it's a double-edged sword by our Supreme Court, but there is more to it than it meets the eye. There is a real need in reviewing how these recent amendments are implemented and farce at the grassroots level. So we had a random discussion with our experts from Obstetrics Department PIMS. This gray area about reporting, few were not aware of this judgment first, and few did not know what it exactly means. Not disclosing identity and personal information is like what to disclose then and how to inform. And few, even despite of knowing the new judgment, they still follow and they disclose the identity of the victim. So our recommendations are sensitization among the healthcare professionals should be done, because this is a huge step despite knowing how important is this mandatory reporting. But still our government has taken a step to reduce the criminal abortion rates. So this knowledge gap should be rectified or will be rectified only when all plausible queries are sorted out. And various inputs are invited from all the experts, legal, police, and lawyers, and our healthcare professionals to know and to have a discussion to explore such areas to gain clarity. So here the act per se is punishable, but the products goes unnoticed. It's a question mark. So it has to be explored. I felt this will be the appropriate forum to have the discussion and to get clarity. Thank you. Thank you, ma'am.
No, doctor, I tell you, you are asking the wrong people. Obstetricians will not know any of this thing. Even I don't know about this judgment. And what I'm surprised is even you have not given me the reference. Otherwise, I would have noted down. Let us go back to the slide. You said a judgment, but is there a reference? I am saying I don't know of that judgment. So, and you are asking gynecologists. I mean,
no, sir.
They are not the right people to ask.
Yes, sir. I had included the judgment, sir, here.
Where?
I failed.
Okay, let me just copy it somehow. But I mean, I was not aware. This is not a judgment. You are giving me a site, you know. This is
Maybe
not.
I have quoted it wrong, sir. I'm sorry, sir.
No. You're not done anything wrong. Anything which I don't know, you're not supposed to know. But what I'm saying is, this is not the way you give references. I'm saying citation of the, like X versus Y, Supreme Court's decision, page number this. I mean, there's a proper way to cite it.
Yes, sir. Exactly, sir. I accept, sir. Yes, sir.
Are you sure? Because see, let us go back to those these things. I have just taken a screenshot of that. Otherwise, even I cannot note this site. I mean, this is, please, I mean, you've done a very good job, actually. I had, of course, this problem was known to me, but I was not aware of the judgment. Now, if you go further down, how can anybody note down these references? You know, these are.
Sir, I'm sorry, sir.
No, you don't have to be, because the lecture was good and I don't want to spoil it. But only thing is, we should have given it proper reference. But you really, it was an education for me, because I didn't know this judgment at all. So hats off to you. You don't have to be sorry.
Sir, I apologize for not giving the judgment properly, sir. But I will share it in the official group shortly, sir. I'm so sorry, sir.
You don't have to apologize, my dear. You have done a very good job. If my impression is that I'm trying to put you down, I'm sorry. It's a beautiful job. The only thing is, had you given me the reference, I would have noted it down. You just send it to Aarti. Aarti will send it to me, okay?
Yes, sir. Yes, sir. Within some 10 minutes, I will send it, sir. I'm so sorry.
It was very, no, you don't have to be, my dear. You don't have to be. You've done a very good job. Thank you.
Thank you, sir.
Thank you, sir. Any questions from the judges?
No question from me.
Okay. So we'll go ahead with the next presentation.
Thank you.
Thank you, Dr. Kritika. Dr. Senthil Kumar. Yes, sir. Sir, you should be able to share the screen now.
Yes, ma'am. I'm just sharing.
Yeah. Senthil sir, you should be able to share now.
Is my screen visible, ma'am?
Sir, not yet. Yes, sir. Yes, it's loading
Yeah.
in. Yes, yes, sir. The screen is visible. Yes, the screen is visible. Your audio is also good. You're good to go, sir.
Thank you, ma'am. And I'm myself Dr. B. Senthil Kumar, Associate Professor in Anatomy, and here to present the topic, evaluation of knowledge and attitude on ethical issues in the storage and reuse of human biological samples in biomedical research in the research institution. For many decades, access to human biological samples and for use in biomedical research has been central in understanding the nature and transmission of diseases across the globe. Many countries have regulations and guidelines that guide the use and exportation of stored biological samples and data. However, there are many variations in regulations and guidelines governing the reuse of stored biological samples and data. Moving on to the need for the study, as emerging innovation in the field of genetics, genomics, and biotechnology increases, the value of biological samples and data creates greater demand. So a knowledge regarding the guidelines governing the reuse of stored biological samples and data are very essential for every researcher nowadays. And this urged us to do the study. So the objective is to evaluate the knowledge and attitude on ethical issues in the storage and reuse of biological samples in biomedical research among the researchers. And my secondary objectives includes to identify and describe whatever the ethical issues they come across in the storage and usage, and to make further recommendations that will protect the research participants as well as benefit the biomedical research community. The study was approved by the Institutional Ethical Committee, and this is a cross-sectional study. A quantitative analysis was done among the researchers of three colleges in and around the Salem. 45 researchers were recruited for the study, and they were divided into 3 groups by convenient sampling method. Group A includes 15 researchers, Group B includes 15 research supervisors, and Group C includes 15 institutional ethical committee members. The knowledge regarding the ethical issues behind the storage and reuse and exploitation of biological samples and data was evaluated using a standard questionnaire by the pre-test from the above 3 groups of people. After the evaluation, the following ethical guidelines on the reusage of human biological samples were explained to the groups by a detailed presentation after the survey. So this is a chapter which is there in the ICMR guidelines, which gives clearly how the biological materials and biobanking and data sets and how the biological samples has to be stored and reused. And this presentation was made in detail, and the participants after the presentation. So this is a questionnaire which includes the knowledge. It is around 10 questions which were asked, which has a scoring with the S for 3 and 2 not clear and 1 for no. So this is going to assess the knowledge, what they have regarding the biological sample storage and reuse. And the attitude, there is around 10 questions which is going to analyze the attitude of the researchers regarding the biological samples. And it includes 10 questions with the options of strongly agree, agree, no opinion, disagree, and strongly disagree. And this is the scorings what is given over there. And finally, perform the skills. Various activities were given, around 5 activities were given, and the scorings were calculated. And the activities, based on the activities, they'll be giving the feedback of not confident, somewhat confident, very confident, and will be able to do independently in future. So this way assessing the skills. So the statistical analysis, the data was analyzed for normal distribution by Shapiro-Wilks test, followed by the paired t-test to compare the pre-test and post-test scores in the same group, whereas unpaired t-test was done to compare between the pre and post-test scores in between the groups. Finally, among all the 3 groups, repeated measures ANOVAs was done to find out the statistical significance. So this is the result where the Shapiro-Wilks test shows the normal distribution, where the pre-test post-test of Group A and Group B and Group C with knowledge, skill, and attitudes mean score. To start with, first the Group A researchers, where you have the knowledge, attitude, and the skills, the pre-test and the post-test scores were compared, and it was found to be statistically significant in case of Group A researchers. And this is the graph showing the post-test scores which were found to be high when compared to the pre-test scores. Moving on to the next group, Group B, research supervisors. When they were analyzed, their knowledge, attitude, and skills shows that the data were pre and post-test scores were found to be statistically significant. And the graph showing the post-test scores to be high when compared to that of their pre-test scores. Finally, move on with the institutional ethical committee members. When compared their knowledge, attitude, and skills scores between the pre and post-test, and their knowledge and skills scores were found to be significant, whereas attitude scores were found to be not significant when analyzed by party test. And the graphical presentation of their pre-test and post-test scores, as usual, the post-test scores were found to be more when compared to the pre-test scores. And finally, we are moving on to the knowledge, attitude, and the skills of the participants. Before the workshop, all their pre-test scores were compared together among all the three groups. And only attitude was found to be significant when done with the statistical analysis using ANOVA. And this is the comparison of pre-test scores of the three groups. Whereas the post-test scores were also analyzed among the three groups, and it was found to be statistically significant for attitude and the skills by ANOVA, and the graphical presentation of their post-test scores. So in all the post-test scores, the group A, that is the researchers, were found to be aware of it, whereas the research supervisors and as well as the institutional ethical committee members has to be streamlined and they have to be given the proper guidelines. Moving on to the discussion, the overall increase in knowledge, attitude, and skills domain after the workshop was statistically significant in all the three groups. The researchers should be aware that ethical committee always plays a key role in oversight and use of the biodata repositories for the research as well as the scientific and public health programs. Regulations and guidelines that guide the use and exploitation of stored biological samples and data has to be created an awareness. And transfer of biospecimens that the MTAP Act has to be executed. And the participants always has the right to own the biological samples and the data collected. To conclude, an awareness has to be created for researchers on ethical issues in the storage and reuse of human biological samples. Various ethical issues such as the consent, claim, and intellectual property rights and genetics, which is arising from the storage and reuse and exploitation of biological samples and data, has to be sensitized to the researchers. And further recommendation on the IPR, data mining, data hacking, data accuracy, and security that will protect the research participants as well as benefit the biomedical research community. So these are the references. Thank you.
Thank you, sir. Open for discussion and questions.
Was prepared by you or
sir?
Hello. The question
Yes,
is prepared by you or
sir, I can't get your question, sir.
the questionnaire was prepared by you?
Yes, sir. The questionnaire was prepared by me and it was validated and then it is copyrighted under my name, sir. It's a copyrighted questionnaire, sir.
You're validated. You've done the validation.
So your voice is breaking, sir.
Yeah, statistician, you have taken help from them or you did yourself?
Statistics part, I have taken
analysis.
the help of statisticians, sir. With the statistician help only, I have done the statistics.
Okay, okay. Yeah, thank you. Thank you.
Any question from Dr. Seetala?
Thank you, sir.
Okay. Thank you, sir. Any other question from anyone else? Okay. Yes. Seetalal, sir, during Dr. Dilip's session, the internet got disconnected. Is there any other question, sir? His session was on fracture and histopathology. Am I correct, Dr. Dilip?
Yes, sir. Yes.
Sir, any questions? From Kingston, sir, yours also, sir. Any question?
Yeah, that histology part.
Yes, sir.
Right. Slides would have been better. That's what.
Okay.
Hello.
Okay. Yeah, Dr. Dilip, there's no questions for you. Even Dr. Sita Lal has put it across as no questions to you. They wanted to ask for a clearer slides. That's all.
Okay. Thank you. Thank you, sir.
Yeah. And Agarwal, sir, Dr. Kritika has shared the judgment in the chat box.
All right.
Have shared to sir's mail ID as well as in the chat box also, ma'am.
Yeah. Actually, I privately shared you my email ID because I was very keen on learning this.
Yes, sir. I have already shared, sir.
Okay. I'll have a look at it. Thank you,
Yes.
but it was really good.
Thank you so much, sir. Thank you, sir.
Yeah.
It is not arrived by now. Anyway, I'll take it from Aarti.
Yes, sir. I'll mail it across to you and WhatsApp you also, sir. Thank you all. Thank you. Thanks to the judges, Dr. from Kingston Marak and Dr. Sita Lal Rathod. Thank you, Dr. Anil Agarwal, and Dr. Sanjeev has also been asking questions and has been from the beginning. Thank you all for joining us. And I'm so happy to say that other postgraduates and undergraduate sessions also went very enthusiastically, and they presented on interesting topic like artificial intelligence and how voices are being used in telemedicine. So it was really nice. Yes, sir.
I can say, Aarti, it was such a wonderful session. Each PG was, unbelievable. Each one can understand. When I was a PG, I could not have took that kind of a lecture. Never I could have taken that. Every lecture was amazing. So I thoroughly enjoyed. Otherwise, believe me, I would have left it because there is no attendance here. So, but beautiful lectures, no doubt. You should conduct these programs more often, actually.
Thank you, sir. Thank you. Sir, indeed, I was surprised. I was in between for the undergraduate presentation. Undergraduates, they were not like undergraduates. I have to say that they were presenting at a very high par. And the quality of study that they have put into, the quality of research that they have put into. And so they have raised new questions and all, which were very interesting for us to know about.
Yeah, somehow my chat disappeared. I wanted to answer those questions, but if you can send me that chat.
Yes, sir. Sir, we are saving the chats, so I'll compile the questions and I'll send it across to you.
Please. Also, and anybody wants to ask any other question, I would be really very, very nice session. Very nice. Beautiful.
Thank you, sir. Any questions? Okay. Sir, anyway, I have a bulk of questions which we have received for tomorrow's panel discussion also. We are still receiving also. And from today's the undergraduate and postgraduate questions also, postgraduate presentations, we have more questions which have come in also. So we are compiling it for the panel discussion tomorrow, sir. I'll send it across to you today for your reference, and we will discuss further tomorrow also, sir.
Great. Yeah. Very nice.
Thank you, sir. Thank you all for joining us today. And tomorrow also we will join in with exciting sessions. So tomorrow we will be starting with update on sexual jurisprudence by Dr. Sunil, and Dr. Sunil will be talking on these judgments too. Then opinion framing in sexual offences by Dr. Dasari Harish, effective consent by Dr. Nandimant. He is the one who Dean introduced. He is from the National Law Schools and of Indian University, and he's very good with the giving expert opinion with respect to consent when it's raised. Then we have a court's expectation by Dr. Shushini, and approach to medical legal death investigation by Dr. Jayanti Yadav. After that, we will be having the award paper presentation. The award paper presentation, we are giving it the chance to the undergraduates and the postgraduates to present during the session. But for the faculties, please don't worry. The cash money that we promised will be given to you. Followed by this, post-lunch, we have the panel discussion and then the valedictory. Everyone's excited for the tomorrow's session, and we will all meet you again at 9 a.m. tomorrow. Thank you all. Thank you all for joining us today. Thank you.
Thank you, Aarti.
Thank you.